Hey Fatima, can you hear us and everything? We're just testing mics and screens and everything.
We can hear you.
Okay, hey Sarah, thank you so much.
No problem.
Okay.
Madam Examiner, it is now 9:31. Are you ready to start the meeting?
I don't know why I have a hard time hearing you. I'm sorry. Good morning, everyone. I'm Maureen McNeil. I'll be the hearing examiner
Recording
today.
in progress.
Good morning, everyone. I'm Maureen McNeil. I'll be the hearing examiner today. It's March 25th, 2026, and we're here for application ZMA 2024-004. Applicant is NBR Inc., and it's a request to rezone from the RE zone to the RPD zone and to allow the applicant to build single-family detached and attached dwellings. Property is approximately 126.16 acres. The site is known as the Grove at Hyde Landing, and it's located on the south side of Steed Road, and with the address of 3801 Steed Road, Clinton, Maryland. If attorneys would identify themselves for the record, starting with you, Mr. Tedesco.
Good morning, Madam Examiner. Can you hear me okay?
Yes.
Good morning. For the record, Matthew Tedesco with the law firm of McNamee, Hosey and Greenbelt, here on behalf of the applicant NVR Inc.
Okay. And I know that's not Mr. Nelson, so.
No, good morning, Madam Hearing Examiner. This is Alex Vota from the Law Office of G. Macy Nelson. I'm unable to change my Zoom name from our firm name, so that's why it still says Macy Nelson. And I'm here on behalf of the Branch Hill Steeds Glen Homeowners Association, Jerome Tidwell, Sam Lynch, Mendelson McLean, Andre Scott, Herman Art Taylor, Jeremy David, and Derek Taylor.
Okay.
Thank
Good
you.
morning, Stan Brown, People's Zoning Council.
Okay. All right. Is anyone, so I know all of your clients are in opposition. Is there anyone else here today that's in opposition to this request that aren't represented by Ms. Votaw? Anybody see anybody? Okay. All right, Mr. Tedesco?
Madam Examiner, good morning. I think what would be useful for us, given Ms. Votaw's representation of a number of citizens, is to also provide clarification on how many witnesses Ms. Votaw intends to call, because we do have unrepresented citizens, some who are in support and some who are opposed. And just out of courtesy, if Ms. Votaw agrees and you agree, I'm okay with allowing them to provide their comments for the record. Obviously, if there's any questioning that I may have or that Ms. Votaw or Mr. Brown may have or you may have of them. But before we get into our case in chief, because we have 6 witnesses, I assume Ms. Votaw has witnesses. So I expect today is going to be fairly lengthy. And just to give the citizens who are here, who are not represented, an opportunity to have their comments put on the record, and so that they may wish to stick around or not is up to them, but I would just throw that out there as an option.
Ms. Votaw, how many do you have?
Yeah, I have at least 3 witnesses. And to the extent I have a few clients I haven't been able to touch base with, and I want to make sure they have the opportunity to have their voices heard. But I definitely know at least 3 witnesses.
Okay, then everyone, if anyone here is not represented by any counsel but would like to testify out of order because you don't want to spend the entire day with me, would you please come on camera? Silly question. Who would want to not spend the entire day with me? Okay, so it looks like I don't see anyone, Mr. Tedesco, but if at any time you see in the chat or elsewhere that there is someone, please, wait a minute. Oh, really? Someone thinks we're not seeing you on camera, Mr. Tedesco, but I'm seeing you. So
We
anyway,
see him.
We can see him.
okay. We've got some people on the phone only.
I'm on camera. You just may have to scroll across the toolbar.
Okay, so if anybody does change their mind and you all keep your eye on the chat, we'll be able to, it
Well,
could
I
be that
see-
they
I
don't mind.
see-
It could be they don't mind the first 3 hours, but after that.
Well, I see Mr. and Mrs. Brown, so I'm gonna,
You
I
do?
think, yeah,
Okay.
they queued up.
So, Mr. and Mrs. Brown, can you come on camera or one at a time? Oh, there you are. Michael and Benita. Okay, I didn't see your last name. So I'm going to swear you both one at a time. Whoever wants to go first, raise your hand. So I'll do you first. Okay, I'm going to pick. Thank you. But Ms. Brown, do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
Yes, I do.
And what's your address?
12900 Jervis Street, Clinton, Maryland. 20735.
Okay, tell me what you want to let me know about this request.
Well, first of all, Matt, should we go ahead and testify now or during?
Oh,
It-
well,
it's-
go ahead, Matt.
Sorry, I muted the wrong thing. Mr. and Mrs. Brown, it's totally up to you. I'm ready to proceed with our case in chief, but that means you would go after our case and after Ms. Votak's case, so you would go towards the end, which we're probably gonna be many hours in. So we just wanted to give the opportunity for you guys to put your testimony or anybody's testimony on record now, and then you're free to stay or go as you wish.
Okay.
It's your decision.
Yes, we will go ahead and proceed testifying now, and then we'll listen. We want to hear some of the other comments, but then we understand we'll be free to leave after.
Okay, so I have to take you one at a time. So what would you like to tell me about this request?
Well, I'm here to say, you have a copy of our letter that both Michael and I signed, and we are in support of the zoning amendment. From the very onset of this proposal, we have been engaged in small community meetings, hearing from our community and various other communities in intimate settings where residents had the opportunity to express their concerns. And we've also attended the public meetings in the aggregate where people express concerns or support of this. We do support it. Again, we've been there from the beginning. We're individuals that don't just jump on the bandwagon just because someone has asked us to. We have lived here for over 30 years, back and forth since we were in the military, but we support this knowing that we believe it will be advantageous to the Prince George's County community. Some of the concerns that we expressed early on have been infrastructure, including, of course, traffic signals, concerns with the road being too small, so much traffic on the roads. Residents also want biking lanes, and a big portion of what we have heard, and we have definitely expressed this, is the public safety aspect. So we want to ensure that our EMTs, first responders, firefighters, police officers can respond in the appropriate time. Not that we add X hundred more homes and then that has an adverse impact on public safety. So that's been a big key with the infrastructure, ensuring that traffic signals are properly adjusted as needed, and the roadways, because we know on Steed Road as well as on Allentown Road, which will also be affected, there's already a lot of traffic. So we hear it all the time, literally, in all the meetings that we attend, the concern about traffic. So again, we do support it because we believe that this will be beneficial. We support the zoning amendment. We believe it will be beneficial. And because we realize that our voices have been heard in the meetings with the attorney Matt Tedesco, GS Proctor, as well as NVR, points of contacts who have attended the meetings, the designers, the traffic consultants. So they've all heard what you're hearing now, although it's much more succinct that you're hearing it now. But we do agree with this and support it because we do believe that it will help improve our Prince George's County community in this area. We live about 3 miles or so away from this community, so we pass it all the time. We're traversing it, and that's all that I have.
Just before I ask anyone else if they have questions, 3 miles in which direction? Further down Piscataway, further down Steve? Where are you?
We are, if you know where Miller Farms is and
Mhm.
where the airfield used to be,
Mhm.
going down past which way would you say it's going? Northbound, we're going north or south? I guess southbound. Oh, Michael said we're going east. So from our home, we're coming up, passing Steed Road, Miller Farms, and then keep going forward, and you're going down past by BK Miller.
Okay, thank
Hopefully that answers your question.
you. Ms. Votar, please forgive me because it's something I gotta stop looking at Nelson. Do you have any questions of this witness?
Yes, ma'am. I just have one question, and good morning to both of you.
Good morning.
Could you just clarify, you do not have to travel along Steed Road to get to your house, is that correct?
It depends on what direction I'm coming from. So for example, we went to a Linton service this morning, and yes, ma'am, we had to traverse. We were on Steed Road, then we turned right onto Allentown Road.
Understood. And do you ever experience traffic on Steed Road?
Yes,
Okay, that's all I have. Thank you so much for your time.
yes, ma'am.
Mr. Brown,
No questions, thank you.
thank you so much. Mr. Michael Brown, do you?
Yes, ma'am. Do I need to be sworn in?
Yes, you do.
Yes.
Do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
The truth and nothing but the truth. Yes, ma'am.
Okay, so state your name and address and what you want to tell us about this request.
Yes, ma'am. My name is Michael Brown. My address is 12900 Jervis Street, Clinton, Maryland, 20735. And like my wife, I too am in approval of this zoning. And I'm going to tell you why. We understand this and this concept that when we first got started with the Grove and in the meetings that we were going to, we came with an attitude knowing that
There you go.
we really want all this traffic. That's the first thing that always comes to our mind is traffic. And asking that question, and then of course other questions about the schools and things like that came up. So, but once we sat down and we got to hear about the planning, but not only the planning of the Grove, once we got to hear the questions that other leaders within the community were asking, and not only asking tough questions, we were able to hear the answers to those questions. And one of those questions had to do with the type of homes that we would like to see compared to the type of homes that the Grove at first decided that they would make. But they heard the voices within the community. And I was amazed from the answers that they gave. And when they would leave, they would come back and make changes because they were listening to the community. I know this. If it's not the Grove, then who else is it going to be? But I'm grateful that and my wife and I were in the meetings from the very beginning, and we got to see the character of those that are coming to build within our community. And in that character, I believe that there was great transparencies, but not only great transparencies, I believe that there was great integrity, because there were times when there's conflicts between our community and some of the things that we would hear outside the community. And then those problems or concerns would get back to us. And this is what I loved about those within the Grove. We had the phone numbers Matter of fact, we had Matt's phone number. And when we found there was complaint and we didn't hear it, but it didn't sound good, we would call Matt and say, Matt, what's going on here? And then he would explain, well, this is really what is really going on. And then in our meetings, he would express what was going on. There was never a time that I felt that they were trying to hide anything or trying to do anything backdoors. So I knew that even though at first, do I want to have to deal with all this traffic? Do I want to have to deal with all these homes? And I know that homes have to be built. With that understanding, I understood the character of those that were coming to our communities. When I understood how they were patient and they did listen and they did make changes, big changes, I said, well, if it's going to be anybody, let it be the Grove. So we do travel, not only Piscataway a lot, because we lived here for 30 years. We do travel Steed a lot because we have the different directions that we go in to our churches, to our bases, to our friends. So these streets along, even though Piscataway may be one of the main streets, these streets along here are the streets that we travel. And we are concerned, but what I feel is the character of the Grove, of the people that are coming, that are going, that I believe are going to not only make a difference with these streets to the best that they can, but they are going to adhere to everything that they say that they are going to do to the best of their ability. Is going to be done. And I believe that they know, because they know of the leadership within the community. If they're not, it's not happening, then they know that their reputations are on stake. So I stand approved of the support and ready for any questions.
Thank you. Ms. Votaw?
Yes, thank you, Madam Hearing Examiner, and thank you, Mr. Brown. Just one quick follow-up question. When you travel along Steed Road, have you ever experienced the traffic back up to the bridge that's on that road?
So thus far, I haven't been traveling on Steed Road where the traffic has been backed up. I have traveled where there has been traffic, and I know there has been some changes with some of the homes in that area, but not backed up, no.
Okay, thank you. And in your opinion, would adding 300 additional dwelling units improve those traffic conditions?
Objection.
Same objection. He's a lay witness. He's not qualified to give an opinion on that type of traffic issue.
If I may be heard, I'm asking for his opinion as a lay witness, not as an expert.
And your question again is what? Say it again.
I'm asking if he believes that adding 300 dwelling units would improve the traffic conditions that he's experienced.
Again, he's not qualified.
I would object. It calls for speculation.
It is more, well,
May I be heard, Madam Hearing Examiner?
we allowed him to say he hasn't experienced any backup. So I will overrule if he changed it to, do you think, I don't know. With 300 more, go one more time, Ms. Votaw. I'll let you respond again, but.
Yeah, I think Madam Hearing Examiner is fully equipped to weigh his opinion with the weight that it deserves, but I was trying to gauge, based on his personal experience traveling that road, whether the traffic from the vehicles from 300 additional units would improve that the traffic conditions on that road.
I think I would sustain their objection, but if you had another question where he clarified further his current experience with the traffic, then that's just an argument you can make later, unless there's an expert witness that will testify as to what 300 more homes will do. Did you
All right,
want
I'll
to
just
ask
leave
him
it
any
at that.
further about what he's experiencing currently?
No, I think he's provided enough detail. Thank you, though.
Okay,
Appreciate it, Madam
all
Hearing
right.
Examiner.
Sure.
And thank you, Mr. Brown.
You're
Anyone
welcome.
else have questions of Mr. Brown? Mr. Brown, do you have questions of Mr. Brown?
No.
No.
Thank you.
Okay. Thank you very much.
You're welcome.
So is there anyone else that would like to testify out of order, lay witnesses that might like to testify now? All right, Mr. Tedesco.
Thank you very much, Madam Examiner. You can still hear me okay?
I need to clarify, I can't hear his staff for some reason. I hear you all. Thanks.
You can hear me though?
Yes, we can hear you.
Okay.
Except I wonder why, since he's muted, what is going on?
So we have multiple cameras set up, so we're
Okay.
using one speaker with two different computers and cameras. So when I speak, it's through the witness computer that you'll see in a moment. So
Yes, we hear you fine.
yeah, that's why, thank you. So Madam Examiner, as you indicated, we're here on the Grove zoning map amendment. I do have opening statements that I'd like to provide, and then we'll get into testimony. But if I could, your indulgence, just so we can go through kind of framing this for a minute. The Grove at Hyde Landing provides a very unique but coordinated relationship with Hyde Landing, which is the development to the south. The latter is also within the RPD zone, with the same builder and the same developer. These two projects are able to be planned and designed comprehensively, and the requested RPD zone facilitates the needed flexibility, both in zoning and in the public benefits these projects will offer the community and the county. Like Hyde Landing to the south, the Grove will transform the property into a comprehensively designed community, allowing for a more effective environmental stewardship, placemaking, and amenities while respecting existing environmental habitats and creating proportionally scaled lots and homes that provide variety in the market and seek to address the housing crisis. At its core, this case is extremely straightforward. The applicant seeks to rezone to the residential plan development zone to allow thoughtfully designed residential community on approximately 126 acres located along Steed Road in Clinton, north of the Hyde Landing project. The proposal includes approximately 300 dwelling units at a density of approximately only 2.9 units per acre, well within the residential low land use recommendation of Subregion 5 Master Plan and Plan 2035. This is not a departure from the county's plans. It is actually an implementation of them. This application is governed by the plan development standards of section 27-3602, not the change and mistake rule applicable to piecemeal rezonings. As confirmed by the technical staff and by the planning board, this is a legislative determination focused on master plan consistency, compatibility, and public benefits, all of which are satisfied. The property was placed in the RE zone through the countywide map amendment, but the master plan expressly envisions residential development at the densities that are proposed here this morning. The RPD zone is the tool the ordinance created to achieve the vision to provide better design, better environmental preservation, and community benefits that conventional zoning just do not allow. What distinguishes this application and what the ordinance requires is the delivery of public benefits that exceed the base zoning that would otherwise be provided. Here, the record demonstrates multiple quantifiable benefits. Over 50 acres of stream valley and environmental preservation, expanding the Tinkers Creek corridor and protecting sensitive resources. A critical multimodal trail connection, filling a gap in the county's trail network system. Major transportation improvements, including bridge widening and extended roadway upgrades along Steed Road that go beyond frontage requirements or simply pro-rata payments into the CIP. Enhanced woodland conservation and environmental stewardship measures. These are not conceptual promises. They are quantifiable site-specific improvements recognized by the technical staff and the planning board exceeding baseline requirements. Importantly, the applicant is not simply contributing to infrastructure. The applicant is building it, including improvements that exceed the pro-rata CIP contribution by over $1 million. The proposed development is residential in character and compatible with surrounding uses. It is intentionally clustered, preserving substantial open space and keeping development out of environmentally sensitive areas. Nearly half the property remains preserved or environmentally constrained. The development is concentrated in appropriate areas, consistent with modern planning principles and county policies. Stormwater, traffic, and infrastructure concerns, which are frequently raised in these types of proceedings, and you'll probably hear later this morning, are not ignored. They are frequently addressed through county's multi-stage regulatory framework, including the subdivision process, the site plan process, permitting process, and technical plan review processes. Although the opposition will probably raise a number of issues this morning, let me go through some of them very briefly. At the planning board level, the opposition argued that change or mistake, that there has been no change or mistake to support this rezoning. As you know, as a plan development rezoning, reliance on this is legally incorrect and has already been rejected by the planning board and technical staff. I'm sure you'll hear impacts on traffic, APF, schools, stormwater, et cetera. These are addressed through established regulatory processes at later stages of development. The record will show no basis to deny the rezoning on these grounds, and the traffic analysis confirms improvements in mitigation tied to county CIP planning. You may hear claims of inconsistency with the master plan, that the project is just simply too dense. The opposite is actually true. The proposed density falls squarely within the recommended ranges and implements the county's long-term land use visions. Finally, you may hear how Ms. Votaw represents a number of citizens and community members throughout the immediate area. But as Maryland law makes clear, zoning decisions must be based on substantial evidence and not the number of letters submitted into the record. When you step back and look at the full record of this case, Madam Examiner, the conclusion will be very clear. The record and the testimony that you will hear today will show that the application complies with the zoning ordinance, it implements the master plan and Plan 2035, it provides significant and measurable public benefits, and it has been thoroughly reviewed and supported by the technical staff and the planning board. This is precisely the type of planned, environmentally sensitive infrastructure supported development that the RPD zone was created to encourage. As I mentioned, we have 6 witnesses that will testify this morning, and at this time, we would call our first witness, who is Mr. Patrick Donahue.
Mr. Donovan?
Donahue.
Donahue, I'm sorry. Mr. Donahue, do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
I do.
Mr. Donahue, could you please state your name and address for the record?
My name is Patrick Donahue. I have a couple work addresses. I'll give you mine in Prince George's County. It's 4700 Corridor Place, Beltsville, Maryland, 20705.
And what is your occupation and where are you currently employed?
I am the Regional Vice President of Land for NVR Inc. Basically what that means is I run one of our regional land departments. I'm in charge of everything from land acquisition, entitlement through development for one of our company's regions, one of Prince George's being one part of that region.
And who is the owner of the property that's the subject of this application?
Sharhano LLC.
And are you affiliated in any way with that entity?
I am not.
And have you been authorized to testify and present this application for rezoning on behalf of NVR Inc.?
I have.
And does NVR Inc. have a contract to purchase the land?
We do.
And Madam Examiner, Mr. Brown, as exhibits 42, 37, and 40, both are a limited power of attorney resolution on behalf of the NVR Inc., as well as an incumbency certificate authorizing Mr. Donahue to testify this morning. And we would ask for those to be accepted into the record.
No objection.
Do you have any objection, Ms. Votaw?
No, ma'am.
They will be admitted into the record.
Thank you. Mr. Donahue, is NVR Inc. in good standing to transact business in the state of Maryland?
We are.
And for your edification, the certificate of good standing is exhibit 42, Madam Examiner. Mr. Donahue, could you please explain how Prince George's County fits in with NVR's strategic business plan?
Sure. Let me start at a higher level. NVR Inc. is the parent company of Ryan Homes, NV Homes, and Heartland Homes. Heartland does not build in this area, but we are a national builder. We're about the 4th largest in the country, and we do it all basically east of the Mississippi. So we really focus on the East Coast, at least for now. We've been building in Prince George's County since 1978. And to my knowledge, we're the only national builder or the longest tenured national builder in the county. On any given year, our market share fluctuates. we build between our market share within the county, within Prince George's County, oscillates between about 25 and 35%. So in very rough terms, I've been working in the county and working with NVR for about 19 years, and that market share has been in that range. So almost 1 out of every 3 homes built in the county over the last 20 years at least has been by our organization. So Prince George's County is very, very important to NVR, not just in terms of the number of homes we build, but also how we implement our business strategy. NVR is known as what's called an asset-light builder. What that means is oftentimes, or the majority of times, we like to rely on other people to go and buy land, entitle it, and develop it. And what we prefer to do is simply buy a lot from those builders and build houses. In the county, since it's so strategic for us, we have taken on another role. So we serve oftentimes as a master developer, where we do go acquire the land, entitle it, and develop it. A couple examples of that are just the neighborhood community Hyde Landing. We bought that approximately 3.5 years ago and have since been processing through the entitlement process in order to get entitlements to build houses as well as a solar field and some ancillary commercial. But we've also done that in Timothy Branch down in Brandywine. We built, there's a great example of a hybrid business model. We built every house in that community. But some of those pods, we call them, NVR owned and developed ourselves. Other examples, Bentley Park, which is in Laurel, straddles the Montgomery County and Prince George's County line. Our organization owned, developed, and built that out. Greenbelt Metro in Greenbelt, this is the south core where the metro station is, and the north core, at one point the FBI was going to go. We bought and developed that, actually bought that out of distress when somebody had built a bridge to nowhere and had abandoned it. We ended up buying the note on that community and ultimately getting the land in the community and building it out with a financial partner from New York. Did the same thing at Oak Creek, one of my proudest developments off of Church Road, where in the heart of the downturn, it was a community that had been basically, it was in distress. There was a golf course on site that the owner had walked away from. And we stepped in, not only bought the community, but bought the golf course, renovated the golf course, and gave it away to a third party simply because, we really, really wanted to focus on the houses. So you can see, we've been in the county a long time as a company since 1978. I've been in the county as an employee for, I think, almost 19 years, not quite 19 years, but a couple more months I'll be there.
And given the current zoning of the subject property, can you explain why you are now seeking rezoning from the RE zone to the RPD zone?
Sure. The 21st century zoning ordinance gives us the opportunity to rezone and gives us more flexibility, both in lot sizes and how we position things and how we develop, to meet the broader goals of the county's general plan and the Subregion 5 master plan and numerous other planning documents that the county has set forth saying what they want. But what they're trying to do is stop sprawl and stop large lot developments that have a disproportionate impact on the overall community without providing any benefits to it. And so transitioning from RE to RPD, we're allowed to go to smaller lots. And in doing so, what we're going to do is we're going to develop and touch, in essence, less of the land. And allows us to preserve more of the forest, more of the trees, bigger setbacks off of stream valley buffers. It also allows us, it gives us the economic freedom to do public benefits, improve some of the road networks, and improve some of the existing traffic congestion out there. So it becomes a win-win for not only the residents that we're building for, the residents that are going to buy houses in our community, but for the residents that have already bought and already living in the community. It gives them a benefit to development as well, a tangible benefit.
And conceptually, what is the vision for the subject property if the requested rezoning is approved?
It's still in the early stages, but what we're planning on doing is developing to about 300 units, which equates to about 2.97 units per acre. This, in the general plan, the master plan, as I understand it, is designated as low density residential, and that caps out at 3.5 units per acre. So we're going to develop at a density that's even less than what it would be allowed under the general plan. But we're going to cluster that development, and we're going to have a number of different housing types: small single family detached houses, large single family detached houses, and some townhouses that will be probably slightly larger than what we're planning on next door at Hyde Landing. And that gives us, we were able to target multiple different buyers within the Prince George's County community. The community will also connect to Hyde Landing, so we don't have disparate developments one after another on a street. It's an interconnected development with trails where people can utilize both the amenities in Hyde Landing and the Grove. It also connects to the Tinker Creek Stream Valley park system. So it's really an integrated development is what we envision. That, and I could go back to my earlier statement in terms of, why is that important? But in this case, much like those other examples I just cited, we are the applicant, we are the developer. And so we can have this holistic vision of how does this all fit together and how can we create a cohesive community that is attractive to our residents, but also something very positive for the surrounding community.
And are you currently familiar with the subject property?
I am.
And how is it currently developed?
It's currently, there's a farmhouse on it. There's a number of ancillary farm-related buildings. It's really, in my eyes, used currently as a hobby farm. I think Dinky the donkey lives there. Couple other pigs, couple other chickens. But other than that, and ancillary storage for farm-related and non-farm-related items.
And have you reviewed the planning board's resolution, in this case, Exhibit 27?
I have.
And do you agree with the recommendations of the planning board in its resolution?
On balance, I generally agree with the recommendations of the planning board, the findings, conclusions, and the conditions. I would like to defer additional discussion on some of the items, particularly the traffic analysis, to our traffic expert.
And do you plan in incorporating any green building standards if this development were to move forward?
We do. The green building standards, not only on the horizontal side of building, there'll be a robust review of stormwater management policies, forest retention, preservation of specimen trees, et cetera. But also in the home building side of it. That's very important to us as our brand and as our ethos as a company. We do have a green building standard. And in that we use programmable thermostats, energy efficient appliances, sustainable wood sourcing. We actually panelize, we own our own factories and panelize a lot of our wood products, stairs, walls, windows, et cetera, in one of our manufacturing facilities. And what that does is it dramatically cuts down on waste that you would experience had you stick framed in the field. So one measure of that, of kind of your sustainability as a builder, is something called the HERS index. I think it stands for Home Efficiency Reporting System. And the benchmarks, really, if you look at the average resale home on the market, a lower score in the HERS index is better, right? It's sort of the opposite of what you would think. But the average resale home in the market that scores a HERS of 130. The average new home on the market scores a HERS of 100. And the average NVR home across our footprint scores to 65. So you can just see our commitment to energy efficiency. And that not only translates to environmental benefits for the broader community, but it also translates to utility savings for our customers. So it's a win-win.
And did you and the applicant and your consulting team do any community outreach associated with this application?
We did. We actually took a very different tact of what historically developers have done. And it's actually been a great process. I think you heard the Browns talk about it earlier. I think they've enjoyed the process. As a developer, I've truly enjoyed the process. And some people who signed up in opposition today have been in almost every one of those meetings. So we've been engaging with the community, whether in support or in opposition, through the Pan Am meetings, through stakeholder meetings. I think we probably have in the materials a record of every meeting. I would say it's probably, I've had at least 15 to 20 of those meetings. I'm not sure if I'm exaggerating or not, but we've been available. We have a website. On that website, we have ways to contact us. Every single comment that has come through our website has been responded to, with the exception of there was a media outreach that we, as a company, we just don't respond to media outreach. But local community citizens, we respond to them 100% of the time. I think many of them have my phone number and have called me directly. So in that process, we have listened and we have changed our plans, and the Browns testified to it relative to product type. We did this on Hyde Landing next door as well. And one of the big concerns of the community was we had initially a plan for apartments on that site. Based on the feedback from the community, we removed them. On this particular community, one of the biggest concerns was Steed Road. And our traffic engineer will testify that usually when you have traffic, it results in intersections, not what we call links. But the community really wanted us to focus on the connection of widening Steed Road. I'll call it north of our site. We call it Plan North, where all of our plans are, moving from our property north across Tinker's Creek. We've agreed to widen, or that's what we're proposing, is widening Steed Road, where it's probably not 100% required if you look at a strict traffic analysis. And all of that came through all of those stakeholder meetings. And that's where we pivoted and said, okay, this is what the community wants and this is what we're going to do. And in doing so, not only did we have to go and widen that road, we actually added on to, we likely wouldn't have to touch the bridge crossing the creek. And as part of that concession, we're now going to have to widen that bridge as well.
Thank you, Mr. Donahue. Madam Examiner, I have no further questions for Mr. Donahue.
While you all are preparing, since you mentioned Steed Road, and this is your case, I drive around there a lot and I don't know this bridge. Is it something people notice because they live there? I mean, it's not a bridge, correct? It's something very low and I don't realize I'm on a bridge?
Yes.
Okay.
But it's narrow, and it's narrowed and Mr. Lenhart will speak more to him. We have exhibits and we can show that to you, but
Okay.
It's part of our public benefit because part of what Mr. Donahue has testified to is what we've heard. And so that bridge discussion will come up much more in Mr. Lenhart's testimony. But yes, you've crossed it and not realized it.
Okay. Ms. Votaw, do you have any questions?
Yes, ma'am. I have a few. And good morning, Mr. Donahue.
Good morning, Mr. O'Toole.
The first question I have for you is, how many dwelling units would be allowed under the base zoning?
I've been told it's 109.
Okay, so you're not aware then that the planning board determined it was 93?
We believe that there was a mathematical error in that calculation.
And you're proposing 300 dwelling units
Correct.
instead. So, okay, I wanted to establish that. The next question I have for you is, you're aware, are you not, that the public benefits being proposed have to be superior to a significantly greater extent? They have to provide a public benefit to a significantly greater extent than would be likely under the development of the base zone. Is that correct?
I'm aware of that.
Okay. And you're, I'm assuming, generally familiar with the public benefits being proposed here, correct?
Generally, yes.
Okay. And I believe I heard you previously state that, for example, one of the public benefits would be the additional preservation of woodland on site. Is that correct?
That is correct.
And are you aware that under the base RE zone, the required woodland on-site preservation would be 25.23 acres?
I don't have that level of detail.
Okay. And do you know whether the amount of woodland being proposed to preserve under the ZMA, whether that significantly exceeds 25.23 acres?
I believe it exceeds it. I would actually defer. We have an environmental consultant ready to testify, and he can give you exact numbers. I think that's
Okay.
what I'd rather rely on that.
Okay, so you're not familiar with the findings of the planning board that the proposal is for the preservation of 25.23 acres, the same as what would be required under the RE zone.
I apologize. We had a technical issue. If you could
no
repeat
worries.
that question.
Yeah, absolutely. I'd be happy to. So you're not aware that the planning board found that the proposed woodland preservation in this case is 25.23 acres, which is the same as what would be required under the base RE zone, correct? You don't know that?
I believe it is.
Okay, so it's your understanding then that the amount of woodland preservation being proposed as a public benefit is the exact same amount of woodland preservation that would be required under the base zone.
I believe so.
Okay. Another question I wanted to ask you about was, are you familiar with the proposed public benefit of interpretive signage?
I am. I read just through the planning board resolution.
Okay, and so you're aware that planning staff found that signage, like that being the one being proposed, is a basic requirement that would be applicable for any development of the site?
I'm not aware of that.
Okay, well, that's on plan staff report page 24. How
I
about
don't have
the,
that in front of me, so I can't cross
okay,
that.
totally understand. How about the Coasca Regional Park funding? Are you familiar with that proposed public benefit?
Yes,
Okay, and are you familiar with staff's finding that this is not an adequate proposed public benefit because it does not include a proposal to actually construct the improvements to the plant, to the park?
if I recall correctly, they basically said we have to agree in the future on, we actually have to construct something for a minimum of $150,000, but it's not a $150,000 contribution. I think it says it specifically in there that we have to construct something.
Yes, but you're not currently proposing to do so, are you?
I'm obligated to do so.
But that's not part of the current proposal or what was submitted to the planning board, was it?
It's a condition of approval. So if I have to do it.
Okay, but you haven't determined what it is that you will be proposing for construction.
That's correct.
Okay, and I'd also like to touch on the Tinkers Creek Stream Valley dedication. Are you familiar with that proposed public benefit?
Yes.
Okay, and are you, just bear with me for one moment. Are you familiar with staff's finding that, quote, either the 5% usable area of land dedication or the stream valley dedication with master plan trails would be a base requirement under the subdivision regulation? Preservation of woodland and sensitive environmental features is also a base requirement. Are you familiar with planning staff's finding to that effect?
I remember that finding. I believe we're dedicating more than the 5%.
I mean, I don't want to debate what staff said, but my understanding of what staff said is there's a proposal for 6.3 acres of parkland, but that is within woodland preservation areas and cannot be counted as parkland. And then there's the 52 acres of the Tinker Creek dedication, which again, staff found would be a base requirement. Do you have a different recollection of staff's finding?
He indicated that he doesn't have the staff report or the resolution in front of him, so there's no need of debating that issue. The documents speak for themselves, Ms. Votak.
All right, I'll move on then. And then I know you described that the Steed Road improvements would be addressed more thoroughly by Mr. Lenhart. But just to give a general question, are you generally familiar with those proposed improvements?
I would say generally, yes, but if you ask me where turn lanes are, et cetera.
Yeah, absolutely. And then are you familiar with the proposal by, or as part of that, to use some of the CIP contributions to pay for the proposed improvements?
A portion of them, yes.
And you are familiar with staff's finding, are you not, that that would not be a sufficient public benefit if it was paid for by the CIP contributions?
I mean, it's a portion of it. I'm not aware of that finding. That the cost to widen the bridge and widen Steed Road to the north far eclipse what would be calculated in the CIP contribution.
Well, staff's findings on page 24, so I'll get into that with not 24, on page 22. So I'll get into that with Mr. Lenhart. I just have a few more questions, and thank you everyone for indulging me in this. From your understanding of the proposal, will there be adverse traffic impacts caused by the increased number of units on this property?
Objection.
I'm so sorry. Can you repeat the question?
Yes, I was asking if he believes there will be any adverse traffic impacts caused by constructing 300 additional dwelling units on this property.
And your basis, Mr. Tedesco?
Um,
You didn't.
My basis for the objection would be that Mr. Donahue's not a traffic engineer, and it calls for speculation on his behalf. And if you overrule, I'll redirect. That's fine.
Oh, same objection. I mean, Ms. Votar, he is not qualified. He is a traffic engineer. The only time a layperson can testify with regards to a traffic-related issue is if they saw a car going down the road, and in the general experience of a person, they know that's 30 miles an hour. He cannot speculate and project what traffic is going to look like in the future based upon any amount of dwelling units.
With all due respect, he was proffered as a witness to talk about the public benefits and the application's compliance with the zoning regulations. So I'm trying to elucidate his understanding of whether it complies with that. But I can wait until
All
Mr.
right,
Lenhart.
yeah, I would sustain also because I recall him saying that he would defer to traffic expert on traffic matters. I didn't hear him testify on that
Okay.
issue.
I will wait for Mr. Lenhart. And then I have one final question. Mr. Donahue, if you'd bear with me one moment while I rifle through my papers. Are you aware of staff's findings that the density and dimensional standards proposed are far more intense than those found in nearby residential areas and even exceed the thresholds permitted in the residential multifamily 20 RMF 20 zone, the densest base zone allowing single family detached dwellings? Are you familiar with staff's finding to that effect?
I've read those findings, yes.
Okay. And are you familiar with staff's finding that the proposed dimensional standards exceed what may be reasonably achievable while conforming to other code requirements on this property?
I am, but I think you're missing all the context relative to Hyde Landing, which is a denser product. But I mean, I've read what you're just reading and asking me if I've read that. And I said, yes, I have.
Okay. Yeah. I mean, we're not here about Hyde Landing, are we? We're here about the Grove, correct?
Correct.
So Hyde Landing is not relevant to today's conversation.
I think it's relative when you're asking about context. When Hyde Landing's next to it, that does provide context, right? And relative to neighboring communities, it's a neighboring community.
And how many dwelling units are being proposed with Hyde Landing?
I believe it's 1288.
And will any of those be using Steed Road?
Yes.
Okay. So those will add vehicles to Steed Road, correct?
I think that's, we're also doing a lot of improvements to Steed Road, to Steed and Piscataway. We're on both communities, making improvements to contributions to the improvements to BK Miller intersection. So you keep on asking me like, hey, are we going to add more traffic to the roads? We're also making it, I think it's disingenuous to say, without considering all the improvements we're making to those same roads.
Well, based on your council's objections, you're not qualified to say whether or not those improvements are adequate to accommodate the amount of traffic being added to this road, correct?
That's why that line of questioning is improper. You need to wait until the traffic expert testifies, Ms. Votar.
Then I would request that the zoning hearing examiner disregard the applicant's statements regarding traffic and whether or not there are improvements.
Don't worry, I'm able to weigh whether an expert spoke. And I was getting ready to say, move on from this. So yeah, I won't be paying attention to that portion.
Okay. Thank you, Madam Hearing Examiner. I believe that's all I have. Thank you so much for your time, Mr. Donahue.
Thank you, Ms. Votar.
Mr. Donahue, did you say that you all accept the conditions of the planning board and the technical staff?
Yes,
Okay, so the dimensional standards are going to be revised as they requested?
yes.
Okay, thank you. Mr. Brown?
No questions. Thank you.
Thank you.
No redirect.
Okay, thank you, Mr. Donahue.
Thank you, Mr. Donahue. Our next witness, we would call Mr. Charlie Howe.
Good morning.
Good morning. Mr. Howe, do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
I do.
Thank you.
Mr. Howe, good morning.
Good morning.
Hopefully I can say that for all of our witnesses. Could you please state your name and address for the record?
Sure. Charlie Howe, employer address is 1101 Mercantile Lane, right here in Largo, Maryland.
And what is your occupation and who's your employer?
I am a site civil engineer employed by Rogers Consulting, title a team leader and principal.
And how long have you been employed in the field of civil engineering, site civil project management, et cetera?
20 years now, 17 of which has been within Prince George's County.
And are you a licensed professional engineer?
Yes, I am. License number 32490.
And have you previously been qualified and accepted by this examiner as an expert in the field of civil engineering?
I have cases A-1159 for Dobson Farms, A-10060 for Saddle Ridge, ZMA 2022-003 for Smith Lake Estates, and ZMA 2022-005 for Hyde Landing.
And Madam Examiner, Mr. Howe's CV is Exhibit 25 at page 8. And we would ask that he be accepted as an expert in the field of civil engineering.
Any voir dire or objections?
No objection.
ma'am.
Okay, to be accepted as an expert in the area of civil engineering.
Thank you. Mr. Howe, are you familiar with the property that's the subject of this hearing?
Yes, I am.
And did you make a personal inspection of the property, and if so, when?
Yes, multiple inspections, most recently on March 24th this year.
Which was yesterday?
Correct.
And from a site civil engineering perspective, please describe the subject property.
Sure. Tinker's Creek is running around the north boundary of the property with the tributary from flowing from High Landing bisecting the site areas. There are large areas of open space that will preserve the continuity of the tributary. Runoff generally slopes.
I didn't interrupt you. Madam Examiner, maybe we put up if Sarah Fatima could put up exhibit 48, because that is a rendered illustrative plan just for folks to look at while Mr. Howe is speaking.
Thanks, Pat.
Can everyone see my screen?
Yep, it's loading up now.
Thank you, Sarah. All right, Mr. Howe, I apologize for interrupting.
No, appreciate it. So again, the Tinker's Creek, you can see at the north boundary of the site there. Then it's bisected by the tributary to the south is the Hyde Landing site. You can also see by this exhibit, there's large areas of open space that were non-wooded areas that are going to be the concentration of the development. There is the high point of the site is closer to the southern eastern portions with the runoff flowing to the tributary in the stream with site access coming off the steep road.
And can you, and if it's helpful to pull up a different exhibit, please instruct, but could you please explain the existing improvements or existing conditions of the property, any environmental features and stormwater facilities or other utilities?
Sure. From engineering perspective, it would probably be best to pull up, I think it's exhibit 31, sheet 5 of the basic plan submission. That's the concept utility exhibit. Might have one sheet too many.
You can give up one.
Perfect. Thank you so much. From a water and sewer standpoint, there's connectivity to sewer. There's a sewer main that runs along Tinker's Creek. Let me back up. The water and sewer is within category 4, which is adequate for development planning. There's water main available within Steed Road. There'll be a redundancy connection proposed to the south end to the Hyde Landing site. We do have a WCC approved hydraulic planning analysis. That's DA 7961 Z25, confirming that that there is sewer and water capacity. As I mentioned, site access is from Steed Road. There's an existing floodplain, the approved plan from DPI. That is plan number SIT-00095-2024, showing 25.22 acres of 100-year base flood elevation, and that was approved October 29th of 2024. We did receive will-serve letters from dry utility companies, Pepco, Washington Gas, Verizon, Comcast, so they're all available on site. Future plans for stormwater management, we will be proposing a diverse mix of stormwater management quality treatment devices, including bioretention facility, gravel wetlands, bioswales, disconnections, as well as the quantity flood control for the 100-year storm. We'll have sediment control traps designed and basins that'll be utilizing the proposed stormwater management facilities to avoid impacts with redundant sediment control devices analyzed for additional protection in this area.
And what Sustainable Growth Act tier is the property in?
Tier 1.
And are you familiar? Just like that. Do you agree with the planning board's findings related to this application's compliance with the general standards, which are section 27-4301D, which is provided in Exhibit 27?
I do, yes.
And from a site civil engineering perspective, could you take us through subparts K, L, M, and N of that section?
Sure. Subsections K is related to the on-site potable water and wastewater. As I mentioned, we are in sewer category 4 with the connections that I mentioned before with the approved hydraulic planning analysis already in process. L is in relation to the on-site storm drain facilities. With this exhibit that we're looking at now, you can see some of these future connections, potential locations, along with the storm drain and stormwater management areas. The on-site storm drain facilities and their connections, again, they're shown on this with the diverse mix of submerged wetlands, bioretentions, disconnections. Details of these facilities will be shown and evaluated at the time of preliminary plan, section 273605 C5FX of the zoning ordinance requires stormwater management concept approval prior to that preliminary plan. And that concept plan will be reviewed by DPI. Section M deals with the on-site and off-site public facilities within the development. We're not in a municipality, but a number of public facilities will serve the development, including the Clinton Fire Station, 825, located at the Piscataway Road, Brandywine intersection, 2 miles from the property. The Clinton Police Station is 1 block off of the Brandywine Road, approximately 4 miles away. Nearby park sites include Costco Regional Park, Rose Valley Park, Stephen Decatur Community Center. At the time of preliminary plan, an adequacy test for the public facilities will be done as at the time for building permit, school facility surcharge per dwelling unit will be assessed. I think the other one you asked for was subsection N, which is related to provisions for transportation, potable water, wastewater, stormwater management. Again, I touched on the WCC water sewer category change. We're in category 4. We will need to modify that to category 3 prior to platting. There is on-site vehicle and pedestrian circulation systems connecting to Steed Road. Adequate the facilities improvements will need to be evaluated at a preliminary plan.
And in your expert opinion, does the planned residential community respect topographic and other environmental characteristics of the site?
Yes, it does. The site, existing drainage patterns will be maintained with the proposed development, stormwater management designed to include a continuation of the 100-year storm to ensure the flow rates do not exceed the current pre-existing development flow rates. Mr. Allison will touch more on the environmental portion of that, but again, we are utilizing the open space areas for our development area.
I have no further questions, Madam Examiner.
Ms. Votak?
Yes, thank you, Madam Hearing Examiner, and good morning, Mr. I'm not sure how to spell your last name. Is it Howell or Howell?
It's how, the E silent.
Got it. Okay, Howell, got it. Thank you. I have just a few questions.
Sure.
I believe I heard you say that the evaluation of the adequate public facilities would occur at a later stage. Is that accurate?
That is correct. That'll be with the preliminary plan, along with the preliminary plan at the ADQ stage.
So you did not evaluate whether this proposed development would have adverse impacts on the public facilities that currently exist, correct?
Correct.
Okay, even though demonstrating no adverse impact is a required finding for this application, is it not?
Can you clarify?
Yeah, it's true, is it not, that section 273602C4 provides that, give me 1 second to scroll there. Planned development decision standards that the entire development will not adversely impact surrounding properties. Is that correct?
That's correct.
But you did not evaluate whether the adequate public facilities in the nearby area would be adversely impacted. Is that correct?
I evaluated from the water and sewer and stormwater management component, and they are adequate as a
Okay.
civil engineer.
Okay, understood. So you can't really speak to whether the public facilities other than water and sewer would be adversely impacted by this project, correct?
Correct. We have other expert witnesses that will.
Okay, just want to make sure I understand the scope of your testimony. This application proposes a bridge over the tributary to Chinkers Creek, is that correct? Or at least a crossing over top of that?
It's a crossing, correct. The initial review, that will be a culvert crossing, not necessarily a bridge.
Okay, and that will impact the environment, will it not?
And sorry, Ms. Wilson, let me back up. That's not
Yeah.
over Tinker's Creek, that's over the tributary.
Yeah, yes.
Okay,
Yeah,
just want to
I
clarify.
understand what you're saying. Yes, absolutely.
Thank
And that will impact the environment installing that culvert, correct?
Correct, that is an allowable impact.
Okay. Did you do an evaluation of whether the I'm trying to think of the technical term for this, the content of the stormwater runoff into the tributary, will that change after development? Meaning the types of particles included in that stormwater. Did you evaluate that in your studies?
No, all that we've done with the concept plan, but as I mentioned, we will be restricted to attenuate to pre-development conditions.
In terms of the amount of stormwater runoff, correct?
Correct.
But that does not evaluate whether the stormwater runoff includes environmentally harmful materials. Is that correct?
Understood, yeah. So along with that concept plan, we would be doing an environmental site design as required, which will include treatment practices such as submerged ground wetlands, bioretentions, and we won't need to meet all the minimum requirements.
Okay, but you haven't done that so far, correct?
Correct.
Okay, so you can't provide evidence or testimony to the zoning hearing examiner that this plan as currently designed will not have adverse water quality impacts, correct?
Correct. The code requirement requires that at a later stage, not at the rezone.
Okay, got it. And another question I had, you're describing stormwater management calculations. I think you said the 100-year flood event. Is that correct?
Correct. That is the flood control, the quantity control I was referring to.
Got it. And those calculations, do they include climate change projections?
Yes, they do.
So you're able to assure the hearing examiner that these stormwater management facilities will be adequate to treat stormwater that is increased and exacerbated by the impacts of climate change?
Correct. The state and the county will as well.
And that's a state requirement that you incorporate climate change projections?
Yes.
Okay, I'm not aware of those, so that's good to know. And did you evaluate whether there will be more or less impervious surfaces created by this proposal compared to what would be allowed under the base zone?
There would be under the base zone? No, I haven't done that comparison.
Okay. Do you have a sense of how much impervious surface is being proposed by this application?
Not at this time.
Okay. So you're not able to provide the hearing examiner with testimony about the extent of impervious surfaces on this property, correct?
Not on the rezoning, correct?
Okay, so then correct me if I'm wrong. The amount of impervious surface is important in calculating stormwater management calculations, is it not?
It is.
Okay, but you're saying you don't have the amount of impervious surfaces currently being proposed, correct?
Ms. Votar, this is an application to rezone a property.
Mm-hmm.
Will be later plans, whether it's specific design plan or detailed site plan, preliminary plans. And at that particular point in time, the project will specifically identify the lot patterns, the parking lots, and any impervious surfaces. It's an impossibility to know today the amount of impervious surfaces, and therefore it's an impossibility to answer your question at this time.
Well, with all due respect, People Zoning Council, the applicant has the burden of proving to the zoning hearing examiner at this stage that there will not be an adverse impact to surrounding properties. And part of that evaluation inherently has to be an evaluation of the impact on the environmental features of the surrounding properties that this will directly impact. Perhaps if this was a different site with no environmental features, like a tributary to the Tinkers Creek stream, that might be a different question. But in my view, and I understand that we might have differing views on this, the applicant has the burden of proof of demonstrating based on the features of this specific site that there will not be an adverse impact to surrounding properties. And I'm trying to elucidate which testimony the applicant is able to provide to the hearing examiner to try to establish whether that's sufficient or not.
Again, you're putting the cart before the horse. That is premature. No one is going to be able to answer that question regarding a rezoning case.
I believe we can't continue down this road, but I would overrule in that she had the right to just question this to an extent because of the language will not adversely impact. And that counsel for the applicant, of course, can come back and explain, as you did, Mr. Brown, what is required at this time. So, Ms. Votar, do you have many more along this line, or you think you can do the compound one?
No, Madam
Okay.
Hearing Examiner, you read my mind. That was the last question I had. So,
Okay.
and thank you for your time, Mr. Howe.
Thank you.
Madam Examiner, unless Mr. Brown, I have one or two redirect.
Okay, but Mr. Brown, do you have any?
Go ahead. I don't have any questions.
Okay, Mr. Tedesco.
Thank you. Mr. Howe, you've been onto the site, that's correct?
Correct.
And what are the current stormwater management features on site today?
There are none.
And
I object. The standard that we are evaluating today is not a comparison of the current features to the proposed rezoning. It's the base zone and what's allowed under the base zone to what's being proposed in the proposed rezoning. So I think it's irrelevant what the any comparison to the current standards is not relevant to this case.
I would overrule. Go ahead, Mr. Tedesco.
thank you, Madam Examiner. So there are no current stormwater management features on site today.
That is correct.
And if this site were to be developed and approved, what would the standard requirements be for stormwater management with respect to the design and the requirements? And in other words, how would the stormwater have to be designed with respect to development on this site?
We would have to, obviously, we'd have to go through the water quality treatment and ESD for any additional impervious area, as well as develop to do the pre-designed conditions for flood control.
And when does that occur in the entitlement process?
The concept plans are done at time of preliminary plan. Final design plans are done with the permit.
Thank you. No more questions. Madam Examiner, we
Todd,
would,
did you have, oh, excuse me one sec, did you have redirect though based on that?
Yes, it's very brief and perhaps redundant, but just so the record's clear. Mr. Howe, the decision standards again are that the applicant shall demonstrate to the satisfaction of the district council or the zoning hearing examiner in this case, that the entire development will not adversely impact the surrounding properties. Is that correct?
Correct.
So that's a standard that this application is being evaluated under?
Correct.
That's all I have. Thank you.
Mr. Howe, in your expert opinion, will this approval have any adverse impact to the surrounding community based upon a site civil engineering?
No, not from site civil.
Okay, thank you, Mr. Howe.
Thank you so much.
Madam Examiner, we would next call Ms. Christine Gillette.
Good morning, Ms. Gillette.
Morning.
Do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
I do.
Would you please state your name and address for the record?
My name is Christine Gillette. My employer address is 1101 Mercantile Lane, Suite 280, Largo, Maryland.
And where are you employed and what is your title?
I'm with Rogers Consulting and my title is Senior Landscape Architect.
And how long have you been employed in the field of landscape architecture?
Over 20 years, and the last 15 has been exclusively in Prince George's County.
And are you a licensed landscape architect in the state of Maryland?
I am. My number is 3686.
And have you previously been qualified and accepted by this hearing examiner in landscape as an expert in landscape architecture?
I have for ZMA 2022-003 Smith Lake Estates and ZMA 2022-005 Hyde Landing.
And Madam Examiner, Ms. Gillette's CV is Exhibit 25 at page 9, and we would ask that she be accepted as an expert in the field of landscape architecture here this morning.
No objection.
No objection.
Thank you all. You'll be expert in the area of landscape architecture.
And are you familiar with the property that's the subject of this hearing?
I am.
And did you make a personal inspection of the subject property?
Yes, most recently on March 24th, yesterday.
And did you prepare or assist in the preparation of the basic plan and the other site plan exhibits which are filed in conjunction with this application?
Yes, I personally prepared the basic plan and all the plan exhibits.
And Madam Examiner, I would just note that section 27-3602A2 of the zoning ordinance provides that the basic plan, site plans shall be prepared by a licensed either architect, engineer, landscape architect, or land planner, for which Ms. Gillette qualifies. And could you please describe the property and the basic plan that you prepared? And if you need to, we can pull up Exhibit 31.
Yes, can we have Exhibit 31, please?
If you could just take us through the basic plan and what we see on the screen.
Sure. So what you have before you is the basic plan with all the required items as reviewed by technical staff. The property is one large parcel. You can see it located along Steed Road. It's currently used as I think someone mentioned a small hobby farm would be the best characterization. Just some grazing pastures for some interesting livestock. To the northeast across Steed Road is one of the Steeds Glen neighborhoods. Lot sizes are approximately 2/3 of an acre to 1 acre. To the northwest, which is up on this plan view, Tinker's Creek runs northeast to southwest, and the entire northern portion of the property lies within the existing stream valley. To the west, there's some vacant land associated with the Potomac Airfield. To the southwest is undeveloped woodland. And to the southeast is the approved Hyde Landing development, which has residential uses, solar pods, and similar extensive preservation of natural features. On this basic plan, you can see Pod B, which is the portion that will front on Steve Road. And that will feature single-family detached homes, which will be compatible to the residential uses across Steed and in the greater area. Pod A is more central in that space, and those are the attached, single-family attached homes, townhouses. And then another Pod C across the waterway. It would be probably larger lots for single-family detached homes. And each of these pods is designed, you can kind of see in green, to have a variety of recreational spaces. And all of these would be interconnected with a network of sidewalks and trails and of course roadways for vehicles. What you can kind of see on this is that these residential pods have been located on the site for the most part where there's currently open space. So the footprints impact the existing environmental features to the least extent possible in this case. And all of those areas are anticipated for preservation in one way or another.
And could you help elaborate more on why the RPD zone was chosen for this property?
So I think one of the phrases you're gonna hear a lot today is flexibility. The RPD zone was designed with the new zoning ordinance to provide that flexibility separate from the base zones so that we can, properties like this can work towards providing a mix of housing types rather than just the one type perhaps in the base zone. So they can fulfill policies such as the housing opportunity for all, countywide housing strategy, as well as the general plan and subregion 5 master which we've explored, in great detail, of course, in the statement of justification and was reviewed and supported by technical staff. Establishing an RPD zone on this property will allow proportional density, net lot area, and dimensional standards to be established for the site, which will meet the purposes of the RPD zone and allow for more efficient use of the land and a higher quality of development, while still respecting the existing environmental habitats and the surrounding neighborhood character. There's, contemplated, like I mentioned, a mixture of housing types and sizes that can help support more of a multi-generational development to further complement the Hyde Landing development approach, with homeownership available to a wide price range, accessible to first-time home buyers.
Excuse me, I'm gonna have to object. I believe this witness was offered as a landscape architect, not as a planner or the developer of the property. So I object to her testimony to the extent that it's outside the scope of landscape architecture.
Mr. Tedesco?
Well, the question dealt with why the RPD zone was chosen. So she's going through the flexibility that's provided in the RPD zone as a landscape architecture and the preparer of the basic plan. I think it's relevant.
Well, again, as a landscape architect, she has experience in landscape architecture and expertise in landscape architecture. That does not expand to planning. And I believe a question of why the flexibility is beneficial to the extent that it touches on any point other than landscape architecture would be outside the scope of her expertise as proffered currently.
And I hear you, but because the rules of evidence are relaxed, I understand that this portion of her testimony is not exactly expert testimony, and I could be wrong. And I might ask this question. Did you discuss these matters with the owner and the other experts and the attorney in this case?
Yes, this is the efforts of the entire team.
Okay, and so as you were hired to prepare these plans, the reasoning, you're providing the reason why the applicant wanted to go forward. right now, correct? You're not exactly speaking as to setbacks, et cetera, topography and everything else with these plans. I'm going to allow it mainly because the rules of evidence are relaxed and I'm not taking this portion as expertise. I'm taking it as a little background as to why they wanted this zone.
Okay, I
So
just,
overrule.
with all due
Go ahead.
respect, Madam Hearing Examiner, I'm just asking for consistency because my questions about general traffic concepts were shut down as it wasn't within the scope of their expertise, so I respect the hearing examiner's decision. I
Well,
just
I
want to note that
understand.
for the record.
And I hear you. I just thought you're going to
Well-
ask that of someone later and that he hadn't testified to that on direct. That was I heard what everybody else objected to, but he hadn't gone that far on direct.
And also, Votar, the distinction is you were asking a traffic question to a layperson. Now the questions are being asked to an expert. An expert may opine on other experts that it has dealt with on an issue. And so when you ask this landscape architect, she can then say, I have spoken with the traffic engineer, I have spoken with the land planner, and it's my understanding XYZ. And so that's the difference here. This is not a layperson. She can rely on other expert opinions in this case.
Again, with all due respect, I'll leave it, but I was asking that of expert witnesses, but I'll leave it. I respect the hearing examiner's decision, and I just wanted to note it for the record, so thank you.
Okay. Go ahead, Mr. Tedesco.
I don't know where we left off.
Maybe just to complete that section of why the RPD zone was
I
chosen.
think you had one more bullet.
There was, obviously the goals of the flexibility, product type, et cetera, fully understanding that public benefits would be a substantial portion of the design process and new community components for both this property as well as the surrounding area. And those are outlined in detail in both the public benefit SOJ, the improvements exhibit, the public benefit SOJ is exhibit 20. The improvements exhibit is number 16, and the big picture exhibit is number 21. And that was generated to communicate and coordinate with staff to show them what would both be the standard requirements for a site development, and then show how the public benefit features were above and beyond measurable and of high value.
And could you summarize the requested development data if ZMA 2024004 is approved?
So there's a development data table on this basic plan, sort of center lower area. We have the gross area, the floodplain area, and the net lot area. And I just need to make one note that there was a typo on this submitted version where the proposed maximum density should show as 101 dwelling units per 100.94 acres, resulting in the minimum density that would be required with RPD of 1.0. And the proposed maximum density would be 300 dwelling units divided by the 194 acres, resulting still in the 2.97 dwelling units per acre density.
So Madam Examiner, we would proffer a condition if you're inclined to recommend approval of this application to modify the development data table to correct that typographical error, which Ms. Gillette just testified to. And for clarity, in the development data table on sheet 1 of the basic plan, proposed minimum density, it currently says 91 DU divided by 90.02 acres. That should be 101 DUs divided by 90.62. And the proposed maximum is 300 DUs divided by 100.94 acres. So the issue is that the acreage for the net lot area is shown and proposed minimum and maximum is 90.62. The correct number is 100.94 acres based upon the gross and the 100-year floodplain. There was a typo with respect to the acreages being transposed as 90.62 instead of the 100.94. And Ms. Gillette, could you also indicate whether or not the resolution of the planning board exhibit 27, I believe, has a similar or other mathematical error in it on page 11?
Correct. On the resolution, page 11, there's a comparison of the metrics currently permitted under the RE zoning in comparison to the master plan. And it lists the maximum density of 1.08 dwelling units per acre, the acreage of 194 acres. But then they inverted the math and listed 93 when it should be 109. I believe the acreage was divided by the density instead of multiplied. So I just wanted to clarify that.
And could you
I'm so
summarize?
sorry, what page was that again on the planning board resolution?
Page 11, it's right at the top. There's a
Okay.
slim table. You're allowed more than one dwelling unit per acre and you have over 100 acres. The density will be over 100.
Madam Examiner, may I continue?
I'm sorry, just one more thing about this basic plan. Does it address the reduced minimum maximum lot cover?
Yes, that's the part we're going to get to just next.
Okay, go ahead.
Great segue. Ms. Gillette, could you please summarize the requested development standards if this application were to be approved?
Yes, on the basic plan to the lower left is the proposed residential intensity and dimensional standards. As noted earlier, there is a condition as recommended by the planning board and staff that we adjust the minimum front yard setback depth to 10 feet, where it's currently listed as 5, and for both detached and attached dwellings, and the maximum lot building coverage from what we had originally started with to 60% for detached and 80% for attached. And those would be modified on the plan prior to a submission for certification.
And you and the applicant are in agreement with those recommended conditions and changes to the basic plan?
Correct.
And in your expert opinion, will the rezoning of the property to the RPD zone establish dimensional standards that are consistent with the requirements of the RPD zone? And if so, why?
They will, because the RPD, when establishing these for the RPD zone, they are all open. They're unwritten in the code. It is.
Again, I'm going to object. I again believe this is outside the scope of her expertise as a landscape engineer, and this is within the scope of what Madam Hearing Examiner described as, talking about setbacks, talking about details of the zoning code, which again, a landscape architect, I believe, does not have the expertise to opine on.
So this actually is fact, because the zoning ordinance, where other base zones have a list of these dimensional standards, this blank for the RPD, because it's listed as this is the time to establish those dimensions, which the
Again,
team
I'm going to object to the extent that her testimony is outside the scope of a landscape architect.
She's just stating what is in the code and what they're providing on these plans. Correct? You reviewed the code in order to do these plans? What was your question again, Mr. Tedesco?
Will the rezoning of the property establish dimensional standards that are consistent with the requirements of the zone?
They will.
And they're shown on the plans.
Correct.
I have to overrule again. She's just restating what it was required in the code to be put on this plan and what she put on it, or whether it meets the code. Okay, overrule.
Did you prepare or cause to be prepared the circulation plan associated with the connectivity index required as part of the basic plan?
I did. It's
Sheet 3.
sheet 3 of this exhibit. That demonstrates the identified links and nodes, which as guided by the ordinance.
I'm sorry, I'm not trying to
result
belabor
in
this point.
1.54.
I object again. Could we at least have a proffer that this is a type of work that ordinarily is within the scope of a landscape architect? I'm struggling to see how this is within the scope of the expertise of a landscape architect to talk about the circulation patterns in a development.
You want to cross-examine on that?
Well, I mean, if I could be heard, so section 27-3602A2 provides the requirements for what's required to file a plan development basic plan. And within that section, subsection A2, it specifically provides that the plan must be prepared by either a licensed civil engineer, a licensed planner, a licensed landscape architect. So this is a requirement of the basic plan. Ms. Gillette is the one who prepared this. She is required by code to prepare this exhibit as part of the basic plan. The code specifically provides that a landscape architect can do that. Ms. Votaw can disagree, but that's what the code allows for. So she's simply just providing testimony that she prepared this plan and that it exceeds the circulation requirements required under the zone. So I can proffer that.
All right, and I'll get into it on cross, I suppose. I'm just trying to preserve my objection, so I'll respect that and we can move on.
Okay, it's overruled. Go ahead, Mr. Tedesco.
Thank you, Madam Examiner. Ms. Gillette, once again, you did prepare the circulation plans required by code.
I did.
And could you just please explain to the examiner what this plan demonstrates and provides for
This is
per the code?
for the code. This is the conceptual land plan that we are starting with, showing the different areas of development. And you can see with the red stars, those are the nodes, and the green double arrows are the links. And per code, those are located on this exhibit and tabulated to demonstrate that the 1.54 meets and fulfills the requirement of the connectivity index for this section.
And did you prepare or cause to be prepared the open space set aside exhibit for this basic plan?
I did. That is sheet 4 of this exhibit.
If we could go to sheet 4, Sarah.
So this exhibit was prepared to demonstrate the requirements of section 27-6400, showing the combination of natural environmental features in purple, the active recreation areas in red, passive recreation in yellow, and you can see some sections of trail in orange, currently proposed for the site. The open space set aside requires 20% of the site to be in one or more of these categories, and this current exhibit is providing 48%.
And did you prepare or cause to be prepared with consultation with other experts, the public benefit improvement exhibit, exhibit 16, and the public benefit statement justification, exhibit 20?
Yes.
Could you describe those exhibits, please?
Sure. Exhibit 16, please. As I actually mentioned just a little bit ago, we created this chart to help demonstrate to technical staff what would be required under a standard site development process and what would be the above and beyond public benefit features. Because a lot of these have parallels. There are road frontage improvements required under the first column of subdivision and other site plan requirements. But then in parallel, under the fourth column, there are various roadway improvements proposed as public benefit features. So we wanted to basically itemize what would normally be required and what would be the public benefit features in a very clear way so that we could demonstrate the measurable nature of them as well as their value.
And do you know what the planning board's ultimate determination was on these offered or proffered public benefits?
Yes, I believe they were in agreement with the proposal for all of them. I think they did have some concerns that the proposed interpretive signage would be something that would be already required. I don't think that's quite accurate because they referenced an archaeological survey that would be done in the future, and anything resulting from that could require a sign. But what was proposed as this public benefit would be interpretive signage to be along the trails, sort of communicating the character of the existing natural systems and community to be designed in the future. But if that's not something that they wanted to accept, that's fine. The other ones, I think, are well in excess supporting this project.
And are you familiar with section 27-3602C of the zoning ordinance?
Yes.
And regarding subpart C3, does the request of rezoning satisfy the applicable standards of the PD zone?
It does.
And regarding subpart C4, as it relates to the basic plan design, and in your expert opinion, will the rezoning of the property to the RPD zone adversely impact the surrounding properties?
In my expert opinion, it will not impact the surrounding properties.
Why not?
The master plan designation and the use we're proposing for the site is residential. The adjacent properties in part are residential in character. There will be adequate and substantial environmental and planted buffering and site design so that there is no conflict in that direction. And as mentioned earlier, of course, the density proposed is well under what the master plan allows, and that keeps it in character with the neighboring developments.
And was the zoning map amendment application and basic plan prepared in conformance with section 27-3602 A5B through H and 27-4301 D1?
Yes, the first set of sections that you mentioned are the standard application procedures. All of those documents and information components were assembled and submitted to the planning department staff for review. All of those were found to be provided and submitted all at once with acceptance review. The second range of sections you mentioned, 27-4301 D1, establishes the planning development, or has us provide certain documents for this basic plan, including development goals, uses, general location and type of residential, dimensional standards, amount and location of open space, environmental features, demonstrating a conceptual pedestrian vehicular circulation system, showing existing and proposed water, sewer, and storm drain, and the specific public benefits, which all of that is included on both the basic plan and the supplemental documents.
And from a landscape architectural standpoint, will the rezoning of the property promote development patterns that respect the character of the surrounding neighborhoods?
In my expert opinion, as landscape architect, it will.
And does the statement of justification address all of the requirements under section 27-4301 D, general standards?
It does.
And does the application as well as the basic plan comply with these standards?
It does.
And you previously testified that you're familiar with the planning board's recommendation in this matter, which was required pursuant to section 27-3602 B7A, correct?
Correct.
Did the planning board's written recommendation and its resolution, Exhibit 27, determine whether all of the general standards of section 27-4301 D were met?
It did.
And do you agree with the planning board's findings related to this application's compliance with the general standards?
I do.
And does the application and basic plan comply with the applicable standards of part 27-6?
It does.
I have no further questions.
I have one before everyone else starts, and that is 27-4301 D states that this plan shall establish the specific principal, accessory, and temporary uses permitted in the zone. The specific ones. I've had this come up with other cases. I just want to hear you all's viewpoint on it. Are the specific accessory and temporary uses shown on this plan?
The specific uses are the two types of residential dwelling unit, the single family detached and attached. And we do have some notes under the dimensional standards for such things as fences, sheds, decks, their locations, shed footprints, things like that, to address any accessory items and temporary uses.
That's the wording, such things as, what does it say about the accessory uses?
So if you...
I can't see it well, I'm sorry, and if I
Yes.
blow it up, I can't see it well.
That's
So,
okay.
I want the old-fashioned paper next time, if
Oh, yeah.
anyone's listening to me. Oh, look, see? You've got it,
So
okay.
down in the lower left corner is the dimensional standards continued, which mentions side, rear, and side and rear setbacks for fences, sheds, and decks. and maximum heights. And then we have notes saying no fences, sheds, or decks are allowed in the front yard of any residential lot. Shed footprints shall be no larger than 64 square feet. Temporary uses and structures are allowed in accordance with section 2753.
Okay. So on temporary use, I'm just throwing it out there. I don't believe that's saying the specific ones unless you're saying you want every temporary use in that section. I don't know that you're saying that. And on the accessory uses, it sounds like you don't exactly say it's accessory, but that's the ones you want. Okay, thank you. I just needed to clarify that. Ms. Votaw, you have any, well, wait a
Yeah.
minute. How long will you all be? I haven't given this staff a break this morning.
I think for these questions, at most 20 minutes.
Okay, can we take, it's 11:16. Can we all just come back in 10 minutes? It's 11:17. Can we come back
Absolutely,
in
ma'am.
10 minutes? Thank
Yep.
you.
Thank you, ma'am.
You can just leave everything.
Recording stopped. Recording in progress.
Thank you, Ms. Vota. You may continue.
Thank you. Okay, let me reorient myself. Miss Gillette, that's how you say your last name?
Correct.
Okay, great, thank you. I first wanted to talk about the site plan, and I apologize, I don't remember what the exhibit number was that you all were looking at during your testimony, but it had the layout of the proposed development with some of the environmental features shown on there. Would it be possible to bring that back up or remind me what exhibit that was?
I think that was exhibit 31.
Thank you, perfect, okay. I just want a quick clarification. So and I apologize if it's not technically a dashed line, but the yellow line that appears dashed, that kind of goes from the top of the screen, then down through the middle around the tributary. What does that show?
That's demonstrating the PMA, the primary management area,
Okay,
delineating the environmental preservation zones.
okay, got it, thank you.
Regulations.
And ordinarily, would an applicant be able to develop in the PMA?
During regular and RPD development, PMA development is, or construction is restricted to certain uses.
Okay,
So we would not be putting any lots or other uses in there.
got it. So under the base zone, this area would have to be preserved, is that correct?
Correct.
And then under the proposed zone, this area is also being proposed for preservation, is that correct?
Correct. Those standards apply regardless of the zone.
Okay, so there's no additional area proposed for preservation than would be required under the base zone, is that correct?
So the PMA and preservation are two different metrics.
Okay, I'll just start with the PMA then. The PMA is the same regardless of what zone is being applied, correct?
Correct.
Okay, and I saw on the sheet, I believe, that the 100-year floodplain consists of 25.22 acres. Is that correct?
I believe so.
Okay, and
Yeah.
is that within the PMA?
That is included in the PMA.
Okay, great. And could you remind me the amount of woodland preservation being proposed?
I don't have that number to hand, but our environmental expert will be able to investigate or discuss that with you.
Okay, so you don't know that number. I'll save my questions for them. Okay, got it. In your testimony, you said based on your expert testimony, there would be no adverse impact of this proposed development on surrounding properties. Is that accurate?
Correct, in my expert opinion.
Okay, and I just want to evaluate the scope of that expert opinion. That expert opinion does not include an evaluation of traffic impacts. Is that correct?
Correct.
Okay, and does that include an evaluation of environmental impacts like stormwater management?
All those components are part of the application, and I've of course discussed that with our development team.
Yes.
But others can speak to those items better.
Got it. So as a landscape architect, that's not your area of expertise, correct?
Correct.
Okay. The other question I have is, the plan lays out dimensional standards, is that correct?
Correct.
And are those the dimensional standards that staff found exceed what may be reasonably achievable while conforming to other code requirements?
A few of those items, such as the lot coverage percentages as originally proposed, we did have that discussion and then came to the conclusion that the numbers would be adjusted.
Okay,
to
and
those.
you haven't since provided the zoning hearing examiner adjusted numbers, is that correct?
Correct. That would be updated on the document following this hearing.
Got it. And so when the hearing examiner is tasked with evaluating specific uses, including dimensional standards, what's currently before her is not what will end up being proposed. Is that correct?
It is a condition. So it would have to be part of the plan moving forward.
Yes, but you are not providing to the zoning hearing examiner the specific numbers that are updated,
Well, the
correct?
specific numbers are in the resolution that would be provided on this basic plan. So all
They
the
laid out all of the dimensional standards that have to apply?
yes,
Okay. And did you prepare the dimensional standard calculations
yes,
as a landscape architect?
yes.
And similarly with the circulation plan, did you personally prepare that?
I did.
And that's based on your expertise as a landscape architect, is that correct?
Correct.
Okay. I think that's all the questions I have for this witness. Thank you. And thank you, Ms. Gillette.
You're welcome.
Thank you. Mr. Brown, did you have any questions?
No questions. Thank you.
Okay, thank you, Ms. Gillette.
Thank you.
We would call Mr. Steve Allison.
Mr. Allison,
Yes.
good morning.
Just
Do you,
screen here? You can lower
do
your
you-
chair.
do
Lower
you
my
swear-
chair. Second.
okay,
Different size than Christine. All right.
okay. Do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
Yes.
Could you please state your name and address for the record?
It's Steve Allison. The address is 1101 Mercantile Lane, Suite 280, Largo, Maryland.
And are you a licensed landscape architect and ISA certified arborist?
Yes, correct, with additional ISA certification arborist of track qualifications.
And have you previously been qualified as an expert in environmental planning and agriculture before this hearing examiner?
Yes, I have, for ZMA 202203, and then for ZMA 2022-005.
Madam Examiner, Mr. Allison's CV is Exhibit 25 at page 16. We would ask that he be retained as an expert in environmental planning and agricultural. Arboricultural, excuse me, I can't pronounce that word.
I kept hearing agriculture. I'm like,
It's
okay.
arboricultural.
It's
Arboriculture.
Forest.
Any objection or voir dire?
If I could just get a proffer on the scope of his testimony to avoid my objections from last witness.
All your woodland conservation questions will be fair game. How about that?
Okay, deal. That makes sense to me, and I have no objections, assuming they stay within the scope of that.
You'll make sure of it, I'm sure.
Thank you very much.
And the agriculture, arboriculture threw me off so much. What's the beginning part?
Environmental expert. Environmental and agricultural.
Arboriculture.
Arboricultural.
Think arbors.
Arboricultural.
Yeah.
If that's the hardest thing I have to do today, we've had a good day.
No, we got some more. He's an expert in environmental?
Go ahead, Steve.
Yeah, so I'm an environmental expert in forest conservation, but I also have training in wetland delineation and ecological systems as shown in my CV.
Okay. Okay. Environmental expert in wetland conservation. I don't have your CV in front of me. Wetland conservation.
Yeah, we can go through it. I'm a professional landscape architect with Maryland. My number is 3845. I'm an ISA certified arborist as well, which my number MA 569A or 5691A. And then I have a wetland delineation training, which is typically what you get in Maryland, not a certification course in 2014. And then in arboriculture, I have a track qualifications, which is slightly different than just being an arborist. It's the ability to assess and manage tree risk and hazards in a standardized, defensible way through ISA, which looks at abiotic and biotic disorders, likelihood of failure, understanding the biomechanics of those, and likely targets. So it's more of a robust arboriculture degree that I use when evaluating the forest on site. And all of this kind of combined as being the environmental lead at Rogers Consulting. I take an ecological look overall beyond all things, with the trees, but I think about the soil. I think about the streams. Those are all fair game that we do analysis of through our review. And I will be touching on some of those points as we look at the overall holistic ecological purpose of this site and what it is today and what it could be in the future.
So if I narrowed it to professional landscape and expertise in landscape architecture, wetland delineation, and arboriculture, will we hit it all? And other environmental issues pertaining to forestry? That is the longest one I've ever had to do, but
Yeah.
did I just cover it? It's
I think
just
so.
environmentalists throwing me off just saying that.
Yeah, no, understood. I think so because it's all interconnected, right? Trees don't exist without the soil, don't exist without the streams and the water and the hydrology. It's all connected and it's under the purview of landscape architecture. You can sign all those plans in Maryland with that information.
Okay, so if we left it in landscape architecture and arboriculture, you could probably say it.
It's all under that purview.
And I understand, I'm accepting you in that, but it's not limited. I understand that all of these things are holistic and you may be touching on
Yeah, exactly. I think
trees, the soil.
landscape architecture, I think you can land 140 different jobs. So
Okay, and
it's a
arboriculture.
tough one.
Okay. Are you all right, Mr. Tedesco?
Yeah, I think previous applications, both four different rezonings, it was landscape architecture and arboriculture.
There we go.
Thank you. I like those. The environment was throwing me off. Okay. Go ahead, Mr.
All right.
Expert in landscape architecture and arboriculture.
Mhm.
Okay. Glad we got through that. And hopefully I don't have to say that word again. Were you employed by the applicant to perform certain services associated with the subject property?
Yes, it was.
And could you touch on what those services included?
Yeah.
And why?
Yeah, sure. So what we've done so far is the natural resource inventory, and that accounts for everything kind of like what we're talking about. Myself and my team evaluated the streams, wetlands, the forest inventory on site, understanding what specimen trees are there, what ecological health of the existing forest. Not all forests are the same. We also looked to see if any county requirements were there, right? FIDs, understanding rare, threatened, endangered species, which is all part of the NRI phase, walking through U.S. Fish and Wildlife, requirements through their IPAC review, which is informational planning and consultation. And we basically take a look at everything that's available on desktop and then everything within the site outside of, I guess we go 100 feet out to see what exists today. And then that's kind of how we frame what's possible on site.
And what work did you actually complete?
All right, so there's gonna be a little bit of repeating because I always go over in what I'm speaking about. But we went ahead and did the natural resources inventory. We took a look at the floodplain areas, the soil for any wetland features, and that's where you go kind of 3 criteria, and you figure out if you have hydric soil, you have hydrophytic vegetation, and what the geomorphology is. And finding those things usually generally around the floodplain and Tinker's Creek area, and then you can have isolated wetlands. So we go ahead and kind of test the environment there. And we also look at the health of the forest that currently exists, and we look at what areas would be priority based on the geomorphic position and the ecology of the site. So we went ahead and did that whole full analysis, understanding requirements that could be down the pike for state, federal, and county.
And you're familiar with the basic plan that's the subject of the hearing?
Yes.
And what components of the basic plan did you assist with and/or with the statement of justification as well?
It would be the NRI and the ecology of the site.
And as part of the environmental team, what specifics did you analyze and go through with respect to assisting with those plan elements?
I reviewed the trees that were identified. I reviewed the forest ecotype. I reviewed what the floodplain looked like and what the wetland considerations were that we found on site. Did the evaluation of our site analysis with that, and then reviewed the NRI as it was submitted and the site statistics that are necessary for the county.
And what type of features did you identify on site?
Yeah, so we found, obviously you have Tinker's Creek, we have forest, I think it was like about 77 acres. I could find my actual site statistics. We had, I think it was 1 perennial stream, 5 intermittent and some ephemeral. And what that means is perennial stream always just have water, intermittent can have it seasonally, and then ephemeral is more stormwater related, doesn't have the base
water table connection as an intermittent. An intermittent, like I said, sometimes can have water, sometimes doesn't have water. Took a look at that. We did find a wetland system within the floodplain, and we evaluated the floodplain soils as well as, and what you're looking at there is you're trying not to have any chemical reduction or anything in that soil as compared to a floodplain soil.
And could you identify what some of the goals associated with the basic plan were to not only preserve the high priority forest areas, but also assess the opportunities for forest enhancement?
Yeah, exactly. So in the master plan, they have a couple policies that we kind of look at. When I look at this site, yes, we have the policies and what they specifically are, but I look at the whole ecological front of, could we make this better with design? How does the whole thing work? But going through the policy ones we look at, first policy is to implement the master's plan desired development pattern while protecting sensitive environmental features to the fullest intent, the environmental policies and regulations. So I take a look at what can we actually do within this envelope, and we meet that kind of by looking at the highest quality forest and see, can we preserve that ecotype? How can we preserve it? What is the condition it is in today? So we took a look at that one. The second policy to ensure the new development incorporates open space. There it goes again, environmentally sensitive design and mitigation activities. We take that into consideration. We look to have no net loss of forest when we do these evaluations. Third policy, which that I'll probably hit on a little bit, or it's reflected, is protect, preserve, and enhance the identified green infrastructure network. And you're going to have that come through Tinkers Creek. I look at that as well and try to see what it currently is today, not what it would be proposed by the base zoning, but what it is today if it was never developed. What does it look like? What does that green infrastructure do? So I take a look at that as well. In the green infrastructure plan, they list one of the primary corridors to protect is Tinkers Creek, along with Mattawoman and Piscataway. And I take that into consideration with any restoration goals or things that we can do once we're actually on site. And on site would be through a development process.
And are there any environmental considerations that are actually advanced as or by this basic plan that would further ensure that adverse impacts on surrounding properties are not realized?
Oh, yeah. Yeah. I mean, coming into a plan that sits here, that's an agriculture or farm use, we mentioned donkeys, chickens, cats, whatever that was there. What do we have there? We had a bunch of stuff, sheep. When you come in a plan that you're actually going to develop, you have to, and yes, we're sitting here at a zoning rehearing, but the idea is that you're going to take this into fruition, and it's going to, you're going to be accustomed to all the developments from the county, the state, the federal, all those things are going to come into play that you are required to take care of. So thinking about betterments of the site, I know that with any development that we're going to do, we're going to have to move up to modern stormwater facilities, standards that you have to do. What that does in an area that's agriculture or farm use that doesn't have a lot of those modern facilities, what you're doing is you're changing the nutrient load analysis. You're changing that framework on site to something that's going to have more forest. It's going to have better stormwater quality, like we mentioned, but what it's going to do, if you develop any one of those areas, and that could be in the base plan, but this is our design right now, you're going to reduce your sediment and your nitrogen just right off the bat. That's going to sheet flow to Tinkers just with any development. That's before you even add in the forest. That's important to know. Understanding that if you do have a crossing, right, in Maryland, you're subject to the joint permit application that MDE. What happens there is you get more scrutiny. Hold on 1 second, something came on my screen. What that does is it brings in a review from MDE and Army Corps to say, what are you doing? How are you making more further scrutiny on the area? Then you definitely, regardless of, if you fall within the impacts of functional loss, you would have a mitigation opportunity as well. When you come in to develop these areas, you also come subject to tier 2 that exists in this area. Tinkers Creek doesn't have a similar capacity. How do you handle that? Without developing these pieces and taking a look at this, as the project sits today, the water sheet flows off. You don't have all these numerous Maryland requirements to take a look at. Once you start developing it, you move forward with all those requirements and you create a betterment for the site. And we can go through individually what those are. But that's what you have in store in the state of Maryland when you develop is all these rigid requirements.
In your opinion, does the basic plan meet or exceed the required environmental standards identified by either the code or highlighted by staff?
Yeah, I think it does. I mean, we can come into just forest conservation, which I know is of interest as I flip through some of my easement language here. Second. Previously, the RE zone that currently there is they asked for a 25% threshold on that baseline. I think it's like 25.23 acres. Converting our zoning to the RPD, it goes to a 20% requirement. We realize that's lower, right? We went ahead and proffered a 5-acre requirement that we would develop on site, put that in as a public benefit. That's a pretty big increase there. It kind of gets you right at that line of what the 25% would be, but we would go ahead and understand that there's more retain opportunities. That's the base level, right? 25.23. We'd have more opportunity to plan on that. Again, we're in a conceptual stage. We looked at the PMA and what was there. I know that was brought up. We have about 31 acres that sits in that PMA of what we're looking to maintain or anything that we would need to replace if you had any stormwater impacts or utilities or things that, beyond what we're looking at in the sketch. And then we're looking to have everything on site, right? So that was an agreement. If you go ahead and look at the technical report, they're looking to have your forest conservation met on site, and we've reviewed our plans and we have the ability to do that. So if you think about, yes, we're going to have some obvious loss of forest in some areas, but we're actually going to replace it. And there's a big argument about what you actually bring in strategically than what is just naturally growing there. Sometimes the health of the forest that's naturally growing there is not the same as what you're bringing in. If you understand the ecology and transitional edges that you're trying to create for species and habitat. So it's something we consider. So as long-winded as I normally get, that's kind of how we feel coming into this position of what we'd even remove or handle would actually be a betterment because we're designing it, not literally just letting it just lay there as it is today with invasives, understory, and vines that seem to be taking some of the trees down in some of our analysis.
Could you speak to one of the benefits of the RPD zone, providing the flexibility and allowing for more compact development versus by right RE, large lot development, and how that impacts from an environmental standpoint and other types of afforestation, reforestation opportunities or no net loss opportunities for this particular project?
Yeah, the clustering and compact development definitely gives you this opportunity to explore options for afforestation and reforestation that then, done well, increases the ecotype that's there. Rarely, when you have this clustered zone in the RPD zone, it's a little bit smaller, you have that opportunity, that flex space to work with your stormwater facilities as well as your afforestation area to create a complete ecosystem buffer to, let's say, this creek, and that's what we were kind of looking at. Going from the basic zone of what you're trying to do, the base zone of what you're trying to do there, your area is somewhat limited to work with, where your base dimensions of what you could provide could be small enough that it's muted in the opportunity that you can create.
And in your opinion, would that be an adverse impact or a benefit?
Developing a site with this new zoning, I mean, that's not necessarily a holistic adverse impact. It's actually a betterment. We do things differently in how we design things here, but on a legal standpoint, that would be a betterment of opportunity of what you could place on some of these existing ag fields and farm fields. Yeah, that's the way to describe it.
And are you familiar with section 27-4301A7, which deals with the purposes, or at least one of the purposes of the RPD zone?
I am.
And subsection A7 deals with the promoting of development forms that respect and take advantage of the site's natural scenic man-made features such as rivers, lakes, wetlands, floodplains, trees, historic features, cultural and agricultural resources. You're familiar with that?
Yes.
And what is your opinion with respect to this basic plan meeting that purpose?
I mean, I think we take care and, you know, we're designing the development around the natural features, which is a big deal. We're not going straight through it. We're preserving and expanding the green infrastructure network. We understand what that network is. We're not just planting trees because it's required. Tinkers Creek is kind of an issue with that. So we understand our expansion of any type of forest or transitional edge is beneficial for that. We're enhancing, we have the opportunity we want to look into from the staff report, enhancing the woodland that exists today, which I think is a betterment, and we're going to explore that option of what's previously there. We talked about the nutrient differences between developing and what exists as today as if there was no other option. And that kind of meets that criteria, in my opinion.
And in your expert opinion, does the plan development community respect topography and other environmental characteristics of the site?
It does. You know, when we went out to the site, we do an evaluation. Usually we're the first ones on site to go through all that. We went back and spoke with the engineers and the planners on, here's what you have to do to actually make this site viable. You got to avoid this. You got to avoid that. Here are going to be your PMA lines. Here's where your stream buffer. Here's your tier 2 buffer. How is this complicated? The design that we did kind of really fronted the point of, yes, you have some forest loss going to the, I think it's the east, off of Steve Road is the east. But that was upland in a slope that was probably the least impactful when you actually think about Tinkers Creek's watershed and the immediate need of how many hundreds of feet that you want to purify the water or filter the water through there. So yes, we have some of those impacts there, but bringing some of that forest edge into the PMA and the floodplain area as our replacement afforestation is actually an ecological enhancement. So I do agree that the way the design has been put together, at least conceptually, is a thoughtful ecological way to do it. And then bringing my point across, if you didn't develop and it laid here and it wasn't developed previously, you have a lot of just obvious nutrient load that's going into Tinkers Creek, which creates anaerobic conditions and additional sediment that we'd be taking care of with this development. So it's pushed back a little bit. The zoning affords more opportunity for forest and ecosystem services than the previous one. And through our design effort and moving forward, we have an opportunity to work with even the planting and the stormwater facilities to create that transient network of species and habitat that actually doesn't exist today because it's a different ecosystem in a stormwater facility than along the forest transitional edge. So those are kind of my thoughts on that.
You touched on the Subregion 5 master plan. You're familiar with some of the goals and policies from the environmental perspective from that master plan?
Yes, I am. I'm trying to get the actual language here, but I am familiar on what they generally look to preserve, as we mentioned, the green infrastructure network and reducing or paying attention to the sensitivity of some of these streams. I mentioned that there was a tier 2 component, as this is a watershed. We don't actually have a segment at watershed that goes to Piscataway. How do you treat that? How do you handle it when you develop? We take all those things into account on each one of our designs, and the basic plan image, the site plan, I guess it was 31, shows the amount of area that we're looking to preserve and retain closest to that watershed. So we work with that every day on trying to meet those preserve, protect, enhance, and understand the layers that are there with green infrastructure, understanding FIDs if it's possible to be there, protecting those areas.
I have no further questions.
Ms. Poto?
Yes, thank you. Good morning, I think, yes, just barely still the morning, Mr. Allison. Could you remind me your first name? I'm sorry, I missed that.
That's all right, Steve.
Steve, thank you. Okay, I have a few questions. First, I'd like to start by getting a better sense of what exactly is being proposed for preservation. So could you describe, please, how much of the woodland proposed for preservation or conservation, how much of that is outside of the PMA?
Here, if we can bring up 31, the sheet 31. What we have in the PMA is about 31 acres. Let's see here. So I don't know if I know, it's still conceptual. So giving a number outside the PMA right? We're still debating where we're putting some of the stormwater. I mean, it's a localized area, but it giving you a specific, there it is on the screen, giving you a specific number outside the PMA of what we're just not there yet. We will have some that's preserved in that area, but the design's not there yet.
So when the applicant
Hold
is,
on one second, I'm getting
yeah.
another thing, something, sorry about that.
oh, it's fine. So currently the proposal is to preserve 25.23 acres of woodland on site. Is that correct?
Correct.
And you don't know at this point where that would be?
Well, you're gonna have some of it towards the floodplain and the PMA areas that you're gonna take credit for it.
So the woodland that's within the existing floodplain PMA area is the same woodland that's proposed for preservation for the most
Yeah,
part.
you will retain that forest in that area, but you do not get credit in the floodplain. So our
Okay.
preservation area, right, to clarify, our preservation area would be outside of that floodplain area because you can't actually get credit for it. So we would meet that outside the specific location and the amount. We would meet what was being required, as I mentioned, where you have the 5 additional, it comes out to, I guess, 25.14 or whatever, but where it's location, we're going to try to do it centrally located towards the stream, but you don't actually get credit for the retainment that you have within that floodplain.
Okay, got it. And the floodplain is within the dotted yellow lines on this image?
Yeah, that's correct. It's down in that area. So we're not looking to impact any of those things. We have regulations through that area, but you just don't get credit for that.
Got it. Okay, and just to make sure I understand, the PMA includes the floodplain, but it can also include other areas. Is that correct?
You can have other things in that area that are going to
Okay.
pump it out. You're going to have like steep slopes and stuff that are going to kind of control your PMA.
Got it. And so the PMA with the dotted yellow line here, that includes a floodplain and it also includes some of the areas that are woodland preservation. Is that correct?
Yes.
Okay. And I recall you stating, and correct me if I'm misremembering, that
Mhm.
you did not view your job as comparing the proposed RPD zone to what would be possible under the RE zone, the base zone. Your job was to compare what's currently there versus the RPD zone. Is that accurate?
No, we look at the base zoning. We look at the existing features in the base zoning as well.
Okay,
And
so you
because
did do
that's,
that comparison.
yeah, to see, the percentage of the woodland conservation threshold, you have to understand that. And we did have that conversation with staff that I think we'd go from like 25% of what the RE zone of woodland conservation that you want to get on site. That's what they're asking. The RPD went down to 20%. So there was a difference there. And then we proffered a 5 acres additional on that. And then that was accepted.
And so under the base zone, or let me rephrase.
Mhm.
How much woodland is being proposed for conservation compared to how much would be required under the base zone?
I'm trying to understand your question. I think it would be, we are protecting essentially almost the same amount of what's being asked for the woodland conservation on site.
As what would be required under the base zone?
Yeah, the base zone is looking to have the woodland conservation threshold. Okay, that's the number. I think it was 25 and 25.23.
Mhm.
We are, with our proffer of that additional 5 acres, we would be at 20.19.
So 25.19?
Well, right, yes, you would hit 20.19 and then you'd have that 5 additional acres over that.
So the proposed woodland conservation public benefit is less woodland preserved than would be required under the base zone. Is that correct?
Not necessarily.
Could you explain to me how 25.19 is not less than 25.23 acres?
Well, because we will be having an increased amount above that we think in retain, it will be closer to like 31 acres of what we would have on site. Total. We're just saying what the zone was at 20.19 or additional public benefit of the 5, but then we have additional areas that we can work with.
But currently the proposal, the only thing that's being committed to is essentially 25.19 acres of preservation, is it not?
Yeah, that's what's listed right now. Yeah,
Okay.
before we design.
And again, the just to make sure I'm clear, the base zone requires 25.23 acres of woodland preservation, correct?
It does.
Okay, thank you. Another question I had was, you described certain improvements associated with stormwater management facilities and how that would enhance or address stormwater runoff that includes sediment and other nutrients like nitrogen.
Mhm.
Is it your testimony that those same requirements would not be applicable, those same improvements would not be required under the base zone?
No, you would have the same stormwater requirements, but it's if it's laid right now, just as a land use difference, okay? So currently, it's not being developed, except we're coming in and saying that. If you would say it, that it's no developers coming in, these are the things that are coming off the site that we can improve on.
Okay,
So, yeah, those are all your modern stormwater would be into effect.
got it. So the amount of stormwater treatment under the base zone would be effectively the same as what you're proposing currently, correct? Okay,
Yeah, it's basically when you develop the site, these are the things that get better. There's no difference in stormwater requirements as a state standard, not necessarily a zone standard.
okay, and when you increase the amount of vehicular traffic on a site and
Mhm.
increase the amount of impervious surfaces on a site and have a roadway over top of a tributary to Tinker's Creek,
Mhm.
would that not increase the likelihood of runoff into the stream that includes things like microplastics, oil, and other contaminants associated with vehicular traffic? Is that correct?
I mean, if you go ahead and put from what's existing today or anybody coming at any given time and putting a culvert across there.
From what's existing today.
Yeah, I would state that if you're going to put a culvert there, you have to avoid a bunch of things through state and federal requirements of that review of what you're putting there to stabilize that area and reduce pollution as much as possible that you come across. That is an intermittent stream, and the culvert does need to be upgraded as well. So right now, it's more of I guess it's a farm crossing through that area. And the improvement of sediment, just sediment as it's a farm use, would be a betterment of an actually established crossing that we'd have to put in there and get approved by Army Corps and MDE. So microplastics, those things, I'd say it's still having the same issue as it's crossed through mud right now than an actual paved surface. And sediment's one of the biggest concerns of what's getting down into Tinker's Creek.
And did you evaluate how much runoff would be associated with this proposed use compared to development under the RE zone?
No, I don't have what somebody would somehow put in there. I know that we have a more muted envelope of what we're doing, so I would assume it would be less, but I don't run those things based on somebody else's design and how they could come up with that in the future.
Okay, so just to make sure I'm clear about your testimony, the
Mhm.
proposed or the described benefits to the environment that you discussed, that's a benefit compared to no development, not a benefit compared to development under the RE zone. You didn't do that analysis, is that correct?
Not necessarily. I mean, we talked about the differences between RE to the RPD and having a more compacted development. That's going to be a betterment. Okay. That you're in not just theory, but you're going to have a smaller envelope, which is probably going to have smaller pervious and smaller overall impact, which is also affording you more opportunity for ecological and preservation enhancement and retainment. So no, I didn't look at it exactly as what are all possibilities, but innately you would have less impacts with an RPD than an RE just based on what's required in the zoning.
Okay, well, and just to make sure I understand the basis of that decision, did you look at what the footprint would have to be to accommodate 93 dwelling units under the RE zone?
I did not put an actual envelope footprint on there for that.
So you don't in fact know that the development footprint would be smaller under the RPD zone, correct? It's just that it could.
I did not take the basis of those two things and do a calculation off that. I run it based on the intent of the zoning.
Okay, got it. So the statement that the RPD zone would create a smaller development envelope, that's a generalized statement of what's possible. Is that correct?
It has an opportunity to be less innately in what the zone is.
Okay, but we don't know specifically for this property under the specific base zone that applies. What would have
In
been?
in my opinion, I think it's less based on what you can do there. It's less impacts with that. And that's my opinion of viewing it. I don't have an actual design layout to review that, but reviewing both those zones is my opinion, it's less.
Okay, got it. And I feel like I had one last question for you that I'm not remembering. Oh, the last question I had for the proposed culvert over the stream, for that stream crossing. Did
Yeah,
I
that
hear
intermittent
you?
streams. Go
I'm
ahead.
sorry, what was that?
The intermittent stream that's running right there.
Yes, sir, that one. Did I hear you correctly that there could be negative impacts associated with that, but there would be mitigation opportunity to address that? Is that correct?
Negative impact, potentially no, if it's the same linear feet, if it's an in-kind replacement, it'll all be reviewed by Army Corps and MDE. And so those impacts would be evaluated. And if there was anything that was deemed negative when you do it, you have to mitigate for it based on functional loss so you'd actually, anything that you would do, you would impair that if it was going to be an issue or repair that through that crossing.
But that review has not occurred yet, correct?
No, we're not at that stage, but it's not simply that you would go ahead and make that impact and whatever your impacts are just didn't meet any type of threshold for the Department of Environment or Army Corps. You would have to go through those process if it was deemed that you did a functional loss and replace that on that stream. So
It's true, is it not, that the mitigation could be a fee in lieu?
for stream mitigation, no,
Yeah.
I wouldn't do that. Yeah, I don't think so.
It's not legally allowed to do a fee in lieu?
I've never done that. I don't think so.
Okay, and do the mitigation techniques have to occur on this property, or would they be allowed on nearby properties?
There are times that you could buy it off-site for something like this type of crossing. I think the intention would be to keep it on site. Usually they try to do that.
But that's not required at this moment by the Prince George's County zoning ordinance or state regulation. It's possible it could be off-site, is that correct?
There's options. There's options that exist.
I think that's all I have. Thank you for your time, Mr. Allison.
Madam Examiner, I have one redirect, unless
Okay,
Mr. Brown has any.
No questions. Go ahead.
Mr. Allison, is stormwater management being offered as a public benefit in this case?
I don't believe so.
No further questions. We would call Mr. Mike Lenhart.
I had one question of him. See if I
Oh,
can
sorry,
get it out
Steve.
correctly.
Sorry.
So from an environmental standpoint, with your expertise, why will this be superior to developing under the RE? Because you have to assume there's less houses under the RE.
Well, Madam Examiner, I'm gonna object to that question because the standard of superiority or substantial development goes to the public benefits, not to the overall development under the required findings.
And I'm trying to get him to,
Well, I mean, I think that's.
I was trying to address that. What makes
Yeah.
it, because
Well, Ms.
one
Votaw,
finding-
Ms. Votaw is attempting to blur the lines with respect to comparative analyses, which is not a requirement. The requirement for substantial benefit, which presumably is the comparative analysis, goes to the public benefits, not to the overall development. And that's a line that's been blurred and crossed in some of the examination here today. Cross-examination, I should say.
would any public benefits be required under the current zoning?
No.
And so in exchange for a different type of more flexible, the county is getting public benefits?
Correct.
Thank you. You're finished, Mr. Tedesco?
I am, Madam Examiner.
Okay.
Mr.
You have
Lenhart,
another witness? Okay.
we got two more, Mr. Lenhart and Mr. Anderson, and then we will submit to Ms. Vota's case in chief.
We have Mr. Lenhart.
Yes, good morning.
You ready?
I am if you are.
No, okay.
Oh,
Mr.
no,
Lenhart, do you
today.
swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
Yes,
Mr. Lenhart, could you state your name and address for the record?
yes, Michael Lenhart, 231 Naholes Road, Suite 250, Millersville, Maryland, 21108.
And where are you employed and what is your title?
Lenhart Traffic Consulting. I am the president. I'm a traffic engineer, transportation planner.
And Madam Examiner, Mr. Lenhart's CV is marked as Exhibit 25 at page 11. He's been qualified as an expert in traffic engineering and planning by this administrative body. On numerous occasions, we would ask that he be accepted in that capacity here this morning or afternoon.
Any voir dire?
No, ma'am, no objections.
You haven't been rejected since I've seen you last, have you?
No, ma'am.
Okay, you'll be accepted as an expert in transportation planning and traffic engineer.
Thank you.
Did you make a personal inspection of the property?
I did.
And are you familiar with the areas surrounding the subject property, including the roads and roadway networks?
Yes, I am.
And are you familiar with the applicant's proposed application to rezone the subject property as envisioned in the development plan?
Yes.
And have you examined the applicant's basic plan?
Yes, I have.
And did you make an investigation of the traffic conditions and levels of service in the areas surrounding the property?
Yes, I did.
And are you familiar with the existing roadway network and the MPOT recommendations for the area?
Yes, I am.
Can you briefly explain the existing roadway network? And if you need to, we can provide Exhibit 19.
If you want to pull that up, it would be.
Sarah, Exhibit 19, if you would be so kind.
So this exhibit 19 reflects the Steed Road along the frontage of the property and beyond the frontage. If property is labeled as a Grove at Hyde Landing on this exhibit, Allentown Road is to the northwest off of the left side of the exhibit. Piscataway Road is Maryland 223, is located to the southeast off of the right side of this exhibit. Steed Road is a master planned collector road, C518 with a recommended right-of-way of 80 feet and 4 travel lanes with 2 in each direction. Steed Road is approximately 9,000 feet long. The existing conditions along Steed Road include a 4-lane section as you approach Allentown Road with 2 lanes in each direction. That exists for a distance of approximately 1,800 feet. Again, that is to the west of the site approaching Allentown Road. The other 7,200 feet of Steed Road is a 2-lane road section all the way down to Maryland 223 under existing conditions.
And did you make an investigation of the traffic conditions and do an analysis of whether the request of rezoning would impact the master plan roads differently than the current zoning?
Yes, we did. We looked at many components associated with the rezoning based on the requirements of the zoning ordinance and the transportation review guidelines, as well as in response to the community input and feedback.
And did the transportation planning staff do an analysis related to this application?
Yes, they did. The transportation planning staff reviewed the materials we provided. They also requested a CIP analysis, which we provided as a result of SDRC comments that looked at the entire road network and study intersections that would be required at the time of preliminary plan for the purpose of calculating the CIP required payments under the base condition.
And did the planning board adopt the findings of the technical staff related to section 273602C4 regarding the rezoning and its adverse impacts on the surrounding properties?
Yes, page 33 of the TSR acknowledges that the proposed development will not adversely affect the surrounding properties and results in a community that not only avoids impacting the surrounding community, but also provides public benefits and a wide range of methods, which includes substantial road improvements along Steed Road.
During your review and involvement of the application, have you attended community meetings and meetings with park and planning staff regarding traffic and the roads and circulation?
Yes.
And could you please summarize the issues and concerns that have been articulated, especially by the community stakeholders?
Yes. There were several areas of concern. Maryland 223, along the section basically from Hyde Landing up to the BK Miller intersection toward Branch Avenue. Currently a 2-lane roadway for the majority of that section. There's a general concern that 223 needs to be improved and enhanced along that area to improve capacity. There's also concerns that Steed Road needs to be improved. As mentioned, when I discussed the existing road network, Steed Road is called for in the master plan to be a 4-lane road, the entire section between 223 and Allentown. However, roughly 80% of Steed Road today is only a 2-lane roadway. And I'll talk more about that later. There's going to be substantial improvements to that, not only with this project, but also previously approved Hyde Landing project. Then the third component is the BK Miller intersection. It's Maryland 223 at Brandywine Road and Old Branch Avenue. It's commonly referred to as BK Miller intersection because the store on the corner there, that intersection for 30 years or more has had 0 road improvements, and is probably one of the worst operating intersections in the county. And there is a CIP improvement to improve that, and I'll discuss that later.
And you're familiar with the county and state project studies regarding the transportation network in this area?
Yes. The State Highway Administration had a project planning study back in 2015 for the Maryland 223 corridor. And that project planning study ran from Steed Road on 223, and it ran up 223 through Branch Avenue, all the way up to Route 4 on Route 223. And the state had come up with concept plans for road improvements along that entire corridor. That was finalized around the 2015 timeframe. And no funding, no recommendations, no improvement projects resulted from that. There are no other state projects in this area.
Thank you. Are there any adopted capital improvement projects in the area that include these and other intersections and links?
Yes, there are 2 county CIP projects.
Could you describe those, please?
Yes. CIP project 4.66.0052 is the Brandywine Road and Maryland 223 intersection. In the CIP, that is described as providing improvements at the intersection of Brandywine Road, Old Branch, Piscataway, and Woodyard Road to include, but not limited to, geometric and safety improvements. It is listed as a combined public-private partnership with funds coming from the county and from development, private developments as approved, either through developer participation agreements or resolutions with the county park and planning at the time of preliminary plan. That involves widening Route 223 and improving the traffic signal to reduce and eliminate the congestion at that location. The other CIP project is CIP 4.66.0050. It's known as the South County Roadway Improvements.
This project provides for intersection improvements at a variety of intersections throughout this South County area, including 223 at Steed, Steed at Allentown, Allentown at Old Fort, 223 at Temple Hill, 223 at Tippett. And that project is listed as 100% developer funding with either through developer participation agreement or through a direct resolution at the time of preliminary plan. That again is a fully developer funded project. There is no public money. There are no public improvements planned out here other than what would be obtained through development approvals.
Is adequacy a required finding at this stage?
No, it is not.
And although adequacy is not a factor at this stage of the entitlement rezoning process, from an adequacy perspective, what would the applicant's responsibility be to satisfy adequacy vis-a-vis the capital improvement projects?
A pro rata contribution would be applied to each of the CIP projects based upon the applicant's impact to each of the CIPs. That would be established at the time of preliminary plan of subdivision through the certificate of adequacy. The CIPs require payment into the CIP, and that would satisfy the adequacy requirements itself through the payment.
And instead of this pro rata contribution, is the applicant as a public benefit proposing any actual improvements?
Yes, they are. We submitted the CIP study for the entire area to determine what the applicant's CIP fee would be at the time of preliminary plan. It would be roughly $800,000. And then we identified improvements that would be above and beyond that, including widening of the bridge and widening of Steed Road to create additional through lanes off the property frontage. Those improvements are about 1.8 million. Therefore, the public benefit would be about $1 million above and beyond what would be required. Additionally, the BK Miller intersection, the Brandywine Road and 223 CIP project, it's anticipated that at the time of preliminary plan, there'll be a condition where the $583,000 that is anticipated as a CIP toward that project would be paid as a lump sum at the time of the first building permit. Typically, that would be paid on a per building permit basis as the project builds out. There's a desire to get that improvement fully funded, and therefore a lump sum upfront payment results in a time value of money benefit in providing that all at once.
Let's spend some time discussing the proposed road improvements should this application be approved, because I understand your testimony is that those improvements would not otherwise be required under a base redevelopment. Is that correct?
That's correct.
So looking at Exhibit 19, I know there's multiple sheets, so Exhibit 19, could you just walk the examiner through these additional road improvements as public benefits that exceed the base zone requirement?
Yes. If you can go to the sheets and views and see if you can.
If you could go to the next
There you
sheet.
go.
Yeah, go to the next sheets if you could, Sarah.
There we go. So this is Steed Road to the west or northwest of our property frontage. To the left side of this exhibit is where the improvement ties into Steed Road, where it's already fully improved. And that point at the west or at the left side of the sheet is about 1,800 feet from Allentown Road. And again, that's fully improved up to that point. we would construct an additional through lane along southbound. In this case, it's left to right. Second through lane heading towards Route 223. And if you can go to the next sheet. That second through lane continues across the bridge at Tinkers Creek. The bridge itself, the frontage improvement, a typical frontage improvement would be 43 feet. The existing bridge is 36 feet wide. Frontage improvement typical would be 43 feet for our half of a collector road. We are proposing to widen that bridge to a total distance of 59 feet. That would include enough room for 2 through lanes in each direction. We propose to build the through lane that is heading, in this case, I'll call it eastbound on this sheet of paper. We are not proposing to build the westbound second lane at this point. That could be built in the future by others, but we are building the bridge structure that would accommodate that improvement. And then along the frontage would be doing, bike lanes, additional through lane, turn lanes. And if you go to the next sheet, through the site frontage, past Ethan Thomas, again, turn lanes at the site, a second through lane continuing eastbound, and then you see Hyde Landing labeled at the right side of this exhibit. Hyde Landing frontage picks up at that part and continues easterly toward Route 223. Hyde Landing will be constructing the second through lane along that entire distance. And therefore, as a result of the approval of this application, we would be able to construct a second through lane along Steed Road and the entire distance from Allentown Road to Route 223.
And could you speak to the genesis or the basis for this particular public benefit and what it was in response to?
We had many public meetings with the community, with work group and task force set up to discuss the community's concerns. And one of the key topics that kept coming up was Steed Road and the concern that Steed Road today is mostly just a 2-lane roadway. And so we made a commitment to the community that we would work to improve that, to put our public benefits to work, to try to improve that situation to the best of our ability. Again, today about 80% of the road is a 2-lane road. 100% of the eastbound direction would be a half section of a collector road with the approval of this project. And most of westbound would be a half a collector section with the improvements by Hyde Landing and the existing section approaching Allentown Road.
And do you know if those improvements associated with the Hyde Landing were accepted and approved by the county as public benefits?
They were.
And do you know if the planning board's recommendation conditioned these improvements as public benefits to be implemented?
They did, yes.
And Madam Examiner, just for your edification, Exhibit 43 is an exhibit from the Hyde Landing that shows those improvements and how this whole entire infrastructure system would improve upon the approval of this application and development of these 2 projects. Mr. Lenhart, regarding the bike lane improvements, I believe you said there'd be bike lanes as part of the frontage improvements associated with both Hyde and the Grove. Is that correct?
That's correct.
If this application is approved, does the RPD zone require a bike ped impact study?
It does not. Section 244506B3 identifies various zones that require the BPIS evaluation and the adequacy determinations. Those zones do not include RPD. It's really a various mix of higher density residential zones or mixed use and commercial zones.
Notwithstanding that, though, are bike lanes proposed?
Yes, they are.
And based upon, strike that. During the review of Hyde Landing application and the significant outreach that you testified to with the local community, did there come a time that you were asked by the county to further analyze the community's desire to see Steed Road widen beyond the proposed frontage improvements?
Yes.
And based upon that supplemental analysis, what findings or conclusions did you reach?
Yeah, this gets back to the CIP analysis that we submitted as a result of Park and Planning's SDRC comments, and that established what our base requirements would be. And then we came up with, based on citizen feedback, the improvements that were to be provided along Steed Road beyond the site frontage, as previously testified, and the widening of the bridge, which result in substantial public benefit over and above the adequacy requirements that are anticipated.
And would development under the RE base zone require public benefits?
No.
And from the perspective of traffic engineering and planning, will granting the requested rezoning application be consistent with the standards enumerated in the ordinance?
Yes, it will. Based on my opinion, testimony provided today and the various reports and exhibits, the rezoning of this application will provide significant public benefits, and the rezoning is consistent with the requirement of the zoning ordinance.
And from the perspective of traffic engineering and planning, and given the significant additional public benefits proffered with this application, is it your expert opinion that the approval of the application will not cause any adverse effects upon adjacent properties or the surrounding neighborhood?
No, it will not. But we did, the CIP analysis that we conducted shows that the traffic that would be generated by this application is minimal in relation to the overall traffic on the road network. And the RE zone does allow for up to 93 units, so that in of itself would generate some traffic. This approval of this ZMA would not result in a substantial increase in the overall traffic on the road network.
That's all the questions I have, Madam Examiner.
Thank you. Ms. Votaw?
Yes, ma'am. Thank you. Good afternoon at this point, Mr. Lenhart. I have a few questions for you. So I'll start with what you most recently said. You said the traffic generated by the proposal would not have a substantial increase in traffic. Is that correct?
In the overall traffic on the road network, yes.
Okay. Will the traffic generated by this proposal have any adverse impact on the traffic situation on Steed Road?
No, it will not, particularly with the frontage improvements and the public benefits that are provided. There will be substantial improvements provided along Steed Road that can not only handle this traffic, but improve the situation for existing traffic.
And how many vehicular trips will be generated by the proposed development, assuming there's 300 dwelling units as proposed?
It will be 218 morning peak hour trips, and 255 evening peak hour trips. That's total by the 300 units. That's not a net increase based on this application.
And when you were evaluating the traffic conditions, did you take into consideration the amount of additional traffic generated by the Hyde proposal?
Yes, we included all approved but unbuilt background developments in the traffic study.
Okay. And I just lost my train of thought, so bear with me for a moment if you may, if you might. Oh, okay. Are you aware currently that when traffic is bad on Steve Road, the vehicular traffic backs up past the bridge?
I'm aware that there are backups, and that is largely due to the fact that it is a one-lane road today. It is also largely due to the fact that the intersection of 223 at Steed Road is woefully underdesigned. Steed Road is a one-lane approach at Route 223. There is a shoulder that is existing, but it's in poor condition and it's not supposed to be utilized for turning movements. Therefore, Steed Road at 223 is a one-lane approach. Hyde Landing is going to widen that out to a 5-lane section. There'll be 3 lanes approaching 223 and 2 lanes heading away from 223 on Steed Road. But Route 223 is also going to be widened to from an existing 1 lane in each direction to 2 lanes in each direction. It's going to create substantial capacity improvements at that intersection, not only on 223, but also on Steed, and that will resolve the existing queuing conditions.
Understood. And so currently the applicant is proposing still to use the CIP contributions to pay for some of the road improvements. Is that correct?
I'm sorry, could you repeat that, please?
Yeah. So currently the applicant is still proposing to pay for some of the road improvements from what would otherwise have been the CIP contributions. In other words, they're doing the improvements in lieu of a CIP contribution. Is that correct?
That's correct. And they're doing much more than what their contribution would have otherwise been.
So, were you present for Mr. Donahue's testimony?
Yes.
Do you recall him stating that the planning board conditioned their approval on the CIP contribution not being used to pay for the road improvements?
Could you elaborate? I don't remember exactly that statement.
I guess I'm trying to clarify. The planning board did not impose a condition prohibiting the improvements in lieu of the CIP contribution. Is that correct?
Let me look at exactly what the condition said, just so I'm clearly don't misstate.
Thank you.
I have it on my laptop. Hyde.
That does.
If you're referring to the TS, you're referring to the TSR for this project, right? The condition.
I was referring to the planning board resolution.
Yeah. Okay. Yeah, condition 2. Condition 2D requires widening the bridge to a width of 59 feet, as I testified, and then condition 2E requires widening Steed Road 1,500 linear feet beyond the site's frontage to the northwest.
And as currently written, that would still allow the applicant to fund those projects from what would otherwise be the CIP contribution. Is that correct?
Yes.
Okay. And are
portion.
you, yeah, a portion. And are you familiar with staff's finding that frontage improvements together with any CIP payments necessary would be a base requirement? Are you familiar with that finding of staff?
Staff stated that the frontage improvements would be the base requirement. And then we provided things that went above and beyond the base requirement. And that is what the public benefit was established to be.
And I'm asking a more narrow question. Again, are you familiar with staff stated, quote, all frontage improvements and transportation improvements for public benefits should not be funded by the CIP? That's on page 22 of the staff report. Are you familiar with that finding?
I am. I just want to look at it to make sure I'm reading the exact same thing. Are you talking about from the staff report or from the resolution?
Yeah, sorry, from the staff report, page 22, it's the last there's gonna be a lot of directions. The last sentence of the 2 paragraphs up from bullet point 5. The sentence reads, quote, therefore, all frontage improvements and transportation improvements for public benefits should not be funded by the CIP.
Bear with me. I'm just
Yeah.
looking for that exact language. That on page 22?
Yes, sir. The beginning of the paragraph that sentence is in starts with the applicant has put forth information regarding
Okay.
using, yeah. And it's the last sentence of that paragraph.
I don't see that sentence as the last paragraph.
The last sentence in that paragraph.
Yeah, this says the applicant projects that payment into both CIPs would be a base requirement for the subject property based on the traffic analysis provided.
In the staff report?
Yeah.
That's not what my copy says. I was trying to find a front page so I can make sure talking about the same stuff.
To be clear, though, we are not using any of the frontage improvements as public benefit, and we're not using the CIP improvements to pay for any of the public, the public benefits. I'm sorry. We are not using the CIP payment to pay for any of the frontage improvements.
But you are using, the proposal is to use the CIP contributions for the additional improvements along Steed Road between the subject property and the bridge.
A portion of it for the
Yeah.
offsite 1,500 feet and for a portion of the bridge that
Mhm.
is above and beyond our standard frontage improvement.
Got it. Okay. Another question I had, you said you're familiar with the traffic patterns in the area. Is that correct?
Yes.
Are you familiar with the fact that traffic backs up from the Mount Enon Church during and after services, before and after services?
Yes, I am aware of that. I've heard that in the meetings we've had with the citizen group and the task force.
And you accounted for that in all of your traffic studies and projections?
The church is included in our traffic studies. The traffic studies are based upon weekday, peak hour, morning and evening commuter traffic. That is standard and typical, and what is normally required.
And so your evaluation did not therefore consider the traffic generated on the weekends by that use.
Well, we do not do weekend studies. If this were an application for a church, we would do Sunday midday traffic analysis. This is not an application for a church. The standard is that you do morning and evening weekday peak hour analysis. And the church, whatever the operations are of the church today during morning and evening peak hours, is included in our analysis. But we're not required to study Sundays.
So your testimony, when you say there's no adverse impact caused by this proposed development on the nearby roads, you're not including an evaluation of whether there would be any adverse traffic impacts during the time that is just before and just after the church services. Is that correct?
We did not study that peak period.
Got it. Thank you. I think that is all I have for this witness. Thank you for your time, Mr. Lenhart.
Thank you.
Mr. Brown?
Mr. Lenhart, you and I have had 3 hearings this week, Monday, Tuesday, Wednesday. I'm sort of sick of seeing you,
Yeah, I'm so sorry. You have to look at me again.
but I won't ask you another question. Thank you.
Thank you.
Madam Examiner, just to and redirect, Mr. Lenhart, Ms. Votaw asked you about church hours and studying that. Is it your opinion, however, that with the public benefits that are being implemented, both with the Hyde development project that's already approved and conditioned, as well as the proffered public benefits through actual implementation of roadway improvements, that the transportation network in this area, whether it be on Monday or Sunday, will be improved?
Yes, absolutely.
Objection. He just stated he didn't review or do a study on the weekend.
I asked him his opinion.
And I believe his opinion has to be based on his studies and what he actually evaluated.
And his experience and knowledge.
And, well, wait a minute, before I rule, Mr. Lenhart, do you have any knowledge of that area on the weekends or during Sunday services?
Well, I have anecdotal knowledge from meetings with the citizens and our regular meetings that we've had with them. But the fact is, Hyde Landing is making substantial improvements at the intersection of 223 and Steed. Substantial improvements, and that will improve operations on a Sunday, whether I don't have to study it to say that it's going to almost double the capacity of that intersection. And this property, if approved, is going to make substantial improvements along Steed Road that would essentially fulfill the link, the master plan link along the entire southeast direction from Allentown to Steed. To 223, sorry. And so those improvements, yes, will dramatically improve the road network.
So I'll overrule now that he gave more factual support for his opinion.
Thank you.
And one final question, Ms. Votaw asked you about the technical staff report. However, you know the difference between the technical staff report and the actual planning board resolution.
Yeah.
And so if I could just direct you to page 18 of the planning board's resolution, if you could just read the findings of the actual planning board with respect to the questions that Ms. Votaw was asking regarding the staff report, which we couldn't find that language, but could you just read the actual finding?
Sure. So I'll paraphrase out of it here. The cost to widen the existing Steed Road Bridge and widen Steed Road between the property frontage and the existing second eastbound lane is estimated at $1.8 million. However, and then it goes on to say that the estimated CIP payment would be $791,000. And then it goes on to say, in lieu of payment to the South County CIP, the applicant is proposing to provide the physical road improvements outlined as public benefits above, which exceed the estimated pro rata contribution by $1,008,000. And the applicant proposes implementation of these improvements to be immediate and tangible and above the base requirement.
Thank you. No further questions.
Okay, it's 1 o'clock. How many more witnesses?
I have just one more.
Okay, we'll finish his witnesses and take a break. Okay, thanks.
Thank you. Thank you. Mr. Anderson.
Mr. Anderson,
Yes, ma'am.
do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
I do.
Mr. Anderson, could you please state your name and address for the record?
Casey Anderson. I live at 8730 First Avenue in Silver Spring.
And where are you currently employed?
Rogers Consulting.
And what is your position?
My title is Market Leader.
And examiner, we are going to be offering Mr. Anderson as an expert in land use planning and zoning. And his CV is marked as Exhibit 38, and he has not previously qualified, so I have some qualifying questions if you would allow me. Mr. Anderson, could you please describe your educational background?
I have an undergraduate degree in international relations from Georgetown. I have a master's degree in journalism from Columbia, and I have a law degree from Georgetown.
And do you have any graduate or specialized education related to planning or public policy and land use?
No.
Could you describe your professional experience in land use planning and zoning?
I've spent about 15 years in land use and transportation related issues, especially in Montgomery County, as well as Prince George's, and to a lesser extent, other parts of the DC region.
How long have you worked in the field of planning and land use?
About 15 years.
And have you held any leadership roles in planning agencies?
Yes, I was the chair of the Montgomery County Planning Board for about 8 years. I was on the Montgomery County Planning Board as a commissioner for another 3 years. During the time when I was chair of the Montgomery County Planning Board, I chaired the Maryland National Capital Park and Planning Commission, the bi-county agency that oversees land use, transportation, as well as parks administration in Prince George's and in Montgomery County.
And how many development strike that. What were your responsibilities as chair of the Montgomery County Planning Board and as chair of the bi-county Planning Board agency?
I oversaw, supervised the planning department and parks department in Montgomery County. That included participating in the oversight and review of development applications, master plans, and similar regulatory activities of the Montgomery Planning Department. I was also responsible for administration, management of the Montgomery Parks system and administrative aspects of the bi-county commission.
And approximately how many development applications have you reviewed and or adjudicated in your career?
Way too many to count.
And
thousands.
Are you familiar with the zoning map amendments, master plans, plan development zones, et cetera?
I am.
And have you previously testified before planning boards and or district councils?
Yes.
Approximately how many times?
I couldn't put a number on it, but it's certainly in the dozens.
And you've specifically testified before Prince George's County Planning Board and district councils?
Yes.
And have you published or spoken on any planning, zoning, or housing issues?
Yes, many times.
And that's provided in your CV, those examples?
I've provided some representative examples. I would not say that they're exhaustive, but I think they would give you a flavor of the types of topics I've written and spoken on.
And have you received any professional recognition in the field of planning and zoning?
I received an award from the Coalition for Smart Growth, the Livable Communities Award that's given every year to a leader in land use and real estate in the Washington region. in 2017. In 2022, I received an award from NAOP for planning leadership.
And have you previously sat for the AICP test?
Yes,
And what was the outcome of that examination?
I passed.
And what type of work do you currently perform for clients?
I typically advise on land use, transportation, regulation, and policy, and related issues, sometimes things related to parks or recreational aspects of development applications, sometimes a more general look at how development applications can be drafted and get support from the government and through the land use regulation process.
And do you assist with land use and planning strategies and implementation policies?
Yes.
Madam Examiner, based upon Mr. Anderson's extensive experience in this field, we would offer him up as an expert in the field of land use planning.
Mr. Brown?
I have reviewed his resume and he seems to be qualified based upon his experience, so no objection.
Ms. Vota?
Yeah, again, if I could just get a proffer on what his testimony will be about based on the questions, I'm worried that the testimony will be offering legal analysis, which is squarely within the jurisdiction of the zoning hearing examiner, would not be appropriate to have a witness describe how the hearing examiner should interpret the law. So to the extent that that's the scope of his testimony, I do have an objection.
You wouldn't, I mean, you
I don't know.
understand her objection?
I don't know if that's a question or just to say, I mean, Mr. Anderson is not being offered to provide any legal analysis. That's your job.
Okay, great. As long as that's the case, then I have no objection.
What is the future of Prince George's County?
Well, you
Never,
you
never
should-
mind.
you
I
should
just
come to my
tried, just checking.
presentation, and then we can, yeah.
Okay, you will be admitted as an expert in land use planning.
Thank you. Mr. Anderson, based on your education, experience, and expertise, do you have an opinion as to, excuse me, strike that, sorry. What materials did you review in this particular application case?
I read the statement of justification, which is, I think, Exhibit 17, the public benefit features memorandum at Exhibit 20, the public benefit exhibit at Exhibit 16, planning board staff report, which is Exhibits 23 and 24, the resolution from the planning board, that's number 2024-123 at Exhibit 27, the traffic consulting report that Mr. Leonard prepared that was just discussed, and the 2013 approved subregion 5 master plan and Plan Prince George's 2035.
And did you make a personal inspection of the property?
I did.
And when did you do that?
I was there yesterday, and I should add that because I am a mountain bike enthusiast, I'm often in the area to mountain bike at Costco Regional Park, which is just, well, it's in the neighborhood.
Yeah, could you describe, actually strike that. What is the, do you know the current zoning of the property?
I believe it's classified as RE.
And you know what zoning is being requested here today?
Yes, RPD zoning.
And you know the type of development that's being proposed?
Yes, my understanding it's up to 300 residential units, including a mix of single family detached and single family attached. That would be townhouses.
In developing the basic plan and the land plan for this application, ultimately the future redevelopment of the property, what were the design themes or objectives that you recommended?
Well, I believe that this plan attempts to organize the site into development plans, development pods that will concentrate development in the existing non-forested grazing field portions of this property, while preserving to the maximum extent possible the Tinkers Creek corridor, its tributaries, and the forest resources that are related to it in permanent open space and Stream Valley parkland. Development is concentrated on less than half the property, with most of the property reserved for recreation, preservation, and stream valley restoration. I think that's shown on Exhibit 31.
And from land use and planning perspective, could you explain the basis and the reasoning for seeking this application to rezone the property from RE to RPD?
Well, the RE zone includes minimum lot sizes of 40,000 square feet without any mechanism that would force development to be clustered away from environmentally sensitive areas. Under the RE zoning, an applicant could distribute development that would be probably single-family houses across the entire site. And I think Exhibit 31 is illuminating on this point, because you can see that there's about 44 acres total among these 3 development pods that are labeled A, B, and C. So just to do the rough math, if the maximum yield permitted under the RE zone would be just a touch over 90 units, some at 92, 93 units, something like that, less than 100, more than 90, you can imagine what that might look like. You would have to spread that development over something approaching 90 acres of land. So there would be legal as well as physical constraints, environmental constraints on using the entire property. But once you back out the 26 or so acres that are in the floodplain or otherwise legally protected for other reasons, you'd be left with something in the neighborhood of 100 acres to spread that 90 some units across. So you'd be looking at in the neighborhood of 90 units spread over about 90 plus acres. This development application, even though it provides the potential for up to 300 units, which is 3 times as much density, it consolidates that development into a land area of approximately 44 acres. So something like less than half the development footprint that would be involved if this property were developed to its maximum yield under the base zone. So I think that's just by way of perspective, without getting technical on the different categories of environmental constraints or features that might be protected under this plan. The big picture here is that you are limiting the impact of the development by placing it in a very compact form that prevents the environmental and other consequences of more spread out development, and also leave room for more recreational amenities, open space, as well as improved environmental results.
And would you say that is an adverse impact or a non-adverse impact?
I'd say that's beneficial.
And are you familiar with Plan 2035 and 2013 approved Subregion 5 Master Plan Sectional Map Amendment?
Yes.
As well as the policies contained therein?
Yes, I am.
And could you just highlight or outline some of those applicable policies?
Well, Plan 2035 puts the property in 2 different growth policy areas. Part is in the area identified as future water and sewer service area. Southeast part of the property is called, quote unquote, established community category. Staff had determined, the planning staff, that in terms of future land use, the proposal is most closely aligned with residential low and parks and open space designation. Residential low would imply densities up to 3.5 dwelling units per acre. Parks and open space contemplates publicly or privately owned open space and recreation areas. And I think this project satisfies both those, the purposes of both those categories. The specific Plan 2035 policies that I think are advanced by this application would be Policy 3, the growth policy map, the residential low designation at just under 3 dwelling units an acre is squarely within the contemplated range, and the stream valley dedication implements the park and open space designation. Policy 4, to phase development to coincide with public facilities. This project is subject to APFO and adequacy requirements at the preliminary plan stage. And Policy 8, strengthen established communities, which calls for this application calls for transforming an underutilized agricultural property into a planned residential community with parks, trails, sidewalks, stream valley preservation, as well as the transportation improvements that were discussed a few minutes ago that will benefit both the residents of this project as well as the surrounding area.
And did you prepare a land planning report for this application?
I did.
And that was exhibit 41?
Yes.
And could you just take us through your analysis and provide us with your expert opinion as to whether the applicant's proposed plan satisfies the criteria of section 27-3602?
Yeah, and I should point out, by the way, maybe we could do it in conjunction with this question, but the Subregion 5 master plan has some relevant policies which are also advanced. Maybe I could cover it in the context of the question you just.
Well, the first criteria is
four decision standards. First, conformance to the general plan as well as the applicable master plan. I've just testified how I believe that the proposed development is consistent with Plan 2035. And as far as the Subregion 5 master plan is concerned, the density just under 3 units an acre is within the residential low range described in that plan of up to 3.5 dwelling units an acre. Also, I would add the Subregion 5 master plan discusses the desirability of consolidating development and in a way that supports transit, not just the sort of high investment transit that we often think about like light rail and bus rapid transit, but also plain old bus service and the multimodal features. Are we out? We're good. The multimodal features of this plan, including the bike and pedestrian facilities, as well as the compact form of this development, facilitate serving this project with bus service along Steed Road. So I think that one thing that is not been discussed in the testimony to this point is the fact that the area master plan does not contemplate a spread out form of development, but rather attempts to achieve a land use mix that will serve a different transportation scheme in the future. So that's the general plan and the master plan. The purposes of the RPD zone are concerned, the RPD zone is designed to allow clustering, dimensional flexibility, open space integration in ways that conventional base zoning can't achieve. This application uses all those tools for their intended purpose, namely by clustering development in the grazing fields, using dimensional flexibility to reduce the development footprint, which I was just talking about a minute ago, integrating the preserved stream valley into the open space network, and also producing public benefits of stream valley dedication, trail construction, and the road that would not have be available or certainly not required under RE zoning. The third decision standard is that the application has to meet the standards, the relevant standards of the RPD zone specifically. The basic plan establishes the dimensional and development standards for the RPD zone, including the maximum of 300 dwelling units, a mix of single family detached and attached units, internal street networks, preservation of environmentally sensitive areas, and the open space and recreational amenity program. The density, lot standards, and woodland conservation requirements are all addressed on the face of the basic plan. The woodland conservation requirement can be met on site, and the applicant is offering approximately 5 additional acres above the RP threshold, which I think has been discussed by some previous witnesses as well. The fourth decision criteria is that you must find that this project will not adversely affect surrounding properties. I conclude that the proposed development is compatible with the surrounding land uses for 3 basic reasons. First, the density of just under 3 dwelling units an acre is consistent with the master plan's residential low
Is he frozen? Or am I frozen? I don't hear anything.
No, we
Okay.
can't hear him.
You can?
No, we cannot.
Oh, okay.
Can you hear me?
Yes.
Okay. We're having some technical.
Oh, are we back?
Give us 1 second. What? How about now? Can you hear me? Can you hear us now? Can you hear us now? Can you hear us now?
You're echoing.
How about now?
Yes.
Yep, that's
Okay.
good.
All right,
Okay.
sorry, we lost the feed, so I apologize.
Okay, I don't know where we lost you, so I might just start on this adverse effect decision standard, if that's.
Yeah, that's where you left off, C4.
Okay, very good. So as I was saying, I conclude that the development is compatible with surrounding land for 3 reasons. The first I just started discussing was that the density is within the master plan requirement. And moreover, if you go to the site, this is evident even on some of the exhibits like Exhibit 31, you can see that residential development right up against Steed Road, right across the street from the property. If you look at what's going on around the property in other directions, it's surrounded by parcels that are either about to be developed, like Hyde Landing on one side, and I think there's another project on the other side of the property, parkland, or existing development on north of Steed Road. So I would conclude that this development, visually speaking, is not going to have much, if any, impact in terms of changing the land use mix or the physical appearance from the surrounding properties in any material way. In fact, most of the development is set well back in the road and will be screened by some vegetation, which is more than what is more than the screening. The development on the other side of the street is much more visible and lacks that kind of screening and is closer to the road. Secondly, development preserves the environmental buffers along the stream valley and forested areas, which reinforces that natural separation between the residential pods and the adjacent properties. And third, as Mr. Leonard has discussed, the transportation impacts of the development are addressed through the road and sidewalk improvements and bike lane improvements that are being proffered in order to mitigate and improve on existing traffic conditions and improve mobility, not just for people who live on this site, but for people in the surrounding area. So for those 3 reasons, I conclude this project is not going to have any adverse impact on the surrounding residents or neighborhood.
And are you familiar with the general purposes of the planned development zone?
Yes.
And could you explain how this application meets those general purposes, or did you address that in your land planning report?
I did. I can go through that briefly. If you'd
Very
like.
briefly.
First, it's designed to reduce inflexibility of the existing base zones. As I've testified, the RE zones, 40,000 square foot minimum lot size and rigid dimensional standards would prevent the clustering necessary to protect Tinker's Creek and to minimize the impact on the natural environment and provide as much space as possible for recreation and open space. The RPD removes the inflexibility and allows the density to be organized around the site's environmental features rather than them. Secondly, the form and design purposes of the which is a direct response to the physical character. Multimodal circulation is improved because the plan is a side path along master plan trail, internal pedestrian connections, and linkage to the Hyde Landing trail network, which would allow residents to reach some of the commercial development in the community center on the Hyde Landing. Protects natural features on the site because the residential pods are expressly cited in the non-forested previously undisturbed parts of the property. So the only intrusions into sensitive areas are for the very limited crossings, utilities and trail connection with replanting to ensure that there's no net loss of forest. There is integration of open space and civic space because the preserved Valley Trail Network and internal open space areas are designed as an interconnected system rather than isolated features. There are design amenities, including interpretive signage, addressing water quality and stream buffer function, pocket parks, and pedestrian connections. The third purpose, to facilitate a mix of uses and housing types, the plan proposes a mix of single-family detached and attached units, which contributes to housing diversity in a sub-region where single-family detached units are the dominant, although not the exclusive type.
We lost him again.
Yeah, I hate to do this to you, but it might be better for us to take our 30-minute break right now, get that situation fixed and finish him and then start with Ms. Vota. You're muted.
It's going to echo. You didn't hear him?
Went out a lot. And right now I don't hear him at all. I mean, just before I spoke. I don't see him.
Hang on.
Okay. Where did you lose me? Where should I pick up?
I think you were saying the third purpose, but I'm not.
Yeah, the mix of uses and housing types.
Yes.
Yeah. So one of the purposes of the RPD zones, the third purpose is to encourage a mix of uses and housing types, which this application does because it proposes a mix of single family detached and attached units. I'm getting a little echo here. I don't know if you're.
Yeah, you guys got two microphones in the same room. You need
we know.
one of the microphones off.
We got it.
Okay. So you get the idea. There's a mix of townhouses and single family homes, which serves purpose 3, encouraging a mix of uses and housing types. The fourth purpose, efficient use of land, is served because as I've testified previously, concentrating development in the grazing fields and dedicating the Stream Valley corridor produces a more efficient and environmentally appropriate land use than large lot development under the RE zone would have produced across the full tract. Fifth, It respects neighborhood character because the proposed density housing types are consistent with the surrounding residential low context and the master plan vision for the area. And for the reasons I was talking about a minute ago, that it's mostly set back from the street and does not confront any incompatible land use, and will have very limited visibility from neighboring properties because the residential uses are concentrated in these pods and surrounded by trees. The sixth purpose, improving communities, services and facilities, is served by the addition of the trail, the Steed Road improvements, the stream valley dedication, and the interpretive signage program. All of those enhance community services and infrastructure for both new and existing residents. And seventh, respect for the natural features. The entire land plan is organized around the Tinkers Creek Stream Valley system and uses that as basically the foundation of the land plan. So I think that covers the purposes of the RPD zone.
And I've only got a few questions, Madam Examiner. I know you want to break. If you could just indulge me, I've got maybe 3 or 4 questions left. As an expert land use planner, is the proposed zoning and uses the density proposed in the basic plan for the subject property appropriate in the context of Plan 2035 and the development in the surrounding neighborhood, in your opinion?
I believe that it is.
And turning to the public benefits, if this application is approved, in your expert opinion, will this project provide benefits to the surrounding neighborhood or the public in general that substantially improve upon the base zone?
I believe so. And while I'm at it, I'll just say I agree with the commentary that was offered by Mr. Leonard and by Mr. Allison and Ms. Gillette on those points as well. And I would incorporate what I said in the expert report by reference, just so we have that on the record.
And do you agree with the planning board's findings regarding the basic plan's conformance to the other applicable Part 27-6 development standards?
Yes, I think I might go a little further than the planning board did, but I agree with their conclusion.
In your expert opinion, would approval of the requested rezoning be in accordance with the principles and guidelines of Plan 2035 and the Subregion 5 Master Plan?
Yes.
And would the approval of the application encourage a coordinated, harmonious, and systematic development of the area and the county as a whole?
Yes.
Could you explain why?
Why it?
Systematic development of the area and the county as a whole.
Yeah, for the reasons that I've been discussing it over the last few minutes, I think that this plan does a nice job of minimizing environmental impact, providing badly needed additional housing, integrating with the existing community, and not just respecting it, but also tying into the planned Hyde Field development. And so for all those reasons, I think, and supporting the future land use transportation scheme that's called for in the area plan. And so for all those reasons, I think the answer to that question is yes.
I have no further questions.
Ms. Votak.
Thank you. And I'll try to keep this brief. And thank you for your time, Mr. Anderson. I again apologize. I forgot. I missed your first name. What was your first name again?
Casey, like Casey at bat.
Got it. Thank you. First, I'd like to talk about density. So you said that the current area where the essentially the development envelope is limited to 44 acres. Is that correct?
Roughly, yes.
And so what is the density of the units within that 44 acres?
Well, it's 300 divided by 44.
So according to my calculations, 6.81 dwelling units per acre. Is that correct?
Well, I think the denominator you're using is not appropriate. The relevant question is how many units across the developable part of the site. You've already subtracted 26 acres that's in the floodplain roughly. So what you're left with is a developable, in principle, a developable area of about 100 acres. And so by that calculation, you're looking at roughly just under three units an acre.
Well, when we're talking about anticipated density in the master plan, that's not just a consideration of the spacing across an entire site. It's also the type of units and the amount of density in any given area. Is it not?
That's not how density is calculated under the zoning code.
Well, that's not my question. I'm talking about when we're thinking about master plan recommendations for context sensitive, low residential uses, low density residential uses. That consideration is not limited to just the traditional calculation of density, is it?
I'm not sure. I don't understand the question.
Let me back up. When the master plan is recommending low density housing options,
Yeah.
would the master plan not ordinarily be anticipating, for example, single family homes?
Well, not necessarily. I mean, the master plan just says this is basically low residential, which is a defined term in the plan. It says it's anything under 3.5 units an acre, and that's this.
And when the master plan was created, did the RPD zone exist?
No, there was a zoning code rewrite in the intervening period where those zones were translated. Not, I mean, they don't. It's hard to make a direct apples to apples comparison, but the attempt, as I understand it, was to try to translate those zones as closely as possible to the what was called for under the previous master plan.
And so are you aware,
It was a comprehensive rezoning
yes,
in the sense that there was, right?
yes.
But
And so are you aware,
the effort was to try to make that match up generally, to sync it up with what was recommended in the previously existing master plans.
and so in that comprehensive rezoning, the district council elected to keep the RE zone. Is that not correct? For this property?
Well, it's a floating zone.
Well, the RE zone.
The RP, right, the RE zoning was kept, but the master plan did not recommend RE necessarily. The master plan said it should be low residential. The district council at the time the master plan was adopted, for whatever reason in their wisdom, decided to apply whatever the previous equivalent of RE zoning was, which is slightly lower, but the master plan recommendation is controlling as far as what the public policy of the county is for this area, what type of development, what intensity of development is appropriate for this neighborhood.
And when are you aware that when the master plan was crafted, was there a zone like the RPD zone where you could have a level of density this high?
Yeah, CDZ, I think.
And that
There were other
allowed the
or-
equivalent of a 6.8 dwelling units per
or
acre
RS.
within the developed area?
Yeah, I would have to look at the old code to give you the right acronym.
Mhm.
But the answer, I think, is yes. There were previously set up floating zones that could be applied to situations like this with this type of base zone that would have allowed higher density in a manner that's generally consistent with what we're talking about in this application.
Well, I'm trying to
Yes.
be very precise. Would it allow the level of density specifically proposed here?
I believe so, yeah. I would have to look at the old code to give you the particulars, but yes, I don't believe that the new RPD zone is fundamentally different than the old floating zones in the sense that you're talking about.
And do you know whether the old floating zones were allowed on this property under the old zoning code?
There would be a master plan conformance requirement, which again, the master plan calls for anything up to 3.5 units an acre. So I think that would be satisfied. If you want to get into the particulars of what the old code said, I would have to have it in front of me. But I think as far as maximum density under a floating zone, yes, that was a thing prior to the zoning rewrite.
But, so just to make sure I'm clear on the scope of your testimony, you did not specifically look at whether under the old zoning code, which was in effect when the master plan was crafted, whether a floating zone could be applied to this specific property with this specific number of dwelling units being proposed at this specific density being proposed. You didn't look at that,
I'm
correct?
gonna object to relevant.
Well,
I
if
have
I
not
may, the
recently.
relevance.
Well, wait, your attorney objected. Could you give us a proffer, Ms. Votar, about?
Yeah, the relevance I'm trying to demonstrate is when you're looking at conformance with the master plan, of course, was crafted numerous years ago and before the new zoning ordinance was adopted. And the testimony I'm trying to elucidate or evaluate is whether, in fact, the drafters of the master plan ever contemplated development which, in reality, in terms of the actual density of where people are living, would have a density of 6.81 units per acre. Because in my mind, low density recommendations are not just a facet of how many units are in an overall development, but what is the living conditions going to be like for those people who reside in that property? And the intention was to have a low density environment for those residents. And so I'm trying to evaluate if this applicant or this witness has evaluated that or not.
Ms. Votar, it's not relevant. I mean, it just conjures up nothing but speculation. When the master plan was adopted, the RPD zone and the 2022 zoning ordinance did not exist. So they could not have contemplated what the density would be under a zone that did not exist. Now that the RPD zone exists, the county council has made a policy decision of what the density can be under the RPD zone. It is not necessary to compare the RPD zone today as it exists to some CDZ zone that existed pre-2022. They're not asking for a comprehensive design zone today. They're asking for an RPD zone with the density that is allowed under the RPD zone.
Yes, but the required findings are conformance with the master plan, and in Maryland, the
So the issue there is
preeminent rule of interpretation is legislative intent.
that's right. Conformance with the master plan doesn't have anything to do with the comprehensive design zone, though. You're conflating apples and oranges.
I'm just trying to evaluate what the
Forget the
witness
comprehensive
evaluated.
design zone analysis. It has nothing to do with this case.
And if I may, Ms. Votar, if you had, I think I know where you're trying to go, and if you had some proof in the master plan, since we are relying on the master plan for density for this case, I mean, we all agree on that. If you had something in the master plan that says he can't measure density in the way that we do, or something of that nature, but you're sort of just, he's correct that you haven't tied those questions to anything thus far that he's testified to. So if that's where you're going, you should ask that question. I don't know where you're going, but I mean, I'm not trying to predict where you're going.
I'm just trying to understand what exactly this applicant evaluated when he says it conforms with the master plan, and whether he considered this or not. If he didn't, then that's the answer, and I'll move on. That's all I'm trying to ask.
And I think he did say he didn't consider former CDZs without pulling up the code and the master plan. I don't put words in your mouth. What did you say to that, Mr. K?
Yeah.
Mr.
Right.
Casey?
Well, I mean, there's a few things here I just think I need to make sure are very clear. One is I do not accept the premise that this is 6+ units an acre. This is 2.97 units an acre. And I think to your point, Madam Hearing Examiner, you are absolutely correct that the master plan does not say that does not suggest the district council thought there was a problem with houses being close together as opposed to far apart. It said the development intensity maximum should be about 3.5 units an acre. That should be the outer limit. There's all kinds of reasons why somebody might say that 3.5 is the right number instead of some other number. But if the district council thought it was because they didn't like townhouses, they didn't say so in the master plan. So that would be completely speculative. I would also add, in terms of synthesizing the environmental and land planning analysis here, that it's environmentally desirable to have a more compact form, to have some townhouses with common walls. It's more energy efficient. There's a whole bunch of reasons why putting the houses closer together and having attached housing types is actually a good thing. It's in the public interest. I don't know what they were thinking when they passed this master plan. What I do know is they were silent on any kind of problem that they may have had with a more intensive building type. What they did say is that they thought that the maximum appropriate density in this area is 3.5 units an acre. And this development application fits comfortably within that judgment and standard that was imposed by the master plan. When the comprehensive zoning was adopted, there was another legislative finding. That was the district council again, applying new zoning to this property, RE zoning, and providing the option for RPD zoning, which allowed relaxed dimensional standards and all the other things that we've been talking about today. So I don't see that certainly there's no inconsistency that's been demonstrated with anything that's in this application and the master plan. And there's intervening legislative judgments that have made that I think are actually in support of it.
So Ms. Votaw, back to you. I'm sorry.
I'll move on to my next question. So I want to touch on the public benefits. How much woodland conservation would be required under the RE zone?
I don't have the number in front of me. I think Ms. Gillette talked about this. I think it was 20, yeah, is this 20 versus 25%, right?
Well, what's the RE zone?
20% of RPD, 25% under the base zone, but we're talking here about an application that gives you 25%, even though that's not what's required under the RPD zone.
Yes. The zoning ordinance requires that the public benefits be substantially better than, that the public benefits are superior features to a significantly greater extent than would likely result from the development of the site under the base zone. Is that correct?
Yes.
Okay. And the development of the site under the base zone would result in 25 acres of woodland preservation, would it not?
Yes.
And currently being proposed is 25 acres of preservation. Is that correct?
That's correct.
And could you please explain how that's a superior benefit to have the same amount of woodland conservation as would be required under the base zone? Not compared to the what's required under the RPD zone, what's compared under the base zone?
Well, you have to look, I believe, from a planning perspective at the totality of the benefits and the other public interests at stake in the application. So basically,
we'll get to that. I'm going to just stick with the forest conservation.
Let me unpack this for you, okay? The RPD zone is basically an offer by the government to applicants in land use cases to say, we'll give you more flexibility, relax certain standards, maybe ask you to do a little bit less in exchange if you can do some more in some other areas. In this case, we're delivering, this applicant is proposing to deliver more in certain respects, for example, transportation and trails, land preservation, park dedication, et cetera, and not asking the government to sacrifice the additional woodland conservation they would have gotten under the base zone. So even though it's the same in terms of the number of, or roughly the same in terms of number of acres that have to be preserved, it's superior because it provides a superior land planning with all the other public benefits we've described. And it does that without taking advantage of the opportunity to reduce the woodland conservation by 5 acres or whatever that net number is. So I think when you look at the totality of the public benefits, including how much woodland is preserved, you have to come to the conclusion this is a better deal for the government and the public than what you would have ever gotten under the base zone.
So by itself then, the amount of woodland conservation is not superior to a significantly greater extent than would occur under the RE zone. Is that correct?
I mean, I think if you're going to take that narrow question in isolation, yeah, that's what you said is true.
Okay, thank you. And I'd like to talk about the dedication of the Tinkers Creek area. That would be a requirement of the base zone, would it not?
Oh, I should add, we're talking on site too. That's the other thing about the woodland preservation here. If we get it all on site, that's a good benefit for the neighborhood as opposed to woodland preservation that occurs somewhere else.
Well, again, the current zoning, the current forest conservation requirements require on-site preservation unless you're approved for off-site preservation. Is that not correct?
No, you can go off-site pretty much as a matter of course.
Under the new Forest Conservation Act regulations?
Yeah.
I don't believe that's correct. But we'll move on and I'll come back to that in a second. For the dedication of the Tinkers Creek stream area, that would be a requirement under the base zone. Is that not correct?
I'm sorry, the what?
The stream valley dedication, that would be a requirement under the base zone?
You might have, I'm not sure you'd have to dedicate it. It might be put in an easement. I don't think you're gonna get full dedication, in the absence of some public benefit requirement.
So are you disputing staff's?
I could be
and the-
mistaken about that, but I think I think you could preserve it like in a forest conservation easement and limit development in the stream buffer, but the benefit here is that it gets dedicated to the Parks Department so they have control over it.
Give me one moment, if you will. So are you disputing the planning board's finding on resolution page 14 that quote, either the 5% usable area of land dedication or the stream valley dedication with master plan trail would be a base requirement under the subdivision regulations? Are you disputing that finding by the planning board?
I think the planning board may be somewhat mistaken in the assumption that that trail is entirely on the applicant's property. Ordinarily, if a trail were shown a master plan on the applicant's property, that could be part of the base requirement. My understanding is this application shifts the trail just a little bit from what's shown in the master plan to put it on the applicant's property, and therefore they agree to sort of absorb the full impact of that. And that's shown on Exhibit 21. If you look at Exhibit 21, you'll see like the Stream Valley Park basically borders, it's abutting the property we're talking about here, the applicant's property. And there's a blue line that shows, sort of in general terms where the stream and trail are where the stream is and where the trail is supposed to be. This application moves that trail a little bit, I guess I want to make sure I'm directionally correct, down on the diagram, which I think is generally south. So the trail now runs basically across the top of the property in an area that it wouldn't have been a required benefit because it wasn't entirely on the applicant's property.
So you are disputing the planning board's express findings that the dedication of this area would have been a requirement under the base zone?
Well, I'd have to think about what the verbiage in the planning board's resolution to be sure about that, but I think this may just be a little bit of imprecision on the part of whoever put together the resolution.
That's also a staff's finding, is that not correct?
Well, the staff puts together the resolution, so yeah.
Okay. So you're disputing that, got it. I'm gonna talk about the interpretive signage. The planning board also found that would have been a requirement of the base zone. Is that not correct?
I don't think that's right. Yeah, I think Ms. Gillette talked about this.
Let me just be precise. Yeah, so you're disputing, for example, the planning board's finding on resolution page 20. Quote, this is a basic requirement that would be applicable for any development of the site and therefore not a public benefit feature.
Yeah, I don't agree with that. And that's why I said in a few minutes ago that while I agree with the planning board's ultimate conclusion, I don't necessarily subscribe to every detail of the way they got there.
Understood.
Ms. Votak, may I just
Yes,
ask a clarification? When you ask these questions, does he dispute something that the planning board said? You want to recharacterize that? Does he agree with it or disagree with it? I don't know what you mean when you say
Okay,
he disputing.
disagree then. Do you agree or disagree with that finding?
I do disagree in part with that finding.
Thank you, Stan, or Miss the People's Zoning Council. Okay. And I'm going to switch focus away from the public benefits. I think we've gone through those sufficiently. When I recall in your testimony, you thought that there would not be an adverse impact to surrounding properties from this proposed development. Is that correct?
Yes.
When you were making that determination, did you include in your consideration impacts of property values?
Not directly.
Okay,
I mean,
thank you.
it's hard to see how
Um,
there would be an impact on property values if there's no adverse aesthetic effect.
That
Or,
was not specifically part of your determination previously,
traffic.
correct?
beg your pardon?
That wasn't part of your evaluation up to this point, correct?
Not directly, no.
Okay, thank you. All right. I believe that's all I have. Thank you.
Ms.
Thank
Voto,
you.
just before we let him go, can you tell me where that was about the signs in the planning
ma'am.
board?
On page 20 of the resolution, the first paragraph of that page says, at this time, there's a lack of detail as to the information and number of signs to be provided. In addition, as part of the archaeological investigations to be conducted on the property and discussed further in the resolution, signage is recommended to capture the site's history in conformance with the historic recommendations of the master plan. This is a basic requirement that would be applicable for any development of the site and therefore not a public benefit feature. On the top of page 20.
But does that go to the historic or all signs?
That's the way, what the planning board applied to all signs, from my understanding, and
I
I'm
know.
not part of the
Reading
applicant's team.
I don't
Okay.
think that's what the planet, that's not my understanding what
you.
the planning board did.
I just wanted to clarify that I was reading in the same area.
Yeah,
I'm sorry.
yeah, the planning board analyzes that bottom of page 19, top of page 20, and they explain in those paragraphs why they came to that conclusion.
Mr. Anderson, what is your characterization of that paragraph?
Well, I think the disagreement here, or the confusion maybe, is that we are providing signage and interpretive features that go beyond the base requirement. There may be some base requirement for interpretive signage, but we add additional interpretive features and signage beyond that base requirement. And I don't think that's not inconsistent with my understanding what the planning board did, but again, I hadn't really focused on that part of the resolution.
Are you familiar with the planning board's statement that, quote, at this time, there is a lack of detail as to the information and number of signs to be provided?
Yeah, it's in the resolution.
Yeah.
I think that will be fleshed out at a later stage of the process. But again, I think the relevant question for the public benefits analysis is what is the base requirement for interpretive signage and the like, and does the applicant provide something in addition to that? I think we're going beyond what's required as the base requirement, but this is, to be honest with you, not something I'd given a whole lot of attention to.
And I want to throw this out because we got to go on break, but when you're looking at this, the next paragraphs, the conclusions are these public benefit features 1 through 6 are found to meet the required criterion. So,
Yeah. Well, we certainly
and
disagree
that
with
was one
that.
of the 1 through 6.
Well, we certainly disagree with that.
Oh, okay.
And we'll go through that. What
Okay.
I'm trying to establish, and I'll talk about this in my opening, so I won't belabor the point, is when you really look at each of these features, the vast majority of them are base requirements and should not be considered public benefits. And then when you're looking at what remains as true public benefits, things that are not otherwise required by the base zone, it's simply not sufficient for the amount of units that are being proposed. But I'll touch on that in my opening statement and my witnesses.
Well,
And that's all the questions I have. So thank you.
I've looked at the.
I have to give this staff a break. I have to.
Okay.
So
well,
everybody put
I
a
had a
pin
chance
right
to-
there and
All right,
can
I've been reading this while you've been talking, so if you want me to address that question, I could do it, but
Are
I
you
defer
trying to
you.
leave before lunch? Okay.
I'm not, whatever you want to do. I
No,
just
if you
wanted
have
to
1
say-
minute to add, go ahead.
Okay, all I wanted to say is that the planning board resolution says that there would have to be signage to capture the site's history in conformance to the historic recommendations of the master plan. That's a basic requirement. What we're talking about here is also interpretive material that relates to environmental features and the like. So that's separate from the historic stuff that's in the master plan and that's also shown in the SOJ. There's an interpretive, there's I guess that's subpart 7 says interpretive signage explains this.
Yeah, I remember reading that in the SOJs, which is why I was looking for it in here, but thank you. So, Mr. Tedesco, are we finished with?
Yeah, that would conclude
Ms. Anderson?
our witnesses, Madam Examiner.
Okay, and Mr. Brown, you had no questions?
No.
Okay, so we're gonna take a break. How about till 2:20? It's 10 of. See you all then. It's not gonna be another link, so leave this up. Thank
Thank you.
Recording stopped. Recording in progress.
Is Ms. Votaw back? We sort of jumped the gun on our recording. Sorry about that. Are you ready?
Yes, ma'am.
Okay.
All right. So for the record, Alex Votaw from the Law Office of G. Macy Nelson, with the pleasure of representing citizen opponents in this case. And I thank you, Madam Hearing Examiner and staff and everyone for bearing through all of this and all my questions. So I appreciate that. Fundamentally, the issue my clients have with this application is the attempt of the developer to present public benefits, or rather present bare necessities and basic requirements of the zone as public benefits. And there are four issues in my mind in this case. One, conformance with the master plan, and I'll touch on that in a moment. Second is are the public benefits superior to a significantly greater extent than what would occur under the base zone of the RE zone? In other words, the important comparison in this case is what would be required under the RE zone versus what is being proposed here. And is what is being proposed here significantly greater, I apologize, excuse me, significantly greater than what would otherwise be required. The comparison for the public benefits aspect of this case is not what currently exists with no development versus what's being proposed. It's not what is the bare minimum for the RPD zone versus what is being proposed. It is the correct comparison for the public benefits aspect of this case is what is required under the RE zone, the existing zone, compared to what is being proposed. And is what is being proposed under the new zone significantly greater, or are the public benefits providing a significantly greater benefit to the public or surrounding properties than would otherwise be required? Another issue is whether there's any adverse impacts. In this case, we argue there are adverse impacts, particularly.
Ms. Votaw.
Oh, can you hear me now?
Yeah, I hear you, but I'm a little bit confused. You're making argument. I mean, if you wanted to make an opening statement, you should have done that at the beginning of the case. So if you're making an opening statement now, you're going to have to just tell us this is what your case is going to be about, as opposed.
Yeah. I did not hear an opportunity to provide an opening statement at the beginning of this. So that was my intention.
Yeah, I apologize for that. That would have been my fault. But he says don't argue too much.
I won't.
Okay.
I'm gonna move on.
Okay.
I'm just laying out our four issues. So public benefits, master plan, adverse impacts, and whether the change or mistake rule applies. We argue it does because section 273601E states that the change mistake rule applies to any zoning map amendment, and this is a zoning map amendment. Before I go to my witnesses, I just want to point out something really important about the master plan, because there's a question about how is density defined. And I just want to read straight from the Subregion 5 master plan, which states the residential low areas are designated for single family detached suburban development. Most of the land in Subregion 5 is in this category, which is intended for single family detached residential development that may have up to 3.5 dwelling units per acre. Single family detached. That is a definition of residential low density. And it's 3.5 dwelling units per acre for single family detached houses. I wanted to make that point. I think that's the reason this doesn't conform with the master plan.
So since you're reading, which page was that?
Yes, ma'am. It is on page 33 of section 4, land use and development pattern. And that's the 2013 approved Subregion 5 master plan and sectional map amendment document. And this section specifically references Hyde Field being designated as residential low land uses in this master plan. So with that, I would like to ask for Jerome Tidwell to testify. He should be logged on.
Mr. Tidwell?
I'll text him if he's not, and I can move on to my next witness and come back.
Okay.
Mr. Tidwell, are you there? Texting him. One moment. All right. I'll for now move on to my next witness if that's all right with Madam Hearing Examiner.
Sure.
Could I have Jessica Brown unmute yourself? I see you on here. There we go.
Hi, can you hear me?
Yes.
Yes.
You can see me.
Ms. Brown, do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
I do.
Ms. Brown, can you please describe your educational background?
Yes, I studied civil engineering for 4 years at the University of Southern California. My coursework included classes in transportation engineering and urban planning, and I received a Bachelor of Science in civil engineering, which is accredited by organizations that give engineering degrees.
Thank you. And can you please provide a description of your professional experience?
Sure. The work I do day to day is within the field of transportation. I've worked on various projects across lots of different modes at different scales, from conceptual level to detailed design. These modes are wide ranging, as I mentioned, but include roadways, site development, including due diligence for developments, transit, aviation, and currently I work in active transportation. So that's essentially getting people to and from their destinations via walking, biking, rolling. Essentially, my job is to make sure that any plan to add any type of transportation infrastructure, whether that's at the concept stage or the beginning stage to detailed design for construction, is feasible and up to engineering standards. So on a day-to-day over the course of my career, I have used a variety of industry standards, including the Manual on Uniform Traffic Devices, the American Association of State Transportation Officials, or AASHTO's Green Book, Highway Capacity Manual, the Institute of Transportation Engineers, Trip Generation Manual, National Association of City Transportation Officials, Street and Bike Design Guidelines. All of these I've used to inform any engineering decisions I make. And this could be anything from appropriate bike widths to what is appropriate number of lanes for daily traffic.
Thank you. So in your professional experience in your day-to-day tasks, would you say that you evaluate the impact of traffic on a roadway?
I do.
Okay. I'd like to proffer Ms. Brown as an expert in traffic.
Do you have a resume or CV for Ms. Brown that you could provide?
I do not want to have one at this moment.
Okay, then
yeah.
that would it would have just been good for me to see it. But Mr. Brown, do you want to voir dire, or Mr. Tedesco?
I do, but I'll defer to Mr. Brown.
Ms. Votar, it's customary to have a resume or curriculum vitae when you offer an expert. Since we don't have one, I will ask questions of Ms. Brown as I can. So Ms. Brown, first of all, Ms. Votar, you're offering her as a witness in what field? Expert?
Traffic impacts.
Traffic engineering.
Traffic impacts, yes.
All right. So, Ms. Brown, are you licensed in civil engineering in the state of Maryland?
I am not. I have an engineering and training certification.
All right, I did hear you say you had a certificate, but again, you're not licensed in the state of Maryland in civil engineering.
That's correct.
And do you have a bachelor's degree?
Yes, sir. And a bachelor's of science in civil engineering.
From what school?
The University of Southern California.
And do you have an advanced degree in any field?
I do not.
And how long have you been practicing civil engineering?
I've been practicing civil engineering for 4 years.
And you are employed where?
I would prefer not to provide my employer, but I do have a job. And I work as a civil engineer for a local municipality, but I don't want to specify.
Well, you're being offered as an expert witness. You must specify your current employment and your past employment in order to qualify as an expert in any field. I'm not trying to be personal, but your attorney has offered you, and therefore you must provide certain information, or otherwise you won't be qualified.
That's
Mr. Mayor,
fine. I work.
she can, oh, sorry, what were you gonna say?
No, you say it first.
I believe she can provide a description of her experience, particularly any past experience. I'm not aware of any specific rule that requires her to disclose her current employer.
It does. In order to qualify a witness, you must determine the witness's education, the witness's experience, and part of it, determining experience, is where are you employed? What have you been doing at that particular job?
I believe she's described what she's been doing at that job, but
Well, I don't know the employer. What is the name of the business?
It's okay. I work for the city of Alexandria, Virginia.
All right, you work for the city of Alexandria, Virginia. And what is your position there?
I'm a civil engineer
All right. And how long have you been employed at the city of Alexandria?
for about 10 months.
10 months?
That's correct.
And are you a supervisor there?
I am not.
And where were you employed prior to working for the city of Alexandria?
I was employed at the Federal Transit Administration.
In Washington, D.C.?
I was located in California.
And how long were you employed at the Federal Transit Administration in California?
For about 4 months.
And what was your job? Were your job duties there?
I was a general engineer, so I was responsible for looking at any new transportation developments that local municipalities and transit agencies wanted to provide, and making sure that they had the necessary resources to get funding from the federal government.
Did you tell me, when did you receive your degree in civil engineering?
I didn't say, but it was in 2022.
2022. All right. So prior to being employed at the Federal Transit Administration in California, where were you employed?
I was employed at a firm called Arup. They're a global engineering firm, and I worked on their transportation engineering and civil engineering teams.
And how long were you employed there?
I was employed there for about 2.5 years.
And where is that company located?
They're a global company, but I was based in California.
And you are a resident of where, Virginia or Maryland?
I'm a resident of Prince George's County, Maryland.
And do you live near this property?
I do.
Have you ever sought to be qualified as an expert witness in civil engineering prior to today?
I have not.
And so therefore, you've never participated as an expert in any court proceeding, correct?
That's correct.
You've never testified as an expert in any administrative proceeding.
That's correct.
And have you ever published any articles on civil engineering?
I have not. That's not really in my purview.
Right.
I'm a practitioner.
I understand, but these are the requirements of an expert witness. I don't have.
I was just explaining.
I don't have your resume in front of me, so I can't zoom in. In terms of projects, what projects have you worked on in the past 10 months in the city of Alexandria concerning civil engineering?
Like I mentioned, I work in active transportation, so most of the projects that I work on are adding bike lanes and pedestrian facilities to roadways. I can be specific, but I work on a lot of projects.
Are you being compensated today to be an expert witness in this case?
No, I'm not.
Most municipalities have a bar to allowing municipal employees to provide other employment opportunities. Are you barred from having employment outside of the city of Alexandria?
I am not.
All right, so we went over your education, we went over your experience. I mean, you don't have any additional experience other than the 20 months that you've been employed in the city of Alexandria, state of California, and then I think it's Aeroflot, I'm not sure the exact name. You have no other experience other than that because you were just a graduate in 2022, correct?
That's correct. I don't know how many, 20 months sounds short, but
Yeah, 2 years is 24 months, and that's, you were
yeah,
at the first place for 2.5 years, you said?
correct.
Unfortunately, Madam Examiner, I have to object to her being qualified in the field of civil engineering on the basis that her degree is recent, less than 4 years ago. Her experience in the field is minimal. She is not licensed as a civil engineer in the state of Maryland. And I'm going to assume, but I guess I'll ask you the question, have you ever participated on a private project of development in the field of civil engineering, not working for the city of Alexandria?
Yes.
And what project was that?
It's confidential, so there was an NDA, but it was a development project, and I did transportation data set, or excuse me, what's it? Diligence for a commercial building, transportation wise. There's sensitivities about that, so I'm not able to speak on the whole.
What state was that in?
That was, I was based in California, but that was for the state of Arizona.
Yeah, again, I object to her qualification as an expert witness in the field of civil engineering.
May I be heard on this, Madam Hearing Examiner?
Well, 1 second, it might help. Mr. Tedesco, were you adding any more? So then you could,
Yeah.
respond to both of them.
I had a few more. Good afternoon, Ms. Brown. How are you?
I'm doing well.
Thank you. Thank you for joining us today. Apologize that you're in this situation, but we are where we are. Reminding you that you're under oath. You said you are a resident of Prince George's County, but you didn't provide your address. What is your address?
Is that necessary, Madam Hearing Examiner?
Well, you said you live near the property, so I was
I do.
curious on
Yeah,
what your address is.
you would have to provide it if you wanted to be a person of record and have any, generally everyone provides an address. Yes.
That's fine. I just wanted to make sure. I'm pretty sensitive about my personal information, so I just provided a lot, and so that's my only reason.
And Ms.
Um,
Ms. Brown is signed up as a person of record and has her address provided on that list.
So what is her address? I don't have the list.
Well, wait. So this is Jessica Brown.
Yes, ma'am.
Yes, sorry, my last name is
You
not.
know what?
it's-
It's not, that list is going to be public knowledge. I'm sorry. If you would just.
Yeah, that's okay.
Okay.
I live at 12012 Bork Drive, Clinton, Maryland, 20735.
And you own that property?
I do not.
Who owns that property?
My parents.
And are you a licensed professional engineer?
I am not.
And strike that. Have you prepared a report in this case?
I have not.
How many traffic impact studies have you ever prepared for a rezoning to the RPD zone in Prince George's County?
Objection. That is not the standard for qualifying a witness.
Well, the standard is trying to ascertain why they are considered an expert. And so we have looked at whether or not you've been completed and accepted or licensed in some way by the AICP, the number of years you've worked in a firm that does the type of work that you're trying to be accepted as, your degrees. She does have the degree, but it's a limited amount of experience to be an expert at this time. And I've never, ever done it without a resume. And it's not that I doubt what she's saying, it's just, there's something, we always count the number of projects or whether you've written in the area, whether you're licensed, and the years of experience. So I don't think there's any reason you can't question her.
Okay.
It just won't be
Respect
an
the Madam Hearing
expert.
Examiner's decision.
Is that a ruling, Madam Examiner? Because if so,
Yeah, I
I'll
don't think,
conclude.
Ms. Brown, I'm sorry, but I don't think I can accept you at this time, but.
Oh, Madam Hearing Examiner, may I be heard on that? I didn't realize we were making a ruling on her.
Oh, you
level
can
of
be heard, yes, go ahead.
Thank you.
I
First and
wasn't done
foremost,
I wasn't done my questioning.
Oh,
that's what I was. I thought that's what we were ruling on.
He paused. I normally jump in there when you pause. I'm sorry, Mr. Tedesco.
So that's okay. So you've never prepared a traffic impact study in Prince George's County, is that correct?
Oh, Ms. Brown, we can't hear you. Can anyone else hear her? I could hear you
No.
before and now.
What about now?
Oh, there we go.
Yeah.
Okay, I have not. That's correct.
Have you ever prepared a traffic impact study in any jurisdiction?
Yes, I have.
And do you know what the requirements are for a traffic impact study in Prince George's County as far as when they're triggered?
Loosely, yes.
When is it triggered in a rezoning application to the RPD zone?
That specific, I can't recall off the top of my head.
And what is your title in the city of Alexandria?
Civil engineer.
That's all the questions I have. I would align myself with Mr. Brown and object to Ms. Brown being accepted as an expert in civil engineering or traffic engineering, traffic planning, or anything of the sort.
May I be heard,
Ms.
Madam?
Votak, yes.
Yes, thank you. First and foremost, there are no rules of procedure on the hearing examiner's website that outlines the requirements for a expert witness. Second of all, administrative bodies are allowed to take evidence, hear expert testimony in a manner that's more expansive than the federal rules of civil procedure. And the hearing examiner is more than adequately equipped to weigh the testimony according to the experience that she believes it is that it accords. And even if you're going under the federal rules of evidence, the standard for expert testimony is a person who has knowledge, skill, expertise, training, or education may testify in the form of an opinion if it would be beneficial to the court's understanding of the case. And in this case, my witness has education, she has professional experience, she has the knowledge, and she has the skill to provide an evaluation of whether the proposed, and I'll proffer what the scope of her testimony, whether the proposed number of dwelling units will generate a level of traffic that will impact the traffic level on Steed Road. She is certainly equipped and qualified to provide that opinion. Whether or not the hearing examiner wishes to give that greater or less weight than other expert testimony, I believe is up to the hearing examiner's discretion. But whether or not she qualifies as an expert in traffic impacts, in my mind, is undisputed. She has the qualifications, she has the education, she has a professional background. And just because she hasn't been qualified in Prince George's County or worked on a specific zoning map amendment case in Prince George's County does not mean she is unqualified to provide her opinion on the impacts of this proposed development.
Okay, we don't have it on our website, but we've had a standard administrative practice for over 20 years as to the minimum level. And in response to Mr. Tedesco, she said she's not aware of the standards and procedures in this county.
She's
So-
not aware specifically of when in a zoning map amendment for the RPD zone, a traffic impact study is required, but she is generally aware of the traffic requirements.
She didn't say all of that.
That's
So-
what Mr.
So
Tedesco
now you're
asked.
testifying.
That was asked, and that was what I was responding to directly.
Yes.
Was that particular trigger, I would look. Every jurisdiction has their own trigger, and because I've worked in various jurisdictions, I know whether it's 100 vehicle trips in the peak hour or 10, that could vary based on which jurisdiction you're in. And because I have worked in various jurisdictions, I think I at least have the opinion of a traffic engineer with different experience to be able to say that. And like I said, I'm getting my sources and the questions that have, are from engineering standards. I'm not going to make anything up, even though I'm not a licensed professional engineer. I have my engineer and training certification, which also goes over ethics and things like that. So I'm not trying to go to jail. There's no trying to do any perjury or anything like that. I just want to provide testimony to help you in your decision making.
But Madam Examiner, if I could be heard, there's a substantial difference between what Ms. Brown just indicated and the actual requirements and the level of experience. Not to say it won't be there one day, but it's not today. And, I understand Ms. Brown's as a civil engineer 1. I mean, that's the lowest of the rankings. There's been no experience in this jurisdiction. She is not a professional engineer. I don't know of any expert witness in my 22-year career appearing before this body, any witness ever being qualified as an expert that's not even licensed in the state. So for all the reasons, we would just respectfully object to her being qualified as an expert.
Okay.
Well, I
If she
can,
Wait,
lived-
wait,
I'm not
I
even
have to put a
finished.
pin in this because we have to continue this hearing. I would not allow her as an expert witness, but you certainly have a right to call her and get her opinion as a neighbor or anything else that you can have her testify to, but not expert witness.
okay, well, I'll have her give her layperson opinion on traffic based on her professional experience and her evaluation of the relevant facts.
I mean, there's no such thing as a lay opinion on her professional experience. They are mutually exclusive. If she is going to testify as a layperson, she can only talk about what she has seen out there in the community, traffic that she's seen, things that are on the property. If she's been out to the property, she cannot speculate as to any technical issues related to traffic or civil engineering.
I object. I believe this is grounds for overturning any decision made in this case. It is an infringement on my client's due process rights. I strongly object to this finding. And to Mr. Tedesco's point, we personally have had traffic engineers who are not licensed in the state testify before Prince George's County bodies. So, if that's the hearing examiner's determination, then I will have to move on and I'll ask her what I'm able to ask her. But I just need to note for the record that we strongly object to this determination. I believe it is a reversible error and it directly impacts and infringes on my client's due process rights.
Okay, and I note your objection. I overrule your objection. I'll state again, it was the totality of everything, not being aware of the rules in this county, not being licensed, not providing a resume. And you have a right to, we're good. We're all good. We're ready to move forward, and I overrule the objection. So you ready with this witness?
Sure. I'll go as far as I can until I am told otherwise. Ms. Brown, thank you for your patience in this process. Are you generally familiar with the proposed development in this case?
Yes, I am.
And are you generally familiar with the area in which this development is being proposed?
Yes, I am.
Have you driven on Steed Road before?
Yes, I drive there nearly every day.
And could you describe for the hearing examiner your experience of the traffic that you have personally observed and seen in your experience of Steed Road?
Sure. I live in a community where I head northbound on Maryland 223 Piscataway Road, and then I make that westbound left onto Steed Road. It depends on the day, the season, the time, but there's been times where traffic has been backed up going through that intersection on Steed or on Piscataway Road, where it's been backed up about, like, I live on Winbrook Drive, which is along Winbrook Drive, which is about 2.5 miles away, and can see traffic building up during the AM peak hour. So I would say that is a area of concern in terms of there's not enough capacity at that particular intersection because of the number of people that live in that area. So, and I know they were talking about the BK Miller intersection, and that's much further away. But at the actual intersection of interest near the development or the proposed development, that northbound left onto Steed Road from Maryland 223 Piscataway Road is a concern. In the PM peak hour, I think as some of the previous witnesses have stated, it's a 2-lane road on Steed Road. And so the right turn onto southbound Maryland 223, there's no actual right turn lane, but people are waiting, whether they're going left or right on Piscataway Road, north or south, I mean. There's people waiting at that light, and some people get impatient and decide to make that right turn from Steed Road over basically what is a shoulder, but it's so deteriorated. There's potholes, there's broken asphalt onto that road. I would also say, in terms of traffic, that the community across from the proposed development, I think that's Ethan, oh, I forget the name of the driveway, but the community the community across from one of the proposed entrances to the proposed development, I can see cars waiting in line to turn out of their neighborhoods. I think it's Timber Branch or Timber Creek or something to that effect, waiting to turn out of their neighborhoods to head towards Allentown Road. And it could be a platoon of cars coming from Maryland 223 Piscataway Road, heading in that direction. And there's just just have to wait. I would also say that there's kind of in testimonies, forgotten stretch of road between Steed Road and Temple Hills Road, that passes the Mount Enon Church, as well as a small shopping center that has like a gas station and a 7-Eleven and barber shop and other retail facilities. And the people that are exiting those retail facilities also have to wait, whether they're waiting for traffic that's coming from like the Brandywine Road intersection, or waiting for people that are coming from the direction of Steed Road. And there's oftentimes where people decide to just dart out into traffic, because there's just constantly cars coming in both directions on Maryland 223. And I do think, people are going in different directions, whether you're going to Route 5 and getting on Branch Avenue that way, or you're going, like I do, towards like the Woodrow Wilson Bridge area, and you would take Steed Road to the Allentown Road to Buck Road to, I don't have to get into detail. One other area is Tippett Road. So I said the long queue of cars that goes almost 2.5 miles from Steed Road to where I live. One of the kind of main choke points is Tippett Road, Frank Tippett Road, that intersects Maryland 223. And that's another where it's just a stop control, or one leg of that intersection is stop controlled. So people are just waiting to make a left or a right onto Maryland 223 from Tippett Road. And they're not able to, there's always a conflict, and it always slows down traffic and offers queues there.
Is that after Miller Farm?
That's correct. So after you pass Miller Farm, it's like the first road on the left, and there's like a little bookstore on the left. So I would say, I think thinking more broadly about the connected network, like Steed Road is kind of in my opinion, Steed Road, as both a resident and a civil engineer not licensed, but it is both a main thoroughfare because it's getting people to like the larger roadway network, be that to get to other parts of Maryland or to DC or to Virginia. And having to come out to traffic when you first turn on to your main roadway is very disheartening, and just in terms of an opinion. And so I'd be concerned about future development, adding more vehicles and more vehicle trips. And that's something that I don't have to speak on per se in detail, but adding more vehicle trips is a concern because there's going to be more cars on the road using the same roads to get to the same major roads.
Thank you, Ms. Brown. And the road you were talking about in the development across from the subject property, was that Ethan Thomas Drive?
Yes, Ethan Thomas Drive.
Thank you. I think we've covered pretty much everything I wanted to cover with the ruling of the hearing examiner. Is there anything else you'd like to share with the hearing examiner?
That's a good question. Yeah, I do think I'll just reiterate what I said, that we've heard about the BK Miller intersection and things like that, but I do think the people that live like south of Miller's Farm really are at a disadvantage in terms of this intersection. I understand that the Hyde or that whole development is something to be aware of, and changing the roads. This is an opinion that is both engineering based and experience based, but widening roads doesn't necessarily always solve the problem that is traffic. I think the last witness that talked about transit, I think that's kind of more important. And I know, we're widening roads so we can accommodate more vehicles and that's more vehicle throughput. But if you're bringing in more residents and bringing in more trips, ultimately that road is going to be filled to capacity. So just like they do, I don't know what a good example is. But any roadway widening project, whether that's toll roads in the state of Virginia or widening in like the Montgomery County area that they're doing, I'm forgetting the names of the roadways. Those you're good for a second, and then more vehicle people say, oh, this is an option now. Piscataway Road is wider. Now I can continue, or Steed Road is wider. Now I can continue and make sure that I drive, and they have no other options. So I would say that, from my opinion, the problem, like the minimum benefit is, oh, we widen the road to accommodate the people that are coming and the people that are here. But honestly, the roads are so congested enough, that widening the road that we're talking about is the bare minimum. And I think that was Ms. Vota's point, is like, what is bare minimum standards? And obviously that's defined by the county, but in terms of the people that she's representing, I would say that we have to think more broadly about what our benefits. Is transit being included? I see the shared use path, but does that really connect to anything? I see people all the time walking up and down walking, rolling, biking Piscataway Road wearing nothing, not nothing, but wearing, dark clothes. I can't see them when I'm driving down. They need infrastructure too, and that doesn't just include accommodating vehicles. That should be accommodating people who want to walk, who want to bike, who want to roll, who want to take transit. I didn't have a car for a while, and so I just, from a public standpoint, and for an engineering standpoint, I think there's a bit of caution that we should take, in just in terms of just the answer is widening roads. I think there needs to be a more comprehensive solution as well.
And last question, in your opinion, as a layperson, would the proposed development adversely impact the traffic situation you've personally experienced?
I do think, without the benefit, I do think that the proposed development would adversely impact my traffic experience.
Thank you. That's all I have.
Mr. Tedesco?
Thank you. Good afternoon, Ms. Brown. Thank you again for joining us. Thought I heard you testify that widening the roads doesn't accommodate capacity. Is that correct?
I wouldn't characterize it as that. There's a concept, and I don't want to blur into the line of, since I'm not
No, I
testifying as an
think your
expert.
testimony was that your testimony was that widening the roads alone doesn't accommodate capacity. Did I mishear you?
I want to explain it in a way that makes sense. Widening roads alone doesn't solve your congestion problem. It may
Okay.
fix it for an interim period of time, but there's a concept called induced demand, where if people see that the roads are wider, they're more likely to drive and not take other modes of transportation. And so the road eventually becomes just as congested as the road was previously.
What's the current configuration of Maryland 223 and Steed Road intersection?
The intersection, there's heading northbound on Maryland 223, there's a through lane. There is a dedicated left turn lane that is signalized, so they're going on the signal or free. Southbound, there's one through lane and one right turn lane onto Steed. On Steed, there is one through lane that's kind of one through lane and a right turn lane for the people that like to make that illegal maneuver in the shoulder, and then the one through lane going eastbound.
And what is the conditional approval of the Hyde Landing project with respect to improving that intersection?
I'm not familiar. I heard it during someone's testimony, but I'm not completely familiar. So I think I wrote down, like, I don't want to say something that's incorrect, because this is not the Hyde Landing project. This is the Grove project.
I know, but you testified to traffic on 223 and Steed Road as a result of the intersection of Steed Road. You also testified to impacts associated with Tippett. So that was your testimony. So you brought it up. So it's fair to say then you don't know what these improvements consist of, only from what you heard today. Is that correct?
That's correct.
Would you agree with me that
improving that intersection to 5 lanes would improve capacity at that intersection?
5 lanes on Steed Road.
2 approach, 2 turn, one through, widening that intersection on both approaches to a 5-lane intersection. Would that improve capacity?
You have to lay it out for me, I'm sorry.
If we could pull up exhibit number 43, please. If we could go to sheet 4.
Can you zoom in on that intersection?
A little more to the right, please. Thank you.
Can you ask your question again?
Do you believe that intersection improvement would improve capacity at that intersection?
I believe for a temporary period of time it will, but ultimately I think it'll be congested again.
Based on what data?
Just the concept of induced demand.
Would you be surprised to know that this intersection improvement aligns with the State Highway Administration's traffic impact analysis for this area, for the
Would I
region,
be-
not just improvement? Would that surprise
Would-
you to know that?
No.
That improvement is basically a regional improvement and not a localized improvement? Would that surprise you to know that?
No, because I heard you talk about the CIP projects today.
And you still disagree that it would only be a temporary fix? Or you still believe it would only be a temporary fix?
I do believe that if we don't shift modes from just cars to other things, I see the bike lanes in here. That's great. There also just needs to be other modes of transportation options that people can take, including transit, including and especially transit, to make this better. So what I would like to see, like bus through lanes, that would improve your throughput or something like that. So
Do you know what bus routes are along this corridor?
not along this corridor. I know they recently just changed the routes for WMATA, but I don't believe there's any on 223. There's some like by Temple Hills Road.
So
a
you
little bit
suggest
east.
you would suggest bus through lanes on a road that doesn't have bus routes?
Yes, but you have to establish the routes as well.
Right. You're kind of getting to what I agree with. Don't we also too have to establish a project implementation plan that actually improves these roads as opposed to the status quo? Would you agree
Yes.
would you agree maintaining the status quo is not sufficient?
Good question. I would say maintaining the status quo is not sufficient, but I wouldn't start with adding more development. I would solve the problem by putting in the infrastructure in terms of transit or bike lanes first, and then I would develop.
And do you know whether or not this intersection is part of a capital improvement program from the county or these road improvements?
I believe so. I know the transportation.
It was yes or no. It was yes or no.
Okay.
And do you know how that capital improvement program is funded?
I do.
How?
Essentially, it's funded by local funds and by state funds.
Would you be surprised to know that this South County CIP is 100% developer funded?
Yes.
Are you aware that, now turning to the case at hand, are you aware that the application for rezoning of the Grove property proposes road improvements and trail connections? Are you aware of that?
Yes.
And you also agree that roadway improvements along Steed Road are necessary?
I believe I believe at the intersection of Piscataway and Steed, they're necessary. If the project
you-
goes in, well, okay, that's all I want to say.
So you believe that intersection improvements at Piscataway and Steed are necessary, but you don't believe that roadway improvements along Steed Road are necessary. Is that your testimony?
Is this just in term adding the proposed development?
I'm just speaking generally. Do you agree that roadway improvements along Steed Road are necessary?
I think adding in a dedicated right turn lane from Steed Road onto Piscataway Road is necessary.
What about the roadway? So I understand your testimony regarding Steed Road and Piscataway. What about the link between Piscataway and Allentown Road of Steed Road? Do you believe Steed Road
Objection
needs to be?
asked and answered. She already answered this question.
She has an answer. She's talking about an intersection. I'm talking about Steed Road.
That's my opinion. Is that's where I think roadway improvements are necessary.
Okay. All right. Thank you. So you agree that
Wait a second. There was an objection. At this point, I overruled because it looked like it was answered, but I do believe he asked for the link. Where is the link?
no, well, I'm trying to ask for the link because I keep
Oh.
asking if roadway improvements along Steed Road are necessary. Ms. Brown keeps saying that intersection improvements at Steed and Piscataway are necessary. And I'm asking, I'm understanding her. Am I correct to understand your testimony that Steed Road along the frontage of either Hyde or the Grove in your testimony isn't necessary to be improved?
I think there could be deceleration and lanes into the proposed grove. I'm not going to say anything about the Hyde. So if you are putting a proposed development in there, it needs a driveway and it needs lanes to get out so they can merge in with oncoming traffic and a turn lane to get in.
Would increasing the width of the bridge along Steed Road provide necessary improvements to facilitate better traffic flow along Steed Road?
Honestly, I don't. I don't want to answer that question.
You don't want to answer that question?
Yeah, I don't know.
Well, unfortunately, you have to.
Okay, can you say the question again? I'm just struggling with it.
Would increasing the width of the bridge and the culvert on Steed Road to accommodate ultimate 4 lanes along Steed Road would that be an improvement to Steed Road and its traffic flow?
Perhaps.
But you're not in support of the project that will actually implement that improvement, is that correct?
I'm indifferent.
Is it your testimony that you're now indifferent about this application?
I came in as just wanting to provide testimony based off of what I knew. You guys said that that wasn't acceptable. That's totally fine. I pointed out what things that I shared, and I'm mostly focused about Steed Road and Piscataway Road, Tippett Road and Piscataway Road. I think kind of in the area that you're speaking of, besides the cars that are exiting Ethan Thomas Drive, there's not much of a problem without the development. There are like people can't get out of that neighborhood on Ethan Thomas Drive because of just the constant queue of cars. But once you get down to the bridge and up towards Allentown Road, it's fine. But a proposed development, I foresee, would add potential problems to that. But so I maintain that I'm indifferent.
Okay, I have no further questions.
Mr. Brown
No questions. Thank you.
and Ms. Votaw, any
Yeah,
redirect?
just a few. Again, Ms. Brown, thank you so much for your time and patience in this matter. I just want to reiterate, I think, an important point that you made several times over and over again. am I recalling correctly your testimony that just because you widen a road, whether it's a bridge, whether it's a state improvement project, whether it's a CIP project, just because a road is widened, that alone does not necessarily mitigate adverse impacts from additional development? Is that
Yes, that's
accurate?
correct. That's
Okay.
accurate.
Thank you. That's all I have.
I have
Thank
one
you.
question, Madam Examiner, just one. Ms. Brown, do you know what the master plan transportation calls for this road, for Steed Road? As far as its ultimate improvement?
Ultimate improvement. I'm not sure. I don't want to say anything incorrect. I was just reading through the proposed one, the transportation go. I have read it in the past, but I don't know ultimately what they plan to do.
Would you be happy to know that it proposes or recommends a 4-lane road section?
If it has room for active transportation and buses, yes. If not, no.
Okay. Thank you.
Thank you, Ms. Brown.
Thank you, Ms. Brown. I appreciate you. Next, I'm going to try to call Mr. Tidwell again, see if that works out. And then I have one more witness after that. Mr. Tidwell, are you able to unmute yourself? I'm going to give him one moment. If the hearing examiner doesn't mind.
Is Mr. Taylor Mr. Tidwell?
No, I think Mr.
Oh, okay.
Tidwell is on the phone.
Oh, okay.
Yeah.
Oh, yeah, right here.
One second, I'm communicating with him right now. Oh, to see what's going on. Thank you for your patience, Madam Hearing Examiner.
Sure.
Can you hear me now?
Yes, there we go.
Okay.
All
Is
right.
he able to come on? We can't see him?
Yeah. Mr. Tidwell, could you explain why you can't be on video?
Well, I work in a secure building and we're not allowed to have laptops and phone in, so I'm in my car on my phone.
Thank you.
Do you know Mr. Tidwell before today, and so you know that's his voice?
Yes, sir. Yes, ma'am.
Okay. Do either of the attorneys have any real objection?
I would object for the record, but not to prolong the hearing. But I would object. I mean, we had a case last month where we had to ensure that all witnesses had screens, so.
I'm sorry, why did he say he cannot be on camera?
Because
I
he's
work
in
in a
his
secure
car.
building.
But you can't do it in your car? You can't turn the camera on?
Oh, that's not missing. That's on in my. Let me try something. Hold on. Yeah.
He's gonna go.
I'm gonna hang.
He's representing the community. No,
That
it's
means-
the fact that he can't get out of the community.
If I may suggest, Madam Hearing Examiner, Mr. Tidwell, why don't I have Mr. Taylor go next? And then if you want to try in that time to see if you can get it on your phone, we could try to do that and then come back to you last. Do you mind doing that, Mr. Tidwell, or is that very inconvenient since you
No,
are in the car?
No, that'd be perfect. I'm working on it. I'll be doing that right now. Okay.
Okay, is that all right with you, Madam Hearing Examiner?
Sure.
Okay, thank you. I appreciate your
Okay.
patience. All right, Mr. Tidwell, you are not muted, so just keep that aware. And next, I'd like to
Okay.
call Herman Art Taylor.
Mr. Taylor, do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
I do.
All right, thank you. So Mr. Taylor, could you provide the hearing examiner your address?
Yes, my address is 4100 Ethan Thomas Drive, Clinton, Maryland, 20735.
And how long have you resided at that residence?
Since 2006, July, our home was the first one built.
Oh, that's lovely. And what attracted you to the area?
Honestly, it was the quiet, um, the spacing of our homes, the idea that the impending residents were going to be people who worked hard in their lives to own a piece of property and who actually were able to achieve that. Um, Also, frankly, it was appealing to me that the vast majority of people who were going to be moving there were going to be African American. We were also drawn by the quality of the homes. By the way, the developer of our homes was Ryan Homes, the current developer of this particular project, I believe, is connected to Ryan Homes. So those were many of the factors. We wanted to have something that we could pass on to our children and grandchildren in years down the road. We wanted to hopefully build wealth. So a number of reasons why we chose this particular development.
Thank you. And are you generally opposed to any development of the subject property?
Of course not. We would certainly appreciate development that does not substantially alter the character of what we've built here and what essentially we believe we were, through an implied promise, delivered.
And do you have any concerns about um, the level of density being proposed in this area in particular, as opposed to a more well-developed area, let's say?
Well, I do because, frankly, we moved here so that we could have more of a suburban setting with homes spaced. And a development of this size would seem to be trying to import a city lifestyle or urban lifestyle into a more residential and rural community. And so I do have some concerns about how that would affect the character and also the value of our properties.
And to that point, you talked about trying to transpose or shift a more urban style of development to a suburban/rural area. Are you concerned that there are this many units in such close proximity to each other with very little amenities in the area?
I am concerned, and the unfortunate part about the zoning, um, the idea of rezoning our area, is that I really do understand what the state is trying to do. They're trying to create more places where people can live in good homes. They're obviously trying to preserve as much green land by doing that in a certain way of population density. I understand all that. On the other hand, though, when you look at the volume of homes that will be coming in as a result of this, it will dramatically change the character. And I know that there's been lots of conversation around being able to improve the road, the quality of the roads, the passability of the roads. But will that actually happen? I don't know for sure if that'll happen, even if there's a commitment made here. We've seen developments in other places where things were promised and they did not happen. And frankly, when I look at the people testifying here today on behalf of the developer, none of them look like me. None of them seem to live in my neighborhood. And they don't necessarily, I'm going to argue, have the same concern about what happens to these properties once they're gone. And so while they may be experts, while they may understand how traffics flow and how water runs down a hill and how it's captured so that floods aren't created, I appreciate all that. But what we really care about is the quality of our lifestyle and how we live in this particular community. And I don't know for sure that the developer has that same concern. I know that the developer will build houses, and when those homes are built, the developer moves on to the next project, and we're left with whatever comes next. So I am very concerned about the zoning change and what that will mean to our the character of our homes. While at the same time, I also understand where the state is concerned, but I wonder if this is the right situation for that to occur.
So am I hearing you correct? It's not, again, about no development. It's about what's the appropriate balance of development in this area. Would that be accurate?
Indeed. I mean, I think the current zoning map would allow for the creation of, what is it?
93.
93 homes. That seems reasonable. And you know, you also have to consider that we just rezoned the area at Hyde Field, from what I understand, and there will be nearly 300 homes put there. And so now the same developer is coming to us with a proposal to add another 300 within a 1 mile stretch of land. Both adjacent, pretty much adjacent to our development.
Yeah.
So between the two, there's going to be a substantial change to the character of our neighborhood.
Thank you. And let's, I'd like to just briefly turn to some of the public benefits, if I may. In your mind, is preserving the same amount of woodland under the proposed zoning as would be required under the base zoning, is that a public benefit sufficient in your mind?
Well, I think the zoning that we currently have now would, I think, match what we would see as acceptable. Why we need to change this zoning so that either more or less of those wooded lands would remain is a question to me.
Right. And I think that's pretty much all I wanted to cover. Is there anything else you wanted to share with the hearing examiner today?
Yeah, I mean, I guess I did have a statement, and if it's okay, I'd like to read it.
Yeah.
You know, again, our community is predominantly Black. You know, at least 38 of our 43 homes are owned by Black families, families who worked hard, saved carefully, and chose this place deliberately. We came here to own something, to build equity, to raise children away from urban congestion and noise. We chose this neighborhood because of its character, its quiet, its green space, its sense of community. That choice was intentional, and it matters. But I want this board to understand something about the value of what we own. Because of decades of redlining and racially discriminatory lending practices, our home values have historically been suppressed below what they should be. We've had to work harder to build less wealth than comparable white homeowners in comparable homes. That's not rhetoric. That's documented history. And the history isn't finished. What happens next to our community will either begin to correct that injustice or deepen it. If this board approves this development, and that floods our neighborhood with density, disrupts our character, and diminishes what makes this place desirable, then our home values will suffer. Again, not because of the market, not because of anything we did or failed to do, but because a decision was made in a room like this one that did not fully account for what we are and what we stand to lose. The families in our neighborhood cannot afford another setback. We've already been told through policy and practice that our homes are worth less. We're asking this board not to approve that. Now, here's what makes this particularly troubling. Our homes were built by Ryan Homes, a company that is owned by the same developer, now seeking to transform this area. When they sold us our homes, They sold us on this community, at least from an implied standpoint. They marketed the nature of this place, the open land, the quiet, the character, the separation from urban density. We bought what they promised. We trusted them. And now the developer is before us asking us to undo exactly what they sold to us. They're seeking to inject the very urban dynamics they assured us we would move away from. This is not a zoning question. It's a question of trust. And it's a fundamental breach of that trust. And the board should consider this. When you consider both Hyde Landing development and this adjacent application together, you're looking at a transformation of this entire area that none of us chose, none of us were warned about, and none of us consented to. We were sold a neighborhood, and now you're trying to sell us that neighborhood, sell that neighborhood right out from under us. Every expert the developer has presented to this board has been white, every one. Traffic engineers, planners, environmental consultants, a parade of credentialed professionals, none of whom look like us, none of whom live near us, and none of whom will bear the consequences of this decision. When our community attempted to put forward our own expert, someone who could speak on our concerns perhaps, that expert was rejected. Our voice, elevated through professional credentialing, was turned away. So I asked this board, what message does that send? What does it say about those whose expertise is valued and who's not? And I want to say something directly to the developer. The people on your teams who are making decisions about our neighborhood should instead be developing our neighborhood with us, for us, and in a way that reflects our faces, honors our investment. And if we can't seem to find qualified experts of color to present to this board, that's a problem worth solving. And one of you have the power to solve it. Hire people of color. Give them an opportunity to build experience and credentials that qualify some of them to stand before a board like this. Invest in that pipeline, because the reason there aren't more qualified experts of color is not a mystery. It's the same story of exclusion that suppressed some of our home values and limited our access to wealth. The board has an obligation. It's not a legal one, but a moral one, to ensure that this process does not replicate the same inequities that suppressed our home values in the first place. Approving a development that overruns our community, dismisses our concerns, excludes our experts, and accelerates unwanted change in a predominantly Black neighborhood is not a neutral planning decision. It's a continuing pattern. And we're not against development. We're just against being misled by the very company that built our homes and then bulldozed, literally and figuratively, while the people profiting from that betrayal look nothing like us and answer to none of us. I urge this board to take seriously not just the traffic studies, the stormwater models, but the urban and human cost that's being proposed. The cost to families who own something, the cost to a community that finally found its place, the cost to people who trusted a developer's implied promise and who've already paid more than enough for the sins of policies we never chose. Thank you.
Thank you, Mr. Taylor. Last question, and this is pretty obvious, but I want to make sure the record's clear. Do you believe that this proposed development will have an adverse impact on your property?
I do.
Okay, that's all I have. Thank you very much. And they might have questions for you, so don't log off yet.
Mr. Tedesco?
I just have maybe 2, 3. Mr. Taylor, thank you so much. And I want to thank you and your wife for opening your homes to us previously for a number of meetings that we've had in your community and particularly in your house. So I publicly wanted to thank you and your wife for those accommodations. And I want to thank you for your testimony as passionate as it was. And I just have a couple of clarifying questions. Would you agree with me that implementing the county's general plan and the area master plan is important?
I do.
And would you, and you would not support any development that exceeds the future land use recommendations for this property based upon those plans. Is that correct?
I would not say that. What I would say is that future development, regardless of what zoning plan it's built under, should truly take into account what we're dealing with here in our community at Steeds Glen. And that is to make sure that the character is maintained and that the amenities that come with any future development are such that we can continue to live the quality of life that we do.
We would agree, Ms. Taylor. We intend to improve the quality of life for you and your residents. So thank you so much for your testimony and appreciate you being here today. No further questions.
Mr. Brown?
Good afternoon, Mr. Taylor. How are you?
I'm fine. How are you, sir?
I'm doing well, doing well. Just wanted to say, you know, a lot of the issues you've raised, they have merit, but they go to the issue of policy in the county, and policy is set by the elected officials, the county council members, the county executive. And we are in a hearing that's considered to be an evidentiary hearing, and it's quasi-judicial. And what that means is we are looking at one particular property and trying to evaluate the approval or denial of the applicant's request based upon criteria that have already been set by the county council. And so many of the issues that you've raised are issues that have been resolved, if you will, at the legislative level. That is, the council has decided the RPD zone exists and it may be applied to this particular property if the applicant complies with the criteria of approval. It would be inappropriate to approve or deny a project based upon what is called plebiscite. That is because all of the African-American people in the neighborhood are opposed to it. Or the opposite of that, it shouldn't be approved because all of the experts and applicants were Caucasian. You can only make the decision based upon the criteria that have been approved pursuant to the law. And so I just want to make sure that you understand that regardless of how this case is decided, it has nothing to do with someone taking the African-American community lightly in this community. All right, and so just stay involved, and you know your voice will be heard, and your concerns can be incorporated as much as they can within the project as the county council and the examiner reviews the project. You're not being ignored. I just want to make sure you understand that.
Well, I appreciate you saying that our voices are not being ignored. And if this isn't the right forum for my statement to be considered in, then I long to be a part of the forum where it will be. It's really, I think, vital that people understand that there's a lot at stake here for us. And we want to make sure that people understand that.
All right, great, thank you. No other questions.
Thank you, Mr. Taylor.
Thank you.
Ms. Votel, do you have any other witnesses?
I just had two follow-up questions for Mr. Taylor on rebuttal. Mr. Taylor, you are aware, are you not, that one of the required criteria for approving this application is that it will not have adverse impacts on surrounding properties. Is that correct?
I am aware of that, yes.
And to my recollection, all of the testimony you provided goes directly to the adverse impact this will have on your property. Is that correct?
I am very concerned about that, yes.
And another thing I'd like to touch on too is this property in the comprehensive rezoning that just occurred a handful of years ago was specifically zoned by the district council as RE. That's the current zoning. That's correct?
Yes.
Thank you. That's all I have.
Okay. Well, you have your next witness?
Oh, yes. And thank you, Mr. Taylor, for your time. I really appreciate it.
Yes, Mr. Taylor.
I think we have Mr. Tidwell on Zoom, hopefully video capabilities available. So Mr. Tidwell, if you could unmute yourself, show your camera, that would be great. I'll give you a few moments to do that. There we go.
Hi, Mr. Tidwell. Do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth? I can't hear you.
Yes,
Okay,
There we go.
thank you.
thank you. Thank you. Okay.
Thank you, Mr. Tidwell, and thanks for bearing with us in your car. Could you please provide the hearing examiner your address?
9612 Gina Nicole Drive, Clinton, Maryland, 20735.
Thank you. And how long have you resided there?
14 years.
And in the time that you've resided there, have you had occasion to drive on Steed Road?
Daily.
And could you please describe for the hearing examiner briefly the traffic conditions that you've experienced?
It is horrific. We, on a daily basis, traffic are backed up either on Steed Road, Piscataway, Old Branch Avenue, Allentown Road. The whole corridor area is a log jam on a daily basis.
Thanks. And in your opinion as a layperson, will the proposed development, given all of its public benefits, address that issue, or will it exacerbate that issue?
It's going to exacerbate the issue.
And do you believe that this proposed development, including its proposed public benefits, would adversely impact your traffic experience and your property values?
Yes.
And could you explain for the hearing examiner what kind of improvements as a layperson you think would be sufficient to address the traffic conditions currently and with the proposed development included?
Well, mostly I don't listen to all the story. Everyone is focused on infrastructure. Even with the 4-lane on Steed Road, redoing Steed Road. They said they're gonna put some lanes on Piscataway Road. Not only that, but we still looking at not just Hyde Land and not just the Grove, but there's another development that is adjacent to the Buffalo that no one's talking about. That's going to be developing another 500 houses, which is going to have through traffic coming back through those development that's going to come onto Steed Road also, which is going to even make that even worse, which is, we're not talking about that yet. So that's just part of the issue. No one is talking about the safety. No one is talking about school, EMS, police response time. None of this stuff is being addressed. We're just only talking infrastructure. So there's more than just the infrastructure. Widening up the road is not just the only thing that's going to have an impact, but there's several other things that goes into that process.
Thank you. And is there anything else that you want to share with the hearing examiner today?
Basically, I'm just going to echo what Mr. Taylor was just saying. Been living in that development for 14 years, and Hyde Landing is already going to put at least 12 to 1,300 houses at the top of that hill, and then rezoning this grove to another 300 houses. It's just going to overcrowd a community that is already crowded, and there's nothing is in sight to alleviate or to help the community that's already there. Basically, to me, it's like the developer is just coming in and the county allowing them to just dump houses into the community and do bare minimum what they say. They say they overdoing stuff, but what they're doing is just the bare minimum of what the plan called for. And then after they do that, they may do the road, they may not. Then they gone, and then we stuck with all this traffic.
Thank you, Mr. Tidwell. That's all the questions I have for him.
Mr. Tedesco?
Mr. Tidwell, it's good to see you. Thank you for appearing. I have no questions.
Okay. Mr. Brown?
I don't have any questions. Thank you.
Thank you, Mr. Tidwell.
Yes, ma'am. Thank you.
Oh, thank you, Mr. Tidwell.
Yes, ma'am. Thank you.
Madam Hearing Examiner, I see, I think 2 or 3 of my other clients on here. Can I just check briefly if they wanted to share their comments? Oh, I'm sorry.
I don't
Madam
want to prevent anyone from testifying, but I have to let this staff go at 4.
Okay. Hopefully this will be good. Miss Sam, I believe that's Mr. Lynch. Do you have anything you wanted to share today? Give you a few moments to unmute if that's the case. Okay, I'm going to go with no. I see a Jeremy. I believe that's Mr. David. Jeremy David, if that's the case, and if you have anything that you want to share with the hearing examiner, can you please unmute yourself and show your screen? Okay, don't see anything. Okay. And I previously saw Mr. Mendelson McLean on here. I don't see him anymore, but in case he's on a different name, if you wanted to unmute yourself and show your screen and say something else to the hearing examiner, could you please do so now? Okay, I think that's all I have, Madam Hearing Examiner.
I'm here,
Oh,
Alex,
thanks,
I'm
Dan.
sorry. Yes, I had to find the mute button.
Mr. Lynch, are you able to show your camera?
Okay,
Oh, it says there's no camera. I've had this issue. If you have a camera cover on, like a physical one on, there you go. Okay.
there we go. Okay.
Is there,
Mr.
if you, oh, sorry, what was that?
Mr. Lynch, do you swear or affirm under the penalties of perjury that the testimony you shall give will be the truth and nothing but the truth?
Yes, I do. Thank you.
All right. If there's anything you'd like to share with the hearing examiner, please do so now.
Yes, I echo Mr. Taylor and Mr. Tidwell. They're my neighbors. I've been here for almost 20 years. So just like Mr. Taylor mentioned, this is a quiet neighborhood. You know, we moved here because of the facing of the housing, you know, the camaraderie of the neighbors that we have here in our 43 homes. To my knowledge, we haven't had any major issues with security or safety concerns for that matter. You know, minor stuff, but in my opinion, you know, with the new developments that's forthcoming or proposed forthcoming, will add to our safety concerns here in our neighborhood. And certainly, as everybody else has mentioned, the traffic will be horrendous.
Thank you. Appreciate
Uh-huh.
it. Okay.
Mr. Tidwell, I think you're still on, you're not muted right now and your camera's still on. I just wanted to let you know. There you go.
Did you already say that?
There we go. Okay, great. Thank you, Mr. Lynch. I believe that's all I have for this witness.
Thank you.
Mr. Tedesco?
No questions.
No questions. Thank you.
Okay. Thank you, Mr. Lynch.
Thank you.
Okay, I don't believe, unless one of my other clients pops up, I don't believe I have any other witnesses.
Okay. Mr. Tedesco?
I'm ready to provide closing, but I will allow Ms. Votaw to go. I believe I get the last word, so we can hopefully wrap up this hearing today.
Okay. Ms. Votaw?
Yep, absolutely. And again, I thank you, Madam Hearing Examiner, staff, everyone on the call for your time today and careful consideration of this matter. As my clients have described, this is really important to them. This impacts their lives every single day. It impacts their future. It impacts their children's future. So it's really important that we get this right and we think about it very carefully. We believe that the hearing examiner should deny this application or recommend disapproval of this application because it's not consistent. It doesn't conform with the master plan, which specifically recommends residential low development on this property, and that's specifically designed as being intended for a single-family detached residential development that may have up to 3.5 dwelling units per acre. And this does not include exclusively single-family detached homes. It includes townhouses. So it does not conform with the express intent of the master plan. We also believe you should disapprove his application because it doesn't satisfy the change mistake rule. I know we have disagreement between me and my colleague across the aisle about whether that applies. We certainly believe it does, and they do not qualify, they do not satisfy the change mistake rule. We also believe the hearing examiner should disapprove his application because it's going to have adverse impacts on the traffic conditions in this area, as well as the property values of my clients' homes. And then finally, we believe you should disapprove his application because the public benefits are not adequate. In the alternative, again, we believe there's ample grounds for disapproval, but in the alternative, if the hearing examiner is intent on approving or recommending approval of this application, we request several modifications to the proposed public benefits and or the overall development. For example, the witness, I want to say it was Mr. Give me one moment. Mr. Allison described that they could probably preserve 31 to 35 acres of woodland on site. I believe that should be a requirement of approval since we've established numerous times that the proposed reforestation or forest conservation being proposed at this time is exactly what is required under the base zone. It is not greater to any extent than the base zone requirements. So we believe there should be a requirement that there be additional on-site preservation up to 35%. We also believe that the hearing examiner should impose a condition that the capital improvement contributions should not be used towards the road improvements, that should be in addition to any proposed road improvements. And I apologize for the mix-up before. I was reading from the staff report dated November 13th, 2025, which does not appear to be part of the record, where they describe this issue. So we believe that should be a condition of approval. We also believe that there should be less houses proposed on this development. For example, if the hearing examiner finds that townhouses are not permitted or don't conform with the master plan recommendations, the hearing examiner could impose a condition limiting the type of houses to only single family detached development, which would address density concerns, traffic concerns to some extent. We would also request that the road improvements to Steed Road include 4 lanes on both sides all the way through Steed Lane. Although our traffic engineer described, or our traffic witness described that alone is not enough to address the impacts of proposed development like this because of the principle, I forget exactly what she called it, but when there's an open road that's available, people tend to use it, and you will get congestion even though you've widened the road. We think additional widening would still address some of those issues, particularly coupled with a decrease in the number of units being proposed. Again, while we don't believe this is enough, we believe there's ample grounds for disapproval of this application. At minimum, we believe those types of conditions should be required by the hearing examiner. And we greatly appreciate your time and the ability for my clients to advocate for their interests today. Thank you.
Can you submit those in writing?
Yeah, ma'am, I would be happy to do so.
Thank you. Mr. Tedesco?
Thank you, Madam Examiner. It's been a long day. I want to thank you and your staff, People's Zoning Council, and all the witnesses, both citizens and experts, for hanging in there today. I think I heard Ms. Votaw close by saying decrease the density, but add more road improvements. And so the fact is that the RPD zone is a floating zone that allows for the flexibility associated with development to implement public benefits. Those public benefits have to be paid for. And everyone agrees that the Steed Road Steed Road and Piscataway Road are in desperate need of improvements. Those improvements are only going to occur if development occurs. And if development occurs to be implemented, requires this rezoning in the sense that the base zone development would simply pay into the CIP and those road improvements would not be realized. So what Ms. Votaw is advocating for is conditional approval that can't be implemented. The question before you, as emotional as some of the testimony was, which I appreciate and respect, that your determination on this case for your recommendation is based upon 4 required findings. Section 27-3602C, and whether there is substantial evidence in the record to support the findings associated with those required findings. The answer based on the unrefuted expert testimony, planning board's findings, the technical staff report recommendations, and the documentary record is unequivocally yes. This is a planned development rezoning, not a piecemeal Euclidean rezoning. The applicable standard is clear. Conformance with the general plan and master plan, satisfaction with the purposes of the RPD zone, and compliance with the applicable standards. No adverse impacts on surrounding properties. Every one of these findings has been affirmatively established. The property is designated for residential low land use recommendations in the subregion 5 master plan, which allows by definition up to 3.5 dwelling units per acre. The applicant proposes approximately 2.97 dwelling units per acre. I would note that in part of the testimony, Ms. Votaw's arguments with respect to residential low in her argumentatively positioned opening statement was referencing Hyde Field, and that too being a residential low land use recommendation. Hyde Field, as this body knows, was recommended for approval and the district council approved that RPD zoning based upon the same definition of residential low, 3.5 dwelling units to the acre. The determination of what that residential low master plan recommendation should be has already been applied. Hyde Landing, and so being approved by the council, is 100% single family attached, notwithstanding Ms. Votaw's reading of residential low being primarily single family detached. So it's completely inconsistent with this body as well as the district council's application and interpretations of what residential low is to then conclude that what is proposed here today is not in conformance with the master plan. As Mr. Anderson testified, this application advances the core principles and policies of Plan 2035 by strengthening the established communities, providing needed housing diversity, coordinating development with infrastructure, and enhancing environmental systems and open spaces. No expert testimony rebutted that conclusion. The application fully meets the purposes of the RPD zone. The RPD zone exists for one reason: to allow better, more innovative, more environmentally responsible development than conventional zoning. That is exactly what this plan delivers and what is proposed here this afternoon. As the planning testimony established, the zoning map amendment and development advances and will implement a compact, walkable neighborhood design, a mix of housing types addressing county housing needs, integrated open space, trails, and civic amenities, and context-sensitive design compatible with surrounding neighborhoods. This is not theoretical. The basic plan operationalizes each of these elements. The record is clear that the uses are permitted in the RPD zone, dimensional standards are established in the basic plan, infrastructure is available and will be further vetted at the time of preliminary plan, and environmental and design standards are met or exceeded. Every expert, planning, civil, environmental, and landscape, both from the applicant's team as well as the Maryland National Capital Park and Planning Commission, confirmed this compliance. There is no contrary expert evidence in the record. There are no adverse impacts, and in fact, a net positive impact with this approval. Fourth finding is often where and what the opposition has focused on here this afternoon. But again, no evidence is provided to overcome the testimony that's been provided and the record in this case. Plan preserves the Tinkers Creek Stream Valley, protects high priority forests and ecological systems. It exceeds woodland conservation requirements and concentrates development away from sensitive areas. As Mr. Allison testified, the design is driven by environmental preservation, not imposed on it. Public water, sewer, stormwater, emergency services are all available and will be fully evaluated at the appropriate stage of development. Transportation, the traffic evidence is particularly important in this case. The required analysis compares current zoning versus proposed zoning. Proposed development results in manageable impacts. The applicant is providing substantial improvements beyond requirements, including CIP contributions, Steed Road widening, and bridge improvements, turn lane, bike lanes, and trail systems. And critically, when viewed in the context of Hyde Landing, the net effect is a reduction in the total trips on the roadway network. There is no credible evidence of adverse transportation impacts. As far as the public benefits, they're significant, quantifiable, and unmatched. The record demonstrates that more than 50 acres of stream valley and environmental dedication is provided. Extensive trail and pedestrian networks or connections are offered. Major off-site road improvements exceed pro rata CIP obligations, enhance woodland conservation beyond required thresholds, and recreational amenities and park contributions. These are not speculative. They are committed, enforceable, and superior to what the base zone would deliver. With respect to the opposition, there is no qualified expert testimony contradicting the planning conclusions, the traffic analysis, environmental findings, engineering feasibility, which matters. Zoning decisions must be based on substantial evidence, not generalized concerns. You heard references to change or mistake, adequacy concerns at the ZMA stage, and demands for engineering level details. All of these are legally misplaced. This is a plan development rezoning governed by section 27-3602. Not by outdated and inapplicable standards. Concerns about traffic, schools, stormwater growth are understandable and appreciated, but they are addressed through the county stage review process, not grounds for denial. The law is also very clear. Generalized fears and reputation do not equal substantial evidence. When you step back and look at this case holistically, it's a master plan consistent density proposal, a superior environmental design, significant package of public benefits, and coordinated extension of an already approved community. As Mr. Donahue testified, this is the type of project the applicant is uniquely positioned to deliver from concept through construction based on decades of experience in Prince George's County and commitments to this community. The record in this case is not close. Substantial evidence exists, and the applicant has met every required finding, presented consistent, credible, expert supported evidence and testimony, demonstrated substantial public benefits, and addressed all relevant impacts. And there is no substantial evidence to the contrary. For all of the reasons and the record in this case, we would respectfully request your recommendation of approval. And again, right at the almost 4 o'clock mark, I appreciate your time and consideration of this application. Thank you so much.
Thank everyone. The record will remain open for a short period to receive Ms. Vota's closing, if you would do that. Mr. Tedesco.
Could we set a date for that, please?
And I was going to finish with, and if you wanted to submit your closing, you could as well. And the date should be, it's Wednesday. Can do it by Friday?
Yes, ma'am.
Yes, ma'am.
Okay.
And just to clarify, did you want just the list of the,
You could do your whole closing if you
Okay.
like, or the list, just nothing else.
Okay,
Same
absolutely,
thing
ma'am.
as you, Matt, if you want to. Okay.
Thank
So
you
I
very
thank
much,
you
Madam
all for
Hearing
being
Examiner.
here today. And the record will close as soon as we get that information. And I thank everyone that testified, if they're still on. Thank you for participating today.
Thank
And
you, Madam
too,
Hearing
Mr.
Examiner.
Brown. And you too, staff. You get to go home at 4:02. Okay.
Thank you.
Bye, everyone.
Recording in progress. Recording stopped.
Good evening. Trying to do an audio check.
Good evening. Testing 1, 2, 3. Testing 1, 2, 3.
Good evening. Thank you for the test.